that. We'll continue to watch the weather and the radar during the course of the day and plan accordingly, but we'll work hard to get as much done as we can today. We may take some additional breaks given the fact that we're starting earlier. But with that, and is there any matter before the panel before we begin? All right.
Nothing from the State Bar.
Mr. Housecott, then if you'll turn around, sir, and come back to the stand, I remind you that you're still under oath.
Yes.
Will there be cross-examination by the State Bar?
Yes, sir. Morning, Mr. Housecott. You testified yesterday you worked at Brownstone Law in Winter Park, Florida before starting a partnership with Mr. Megaro. Is that correct?
That's correct.
Were you at Brownstone at the time they were ordered by the North Carolina State Bar Authorized Practice Committee to cease and desist engaging in the unauthorized practice of law in North Carolina?
Not to my knowledge.
Okay. What year did you leave Brownstone?
2013.
So 2013, not 2014?
No, not 2014.
Okay. When did you start your partnership with Mr. Megaro?
2014, early 2014.
Okay. Are you friends with Mr. Megaro?
He's more like a work wife. That's the joke. We see each other more than we see our own families. So, but yeah, he's a great guy. I mean, I'd say we're friends.
How long have you been friends?
Well, I mean, we've been partners for 7 years. So, and that's pretty much the extent of the time I've known him. I knew him from Brownstone for about 6 months there. So close to, I guess, 8 years.
Mr. Megaro worked at Brownstone as well?
He did.
When did he work there?
2013, to my knowledge, into the beginning of 2014.
So he was there in 2014?
Early 2014, yes.
Okay. How does the money of Housecott Megaro work? Is there a bonus structure? Is everyone's salary? Is there a profit share? How does that work?
It was salary for all of our staff and employees.
Everybody got a salary?
That's correct.
Does anyone have a bonus structure or get compensated based on the work they bring in?
No, we were thinking about doing that, but it never was something that panned out.
It all goes into the same pot and then it's distributed just by salary?
Yes.
Okay. What was your salary while you were at, or I guess during the time of the Henry and Leon representation?
It's hard to calculate because Mr. Megaro and I never took a direct salary. We would pay ourselves as needed.
You did, so it wasn't salary as your previous testimony?
It's owner, but it wasn't a fixed salary. So it would be, we had a base of say around $100,000, but it might vary if we wanted to hire someone else or do something as the owners, the two sole owners of the firm. We might not necessarily pay ourselves that full amount if we wanted to expend on additional employees or hire a new attorney. The standard growth issues of a small firm.
So did you benefit from the profits of Housecott Megaro?
I did.
You personally benefited financially from that?
I do.
Okay. What states does Housecott Megaro advertise in?
Florida primarily, and then the states within which Mr. Megaro or myself are licensed.
And which are those?
I'm licensed in Florida, the District of Columbia, and Minnesota. Mr. Megaro is licensed in Florida, North Carolina, Texas, Washington State, New York, and New Jersey, to the best of my knowledge.
And do you provide legal services in all of those states?
We provide legal services in all states within which we are registered and operating.
And which are those?
It should be all of those as far as I know. I'm very careful about my language, parsing it here to make sure that I'm saying the appropriate thing. But yes, it's our duty to, and we endeavor to comply with all of the rules of all of those bars.
And what physical locations does your firm have?
We have one physical location currently.
And where's that?
That's in Orlando, Florida.
Okay. Did you work on the Pardon and Industrial Commission matter in this case?
I did.
Okay. You provided legal services for that Pardon and Industrial Commission matter?
I wouldn't say that necessarily. It was more of a supportive role, providing logistics support, similar to the functions of, say, a paralegal or an assistant. This was always Mr. Megaro's show.
So you didn't provide any legal advice to the clients in that matter?
Not that I recall.
Okay. Are you licensed in North Carolina?
I am not.
Were you admitted pro hoc vice to practice in state here?
I was.
By which court?
The Eastern District of North Carolina. The court within which we were, the Brown and McCollum case was
The federal court?
Yes, the federal court.
Okay. And you believe that gives you the right to practice before state courts?
I don't believe I ever practiced in front of a state court without any proper authorization in the state of North Carolina.
Okay, so you weren't admitted to a state court in North Carolina, but you provided legal services in the industrial commission matter and the pardon?
That wasn't my testimony at all.
Help me understand.
Yes, I said I provided logistical and support, back end, similar to an assistant.
Okay, and you had a portion of the legal fees that were collected from the industrial commission matter?
It doesn't work that way, no.
Yeah, maybe I'm confused. Help me understand that. I thought you just said you shared in the profits of the industrial commission matter.
No, I said I shared in the profits of Halscott Megaro.
Okay, so you didn't benefit at all from the industrial commission matter?
If the money went into the firm, then
Which
it went.
it
into the firm.
did, right?
But it's not that clean cut. We had Brown and McCollum was not the only case that Halscott Megaro worked on. We worked on hundreds of cases across those states within which we are licensed. So
Did you or did you not receive money from the industrial commission matter personally?
not to my knowledge.
So you didn't benefit from the money that was brought into the firm from the industrial commission matter?
I wouldn't categorize it as that, no.
Well, which is it?
Which is what?
You said you wouldn't categorize it as I just stated it, or was that an affirmative response?
I wouldn't categorize it as you stated it. The question is worded in such a way as to trip me up, and I'm trying to be honest with you and share with you how our firm is structured, how compensation works, and you're mischaracterizing it to say that I had somehow a stake or an unauthorized practice in North Carolina, and that's not the case.
No, I'm asking if you benefited financially from the money that came into your firm from the industrial commission $500,000 fee that your firm collected.
Not directly.
You didn't benefit from that.
Not that I recall.
Did all of it go to Mr. Megaro?
It doesn't work that way. The fees don't come in and go. That they pay for things like operations. They pay for salaries of attorneys who were on the case, our assistants who might work on the case.
Okay, but you were not admitted to a state court here in North Carolina?
Not that I recall.
Have you ever filed a petition for pardon here in North Carolina?
I personally have not.
Has Mr. Megaro filed a petition for a pardon in North Carolina?
To the best of my knowledge, yes.
Which one?
Mr. McCollum and Mr. Brown.
He filed the petition for the pardon in that case?
Yes, he did.
Okay.
I mean, excuse me, I'm sorry. He did not. That was Ken Rose's. I misspoke on that. Yes.
So well, I'll ask it again. Has he ever filed a petition for pardon in North Carolina?
Not that I recall.
Okay. Did your firm do any depositions in the pardon matter?
I'm not aware of which depositions were done or weren't done.
You're unfamiliar of the work that was done in the pardon case?
I'm unfamiliar with the depositions that were done.
But you believe there were depositions, or you just don't know?
I don't know.
Okay, and you're the managing partner of Halscott Megaro. You testified yesterday about all this extensive work that Mr. Megaro had done in that pardon matter.
Yes.
And you were present in the office. I believe you said you heard almost all of his phone calls.
I didn't say that. I said I heard. I share an office with him.
Mhm.
All right, we face each other.
Yeah.
I hear a lot of work that goes on. Pretty much, I know that he's working on that case because I hear him talking about it. But I couldn't say yes, he did 10 depositions, or yes, he did 1 deposition, or yes, he made 493 phone calls versus 253 phone calls, or some random number. The volume. I was not responsible for oversight of the work that he was doing on the Brown and McCollum case or the pardons in this case.
Were any depositions done for the industrial commission matter?
I'm unaware of which depositions were done.
So it's possible no depositions were done for the industrial commission matter?
Possible 100 were done. It's possible none were done.
Okay.
I have no knowledge of that.
Did the firm serve any discovery in the pardon matter?
I'm unaware of what discovery was served specifically.
Or if it was?
If it was or wasn't, I'm unaware of that.
Okay. Did your firm serve any discovery in the industrial commission matter?
I'm unaware of what kind of discovery was served in that regard. Again, my testimony is consistent that this was Mr. Megaro's case that he was working, and I was purely in a supportive role.
But not, you don't know if depositions were done or if discovery was done?
It was not my case. No, I do not know how many
Okay.
or the volume of which discovery or depositions were done.
Were you the only other attorney from your law firm to work on this case?
Let's phrase that in a way that I can understand, because you've already made accusations or kind of backhanded of unauthorized practice of law.
I'll object
while I'm an
to the
attorney-
characterization of my questions as an accusation.
Mr. Halsman, just to answer his questions.
While I'm an attorney, my role was primarily administrative and support and logistics. Other attorneys had similar roles, or otherwise, to the best of my knowledge, complied with all North Carolina bar rules.
Which attorneys had a similar role to you from your firm?
I wouldn't remember which ones at the time. We had multiple attorneys at that point.
You're the managing partner of your firm and you don't know which ones worked in this matter?
It's a long time ago.
Okay. Did Scott Brett Schneider work on this case?
He did.
Is he a member of your firm?
He is not.
What firm is he a member of?
Scott Brett Schneider, to the best of my knowledge, had a solo practice.
Where?
He lives in North Carolina, but had practiced extensively in New York City.
He's licensed in North Carolina?
I have no knowledge about his licensure.
Okay. Are you still working with him on cases?
I am not.
Is Mr. Megaro still working with him on cases?
Not to my knowledge.
Did your firm make any efforts to collect any additional money from Henry or Leon after your firm was fired from that representation?
To collect money, fee or costs?
Money was the question.
Okay. I believe that I myself had sought with the guardians, Ray Tarleton and Dwayne Gilliam, for recovery of costs that were reasonably expended in the litigation.
Okay, let's look at that. Thanks.
Mr. Walthall, is this one of the previously admitted exhibits?
Yes, sir. Mr. Halscott, this is exhibit 719. Would you please read that into the record?
Yes. Good morning. I wanted to reach out to you about the payment of the outstanding costs laid out in this case. The court specifically reserved ruling on the fees, but there is no legitimate dispute about the costs laid out by our firm. I know that you have been given multiple copies of the expenses, but let me know if you need them again. October 31 is a reasonable date by which we expect to be reimbursed for those. I look forward to your response.
And who'd you send that email to?
That was to Raymond Tarleton, also Amanda Foster.
And who are they?
Ray Tarleton was the court-appointed guardian ad litem, and Amanda Foster worked with Kimberly Pinchbeck as the conservator of the estate, if I recall correctly.
And what outstanding costs are you referring to?
Costs of litigation. As far as I know, there were more than a dozen, possibly close to 24 depositions taken. There were travel fees, lodging, airfare expenses, copy costs, process serving, things like that, that were expended by Halscott Megaro during the course of the litigation over that multi-year period.
What litigation, when you say this case, what are you referring to?
The only litigation that was filed in this case, the 1983 civil rights action.
So the pardon in the Industrial Commission matter were not litigation?
That's not technically litigation in the terms of civil litigation.
Gotcha. Okay, so what contract would give you the right to those costs from Mr. McCollum?
I understand where you're going with this, that Ray Tarleton's position is that there's no contractual agreement.
I would again object to you telling me what my position is on this case. I'm asking you a question.
Mr. Halsman, you do need to not editorialize or theorize about the purpose of the council's question, but rather just answer that directly, please.
Yes, I'm sorry. I believed it was in the email that was in your exhibits. That's why I was testifying to it.
Do you need me to ask the question again?
Please.
What contract would give you the right to those costs?
A quantum merit contract under the theories that we were told. But in my basis that we had expended those prior to any kind of court changing the terms of the retainer agreement or partially invalidating that retainer agreement.
You believe the retainer agreement was partially invalidated?
It was partially invalidated, yes.
Okay, where are you getting that?
From the court's order itself.
And have you been paid these costs?
I have not.
Have you taken any steps to pursue them?
Not currently.
Are you planning on doing that?
I could go to Hawaii tomorrow too, who knows?
I'll ask again because I didn't understand your question or your answer. Are you planning on pursuing those costs?
I may,
Okay. But you haven't filed suit for that?
not currently, no.
Okay. Why not?
Kind of busy with this hearing and other things going on.
Okay. The only contract that you had signed with Henry and Leon, an order had been entered saying that that was an invalid contract. Is that correct?
That's not correct. No,
An order hadn't been entered saying it was invalid?
no, that is not correct.
Okay. Yesterday, you testified that the online petition your firm started for Henry and Leon had over 100,000 signatures.
I was trying to recall how many signatures it has. That's
Uh-huh.
why I specifically testified that I wasn't sure, but I believed it to be over 100,000.
Okay. Is this that petition? We just looked it up, change.org. It looks like that's Patrick Megaro's name and picture there. Couldn't find any others. It says that there are 33,000 signatures on it.
And that's possible. That's why
Okay.
at the same time, I was speaking in the context of Mike Anderson's petition, which if you look up, you'll see has a tremendous amount of supporters as well. We had a large amount of change.org petitions going on during that time period.
You have accused the state bar of leaking information to the media.
I filed an email or sent an email to Catherine Jean. I had some very legitimate concerns about that. So I did send an email asking for help in locating a leak or breach in the confidential grievance procedure with the state bar.
And you were here during Ken Rose's testimony.
I was.
And did you hear him indicate that he in fact had spoken with Joe Neff about this case?
Yes, I heard him say that.
Okay. You called the articles about your partner fake news. Is that right?
That is what I did in that email, yes.
Okay. Look at exhibit 720 there on the screen. This has been previously admitted. If you would please read that email into the record.
Yes, this is an email to Catherine Jean. You have a serious leak or breach in the bar. My partner was the victim of a fake news article yesterday, the latest in a series of them, which revealed many confidential details about possible bar grievances. It is causing harm to his reputation in my firm. I want to get to the bottom of it, and I'm hoping that your office can assist.
You called the articles about your partner fake news.
I did.
You claimed that there had been a series of fake news articles about Mr. Megaro.
Yes,
Is that still your position that these are fake news?
it is.
And is it still your position that you and Mr. Megaro have done nothing wrong in this matter?
I'm not on trial, but I've done nothing wrong, nor do I believe Mr. Megaro has.
Okay, so you indicate you're not on trial, but if you were working on this matter, if Ms. Megaro is found to have violated rules of professional conduct, would that possibly implicate your professional conduct as well?
No,
It wouldn't.
no,
You haven't disclosed to the Florida bar any of your actions in this case?
there's no need to.
Okay. Are you worried about the harm to your firm that could come from a finding in this matter?
Not particularly.
So when you say it is causing harm to his reputation and my firm,
Yes,
seems there you're worried about the reputation and harm to your firm. Is that
well, you're
correct?
conflating the two issues now.
Help me
because
understand.
Back then, there was no grievance that I was aware of. There was,
In April of 2018, you weren't aware of the pending matter in this case?
I was not aware of the pending matter. As far as I knew, it was September of 2018 that it became public. the
So when you
information.
say confidential details about possible bar grievances, what are you referring to?
Mr. Walthall, let him finish his answer, please. before
Oh,
beginning
that's
that.
actually,
I apologize.
that's actually very good, because if you look at the report that we showed Mr. Tarleton, or you showed Mr. Tarleton the other day, where he made his modus operandi comment, he cites specifically to a Marshall Project news article. It says that there are two grievances, that Ken Rose stated there were two grievances, and then it gives details about the Grace Humphrey, which makes sense. Of course, that's how he would know the Grace Humphrey details. However, in his filing in federal court, he specifically gives details about the substance of those other two grievances. My concerns were, where does he get them from? Now it has become clear that Ken Rose unethically decided that he wanted to share those confidential grievance information, but it's less my theory now that it was the North Carolina State Bar than Ken Rose acting on a personal vendetta.
So getting back to my question, in 2018, you were aware of the grievances against your partner, Mr. Megaro.
I was aware of the existence of grievances,
Okay.
but I don't remember the exact time and within which I became familiar with that.
But at least by April 2018, because you're referencing them in this email.
I'm referencing what was written in the news article and what was later stated by Mr. Tarleton in his court filing.
So just so I understand your testimony, and feel free to correct me, you were worried in April of 2018 about the harm to your firm that possible grievances could create. But now that we have an actual DHC case, you're not worried about the harm to your firm.
The harm had already been done. Our firm was receiving calls, threats, harassing emails as a result of the news article. We saw the harm done at that point. I mean, people would literally call the office and scream at us and tell us we're terrible people because of the substance of what was happening, which was reported, the confidential information of which was reported in the news articles and or in federal court filings by Ray Tarleton. So the harm is talking about that snapshot in time. At that point in time, the harm that was being done to my firm, but by what I perceive to be a leak or a breach in the bar as the most reasonable explanation for confidential bar grievance information being disseminated.
You're no longer worried about the potential harm to your firm of a conviction in this case?
I'm not.
Okay.
The damage has been done to my firm as a result of this for multiple years. So.
Did you provide legal services to Henry and Leon pursuant to the same contract as the defendant in this matter, Exhibit 105?
Could you show me Exhibit 105?
Yeah.
I mean, that is the retainer agreement. Yes.
You didn't have a separate retainer agreement, it was Exhibit 105?
I did not have a separate retainer agreement.
Now, that contract, do you believe Henry and Leon understood it?
I do.
Do you believe they understood their confessions?
No, those are two separate standards, as we spent many days with experts talking about.
Your answer was no, that you don't believe they understood their confessions?
My answer is that I am testifying in conformity with the experts which we've put on, who outlined it much more articulately than I could.
It's a simple question. Do you, as one of their attorneys, believe they understood their confessions?
I do not believe they understood the confessions in 1983.
You testified yesterday that Henry was like any other normal guy and had a flawless memory. Is that right?
He did in the testing that I did. Again, I think I also stated that I was not a forensic psychologist or psychiatrist or anything like that. I wasn't a mental health expert. I was just testifying on what I knew as a lay person. In my discussions with Henry, his recollection of those that were on death row, his recollection of things that had happened over the last 31 years were impeccable in my discussions with him.
You testified yesterday that Henry's intelligence doesn't have any defects?
Not that I saw.
Okay. Do you believe Henry has any mental deficiencies or intellectual disabilities?
Based on the filings in courts, based on the reviews by the doctors, I do concur with Dr. Harbin and Dr. Ballard on their assessments.
And they indicated that there are signs of intellectual disabilities and mental deficiencies. So you would agree with that?
There is a difference between what I testified to, which is that I did not observe any, and whether or not he does have some, right? It's just that simple. There's a nuance that you're missing here.
No, I'm asking you if you believe they have any mental deficiencies or intellectual disabilities.
I do based on those reports, yes.
Okay. Did your firm serve the town of Red Springs with discovery requests to determine their assets?
I am not aware of exactly what discovery requests were served on the town of Red Springs.
And this Exhibit 105 that your partner has testified to drafting has a portion regarding costs and expenses. If you would please read that into the record.
Yes, I know we've read this into the record before, but I will indulge further. It is often necessary for us to incur expenses for items such as travel, lodging, meals, telephone calls, transcription, and the like. Similarly, some matters require substantial amounts of costly ancillary services such as photocopying, messenger and delivery services.
Wait a minute. Let me, on behalf of the court reporter.
Oh, I'm sorry. I apologize.
Yeah, you beat me to it. I was just about
Yes.
to interrupt him, Mr. Halscott. She needs to keep up with you as you are reading. So please, for her benefit and if for nothing else, please read more
Yes,
slowly.
sorry, Mr. Chair. We had read this before, so I was being expeditious. Similarly, some matters require substantial amounts of costly ancillary services, such as photocopying, messenger and delivery services, and computerized legal research. HM agrees to advance all such costs and expenses incurred in connection with the matter, including but not limited to photocopying, messenger and delivery services, expert witnesses, court reporter fees, computerized research, travel, including mileage, parking, airfare, lodging, meals, and ground transportation. Shall I continue?
Please.
Long distance telephone calls, telecopying, court costs, filing fees, and other similar expenses. Certain of the preceding items may be charged at more than H&M's or HM's direct costs in order to cover overhead.
So your firm was contractually obligated to pay the costs in advance in this case?
That's what the retainer agreement says.
Okay, and that specifically included expert witnesses, is that right?
Yes, that would be what the contract says.
At one point during this matter, your firm had to take a loan from Derek Hamilton because you were struggling financially, is that correct?
I'm unaware of such.
Okay, let's look at the defendant's deposition. I'll bring you to line 24, page 455 of the defendant's deposition. I asked what was the other $10,000 for. Mr. Megaro says 10,000 was a loan to me. And I asked if it went into Henry's trust account. He said, yes, it went in there. We talked about why this loan needed to occur, and he said it was to assist us. We were going through some financial troubles to assist us for paying additional expenses. I understood you yesterday to say that you were the managing partner of your law firm and you were unaware that your firm was taking a loan from Derek Hamilton for the amount of $10,000.
I wasn't involved in anything with that.
The question was if you were aware of it or not.
I was not.
Okay, do you manage the finances of your firm?
Mostly, yes.
Mr. Walthall, would you identify the exhibit? I don't think you did that as you began the deposition.
Exhibit 100, I apologize.
Thank you.
Yes, sir. So you mostly handle the expenses of your firm?
Well, I don't deal with the North Carolina trust account myself. It's not my account. So I'm not doing any of the trust reports or any of those things, or reconciliations of those.
Who is doing those reconciliations?
Mr. Megaro handles North Carolina accounts.
Okay, do you know if your firm had a contract for that $10,000 that you borrowed from Derek Hamilton?
I don't know if our firm did, not that I know of.
You know if your firm paid back any interest to Derek Hamilton for that loan?
I don't.
You know why your firm needed $10,000 just shortly after getting a fee of $500,000?
I wouldn't be able to speak to the reason for such a thing,
Even though you mostly handle the expenses of your firm?
except for the ones as I've specifically noted, this did not include.
Okay. So you didn't handle the expenses in the McCollum and Brown matter?
Not other than something that would have been ministerial in function.
What would include ministerial in function?
Can you grab a check? Can you write a check for something? Can you handle, paying this bill or something like that?
So you did regularly give Henry and Leon advances, is that correct?
I don't know if I would say that, no.
You weren't the one who handled the advances?
I don't handle those things. I might sign a check or do something like that on behalf of Mr. Megaro. If he asked me to provide a check or payment for something, I would do so. That's entirely possible.
One moment, please. All right, let's look at some of these advances, which I believe are in Exhibit 121. This is page 7 of Exhibit 121. Do you recognize this, Mr. Hall Scott?
Yes, it looks like the settlement statement.
And what's listed there in the boxes from March 2nd, 2015 to October 26, 2015?
Looks like various different expenses.
Those are expenses or are those advances?
They are what they say they are there. I'm not going to categorize them as one way or the other for you. I would go with the descriptions that are provided there.
Okay, so let's look at what's provided there. It says total firm advances, $11,637.57. So are these advances?
I would go with the description that's there.
I'm going to object to non-responsive. Are these advances? It says right there, if they're total firm advances, is it incorrect or are they advances?
It says it's advances. I said I would go with what's there.
So it is advances then.
It says total firm advances.
Okay. Are these for litigation expenses?
The expenses are listed out there.
Object to unresponsive.
Answer if you know, Mr. Housecott.
I don't know. They say hotel deposit. They say car travel expense. They say videographer. I don't know if those would be categorized as litigation expenses. You can categorize them as whatever you'd like, but I'm not going to be able to say what those expenses are other than what is listed there.
Okay, so was the Majestic bus leasing on October 15th litigation expense?
I think that was for the family to come down to Walt Disney World.
Okay, so was that a litigation expense?
It was for the family to come down to Walt Disney World.
Was that a litigation expense?
I can't categorize it as that for you. I'm sorry.
Okay, so it's not a litigation expense?
I don't see that as a litigation expense.
Okay, but your firm advanced that money to Henry and Leon?
It says that here on the settlement statement.
So you paid for a non-litigation expense for your client and then later took it out of their funds once you received them?
I think that's a miscategorization. That's why I didn't want to go down this line of questioning with you and being trapped into an answer, giving you what you want to hear. These are what they say here on this spreadsheet.
I'm going to object again. This is non-responsive. You're editorializing.
Mr. Housecott, you didn't answer the question directly, please, from the
I
State Bar
don't
Council.
know how to answer this, Mr. Walthall, other than what is listed here is what it is.
And so what's listed here then is your firm lent money to your client for a non-litigation expense?
I wouldn't categorize it as that, no.
Okay, then how would you categorize it?
I would not categorize it as that. I don't know how I would categorize it.
You don't know how you would categorize it?
It says firm advances and it lists these various different costs.
Okay. Did you state to the media at one point that you believe this is a political prosecution?
I did.
Okay, what does that mean?
That means that there has been some kind of political outrage, likely caused by, in this case, as we've found out over the years, Ken Rose being upset that the case was no longer with him, feeling a great sense, as he testified, of anger and frustration that he no longer had the case, that he was personally hurt by the case, using that to, in conjunction with his friend Joe Neff, create news articles designed to stir up trouble, designed in fact to incite Judge Boyle to the events that we saw shortly thereafter those. And then once these things take on a life of their own, it's very difficult to remove them. And once these things become popular and prevalent in the media, they turn into prosecutions. And then there's an expectation from the prosecution to get a pound of flesh in order to make everything look good with the world.
You believe that's what the State Bar is doing here, trying to get a pound of flesh to look good?
Well, you specifically asked, how does Mr. Megaro's behavior impact the way that people see the practice of law? You've asked that of many witnesses. That's the process here. I mean, the State Bar has continued to increase these charges and increase these grievance counts as time has gone on. It seems like a reasonable explanation.
So you do believe that the State Bar's goal here is to, quote, get a pound of flesh to look good?
There could be many goals. I know we're having problems with nuance this morning, but the
Objection.
state has many different goals.
Overrule. Go ahead.
Notice also in this is where you said it, Exhibit 675, which was previously admitted, this is a political prosecution, absolutely, said Hall-Scott. That's not a misquote.
No, that is a correct quote.
Okay. Notice just slightly above this, if you would please read the paragraph that I've highlighted there on page 2 of Exhibit 675.
Reached by telephone Wednesday, McCollum said he's unhappy with his former lawyer. He took money that he should have never took, McCollum said. I could have that money right now.
And Henry's the one you said had the flawless memory.
That's not a memory issue, but yes, that is what I testified to.
Okay. Let's look at one of your exhibits, Defense Exhibit 170. This is one that you all talked about a couple of days ago. Do you recognize this pleading?
Yes, I do.
Okay. Let's look at page 4. You stopped reading here at claims. I'd like for you to read this next paragraph here, starting with for his part.
For his part, Mr. Brett Schneider, aka Mighty Whitey, was recently indicted by a federal grand jury sitting in the Eastern District of New York for conspiring to submit false statements to prison authorities about a client's drug problem in an effort to secure his early release. Would you like me to read the citation?
The whole paragraph, please.
Can I skip the citation?
You may.
Thank you. Prosecutors have also alleged that Mr. Brett Schneider and one of his alleged co-conspirators previously coerced criminal defendants to retain Mr. Brett Schneider as counsel in post-conviction proceedings by promising false recantations from witnesses they planned to bribe. I'll skip the citation as well. Mr. Brett Schneider and his alleged co-conspirator, who is not a lawyer, allegedly planned to divide up 1/3 of potential $22 million post-conviction award, calling it their quote retirement money. Mr. Tarleton is highly concerned that a lawyer facing federal criminal indictment simply cannot effectively represent Mr. McCollum's interest.
And Mr. Brett Schneider did end up going to federal prison. Is that correct?
I do not know if he did.
Okay. I have no further questions.
Would there be further? All right, Mr. Hall-Scott, you may step down, sir. Thank you very much. You are obligated, unfortunately, Mr. Hall-Scott, as you back down your area. Thank you very much.
This is the hardest thing I do today, Mr. Chair. I'm happy.
Will there be further evidence for the defense?
Yes, Mr. DeVore, could we have just a minute? We're just setting up our exhibits.
Sure. Do you need 5 minutes or so?
That'd be great.
All right, let's
Appreciate it.
let's be in.
Megaro.
Mr. Megaro, if you would, sir, place your left hand on the Bible, raise your right hand, face the clerk. You solemnly swear the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, you may have a seat.
I may take this mask off.
Yes.
Mr. Megaro, would you state your full name and residence address?
Patrick Michael Megaro, 7566 Brightwater Place, Oviedo, Oviedo, Florida 32765.
And you are a practicing attorney?
Boulevard, Suite 195, Orlando, Florida 32708.
And do you practice with a firm?
Yes,
What is that firm?
my firm's name is Hall-Scott Megaro, PA.
Are you one of the partners?
I am.
Is Mr. Hall-Scott here, the other partner?
Yes, he is.
Are there any other partners?
No,
How long have you practiced with the firm of Hall-Scott Megaro?
I believe we formally came into being in early April of 2014. I want to say the first or second week, if I remember correctly.
Tell us generally about your educational and professional background before you formed Hall-Scott Megaro.
Educational and,
Professional.
oh, okay. I attended college at Hofstra University in New York, 1995 to 1999. I graduated with a Bachelor of Arts in History and Secondary Education. After that, I went directly to Hofstra University School of Law. I graduated in 2002 with a Juris Doctorate degree. While I was at Hofstra, my last year of law school, I participated in the Criminal Justice Clinic, which is a clinic run by the law school that permits students under the order of the New York State Appellate Division to practice under the supervision of a licensed attorney. I also interned at the Legal Aid Society of New York City, which is New York City's institutional public defender. After I graduated law school, I was hired by the Legal Aid Society Criminal Defense Division in New York County, which is Manhattan, New York. I practiced there as a staff attorney, handling criminal cases for indigent clients until 2004, when I went into private practice. After I went into private practice, I went to work for Scott Brettschneider, who is a practicing criminal defense lawyer. Did a variety of things, mainly criminal defense, some civil litigation. That's where I learned how to do appeals and post-conviction relief. In 2007, I started my own solo practice, continued my solo practice until 2013, when I moved to the state of Florida. I obtained employment at the Brownstone Law Firm in the state of Florida, where I continued to practice mainly appeals at that point, some criminal defense, some post-conviction relief, and some civil litigation, some civil appeals. And after Brownstone, I formed the partnership with Jamie Halscott.
And what is the nature of your current practice?
Mainly appellate litigation. I have been doing 1983 civil rights litigation since I've been a solo practitioner. Some criminal defense, but the concentration is in appellate and post-conviction remedies.
Do you recall from yesterday, Mr. Halscott's testimony about the firm's experience with obtaining pardons and the like?
Yes. And that's another area of practice is pardons and executive remedies. I've handled a number of pardon and commutation applications over the years in various venues, various states, and the federal system. And one of those clients is seated right behind you today.
Who is that?
It's Corvain Cooper. Corvain Cooper was his sentence of life imprisonment without the possibility of parole for a marijuana trafficking was commuted by President Donald Trump on Donald Trump's last day in office.
Now, I'm going to ask you, as we go through the Brown and McCollum matter, we're going to do that chronologically. And that's the first claim of the amended complaint, and then we'll talk about Grace Humphrey.
Okay.
So we're going to go through this chronologically. And I want to start with what happened before you got involved. Did you, about a year before, get involved with a pardon for Mr. Cornelius Michael Anderson III?
Yes, it wasn't just a pardon. It was actually a number of different proceedings that I commenced for Mr. Anderson. What had happened with Mr. Anderson was
well, before you talk about that, I want to tie why you believe Mr. Anderson's matter relates to Brown and McCollum.
Certainly. It was in Mr. Anderson's case in St. Louis, Missouri, that I learned really how to harness the power of social media and how to harness the power of social causes and parlay that into a result in a criminal case or a legal case, rather, and how to obtain the result by use of social media and a public pressure campaign on elected officials.
Now, just in general, why do you believe that it's important to use such tactics and strategies to involve social media and pressure and so forth, rather than simply allow the filing and the process to take its course?
Well, it's been my experience over the years that elected officials will not always want to do what's quote unquote the right thing unless it's politically expedient, unless there's some awareness to a particular cause. So a lot of times when you're dealing with a public official that's in a position to make a purely discretionary grant of relief to a client, there has to be some political will to do it, and there has to be a public perception that this is the right thing to do. And that those are sort of the ingredients that make for a successful public relations campaign. And those are the ingredients that can lead to a successful legal campaign to obtain a result for a particular client. And experience has shown me that several times.
And it's one of those times, the Brown and McCollum part.
Absolutely.
And I'm going to show you several exhibits from that relate to the Anderson matter. And when I do that, I'm simply asking you to explain what each exhibit's significance is and how that would relate to what you did in Brown and McCollum. Does that make sense?
Yes.
Okay, first one I want to look at is the defense exhibit 75. Okay, what are we looking at here?
This is a news article from the New York Daily News that was published on April 15th, 2014. And this is a news article about Cornelius Michael Anderson III.
Okay.
And if you want me to explain further,
We'll just explain the significance to you and how it would relate to Brown and McCollum.
sure. If you could scroll down a little, please. Okay, all right, you can stop right there. So here, after I'd gotten involved in Mr. Anderson's case, one of the first things I wanted to do was humanize him. And that's why Laquana Anderson, who's his wife, depicted here. If you scroll down a little bit further, I wanted to depict this man as a family man because, number one, I wanted to make sure that it got out in the media that this was a decent man. And I wanted to humanize him as much as humanly possible. That's step number one, is to humanize your client. And as you can see, if you scroll down a little bit further, the first lead-in on this article talks about that he was a family man. He's a father of four. He owns his home, pays his taxes, volunteers at the family's church. That's exactly the intro that I would like. And that's why I'm asking the Daily News to publish an article such as this, because it's humanizing the client. And now that's the first step in making sure that you apply the right political pressure for the right person to the public official.
So it's fair to say you had input into this article.
I did.
How did you do that?
Contacted the media and spoke with them about the case, provided them information, gave them access to the client's wife, and gave them the photograph that they can publish.
All right. Anything else about this particular exhibit you wish to draw attention to?
If you can scroll down a little more. Okay, so again, this article talks about the circumstances, which very briefly, when he was a young man, he was convicted of a BB gun robbery of a Burger King employee. He was convicted and sentenced to 14 years in prison. He spent approximately 1 month in prison before he was granted bail pending appeal. And through a series of mistakes, the Missouri Department of Corrections and the Missouri court system simply forgot about him until 14 years later. They found him where he was living still in the city of St. Louis, had never run, and decided to tell him that he owed a 14-year sentence commencing 14 years later. By that time, he'd married and had 4 children, was a business owner, et cetera, et cetera. And what I'm doing here is if you can see this quote, I'm planting the seeds for the Missouri state officials to do what I believe is the right thing, which is release this man from this sentence because he's reformed and it was through no fault of his own that that he was forced to endure this circumstance.
Um,
And if you read further, and I'm not going to waste everybody's time with this, but if you look further, there's other articles. Initially, there was opposition from the Missouri Attorney General to my endeavors.
All right.
That changes over time,
Okay,
as you can see.
all right. And we'll get to that. The next exhibit is Defense Exhibit 76. We put that up.
Okay.
All right.
This is 76 is an article. Can you scroll up just a little? I forget what this was. I forget who this is published by. I know it's in the article itself, but as you can see, the headline there is "The System Failed." So now and that was one of the themes that I was getting out there, is that it was not Mr. Anderson's fault that he didn't serve this sentence. It was the system's fault, and he should not be held to blame for somebody else's mistake. And that is what makes it more palatable for a public official and discretionary function to do what I believe is the right thing. And if you see here, I've also petitioned the governor for clemency. That's an alternate avenue of relief. At this time, I'd also filed a petition for a writ of habeas corpus in order to secure Mr. Anderson's relief. So I'm simultaneously pursuing a remedy through the court system, and I'm simultaneously pursuing a remedy through the executive branch, the governor's office, and the attorney general.
As evidenced by this article, is there an advancement in your strategy at this point?
Yes,
Having an effect?
yes, because at this point, the resistance is starting to wear down as I've built a social media campaign and I'm starting to get some favorable press coverage. As you can see in the subsequent videos, the resistance by the law enforcement, the chief law enforcement officer of the state of Missouri, is starting to break down.
All right. Next go to Defense Exhibit 73.
Okay. All right. So Defense 73 is my change.org account. It's a printout of the account. It shows the petitions that I have commenced and also the results. I know there's a lot of extraneous stuff there. That's just how it renders when you print it out. And there's also some petitions that I've signed myself as a supporter. But if you keep going down, you have to get through all of this stuff. Okay, sorry. All right, so go back up. All right, so the first one here, go back up a little more. Okay. So as you can see, this petition is for Corvain Cooper, who's sitting right there in the front. I had 151,599 supporters as a result of this change.org petition. Keep going down. And that's petitioning for clemency. Okay. Then there's a second petition because I had not only petitioned President Trump, I had unsuccessfully petitioned President Obama. Now, stop here. Go back up. Okay. Now, that one was for another case that we handled in federal court in Atlanta. That was a killing of an unarmed young man. We filed a 1983 action, and we used change.org and a number of other avenues to publicize this particular case. Keep going down.
Let me ask you, just more generally, what is change.org and what is a change.org petition? What's the purpose of using that? How does that work?
Change.org is a website where people can advance causes that they believe are worthy by creating an online petition. And the way that you set up a petition is that if somebody supports the petition and they digitally sign it, you can have it so that they automatically send an email to whichever public official. It's almost like a letter writing campaign. It'll automatically send an email to the elected public official or whoever it is that you're directing that petition to show them that I have another supporter, I have 10 more supporters, or sometimes 100,000 more supporters. The main advantage of a change.org petition is that after you reach 10,000 supporters, it starts to gain a critical mass. After 10,000 supporters, the website then automatically starts sending the petitions to major media outlets, not just social media outlets. You'll get NBC, CBS, ABC, the major news carriers will start to take notice of it. And as you get more supporters, they actually, I guess I'm not sure how it works exactly. Maybe there's some algorithm or something, but they start to promote your petition itself. And you'll start to see a sort of rising curve where you'll get a lot more supporters, and then that turns into a lot more recognition, a lot more pressure. And the next thing you know, it's on Facebook, and sometimes it goes viral, which means that it starts going through every social media channel, and it gains a lot of steam right off the bat. And the other advantage is you can do this relatively inexpensively. You can spend as much or as little as you want. You don't have to spend a lot of money. You can spend a lot of effort in promoting it, or you can spend a lot of money and effort in promoting it. And that's generally what I like to do, because I wanted to make sure that it got as much support as humanly possible. But in change.org, that was the catalyst for reaching major news networks like Fox, CNN, NBC on the Cornelius Michael Anderson case. And to tie this all into the McCollum and Brown, I use the same tactics for Michael Anderson as I use for McCollum and Brown.
All right. Well, let's go on to the next exhibit, which is 74.
Okay.
And what is this?
This is the Cornelius Michael Anderson change.org petition. It ended with 35,368 supporters. And once you confirm victory, it's closed. No one else can sign it, as far as I can tell. But as you can see there's tabs on the right side of the screen, which allows you to share it on various social media channels. And also in change.org, you can put your petition, your version of the facts out there. And that's exactly what I did with Mr. Anderson here.
And did you do, to tie it to Brown and McCollum, did you do something similar with
I did, and that's in our exhibits as well.
Right, and we'll get to that. Just trying to tie it to Brown and McCollum. Next, I'm going to show you, I don't want to run through the entire video of each of these, but I want to show you several videos relating to the Anderson matter, and I want you to tell me from the snippets that we see what the significance of those were and how that might tie into Brown and McCollum.
Okay.
So the first one I want to show you is number 77. We have sound. I have.
Armed robbery, but now years later, after turning his life around, should learn today if he'll.
But before we do, how long is this video? Okay, let's go ahead and play that.
Have to keep fighting to get out of jail.
Hold on, before we do, just say what this is.
This was a newscast by NBC on the Today Show. After a certain point, I don't remember exactly when, NBC was one of the first major networks to pick up the Cornelius Michael Anderson story. And that's when I started feeding the network's information and, presenting my case to the networks. And I think this was one of the first major pieces to run on the case, which then transformed into a lot of other things.
Did you have some personal input in getting this done?
Sorry, I beg your pardon for interrupting you, Mr. Williamson. I was just concerned about how we're going to handle this in terms of the record.
We have it on disc.
Right. Is the court reporter expected to transcribe?
No, I would waive that. It's.
Okay, I just want to
appreciate it if I said you don't need to do this, because the actual, well, transcribe what he says, but not, the video is there.
Right, sir. I just want to make sure we're clear about that, so that Amy's not trying to keep up with what they're what is in the video.
I never wish to inconvenience. Amy
All right,
more
sir.
than
I'm sorry to
necessary.
interrupt you. Go ahead.
Okay, the question I think I had was, did you have some personal input into this particular broadcast?
Yeah, so I was contacted by NBC before this ran.
Okay, well, let's go ahead and see it.
Missouri man should learn today if he'll have to keep fighting to get out of jail thanks to an apparent clerical error. He never served his prison sentence for armed robbery, but now, years later, after turning his life around, the state is trying to make him. Here's NBC's Joe Fryer.
As Mike Anderson, a father of four, sits behind bars, his wife says she struggles to eat and sleep.
It's just very hard. And I miss my husband very, very much. My kids miss their father.
She says she recently learned that before they met, Anderson had been convicted, guilty of armed robbery, taking money from a Burger King manager who was making a bank deposit in 1999. Anderson was sentenced to 13 years in jail, but during his appeals posted bond and went home.
He then waited and waited and waited for the Missouri Department of Corrections and the courts to give him a date to surrender and to begin serving his sentence. That day never came.
For some reason, the state thought Anderson was in prison when really he was leading a normal life.
He got married, had children, opened a successful business, coached youth football, joined a church group, did everything that you would expect a normal person to do, because in his mind, he believed that maybe the state courts had changed their mind.
Then last summer, when his sentence was supposed to end, authorities realized an apparent clerical error. Anderson was never in jail. That's when law enforcement showed up at his front door and arrested him. From prison, Anderson spoke with the radio program This American Life.
I never feel like a fugitive because a fugitive is someone that's running from the law. I never ran from law. I was there.
His attorney has filed a petition asking for Anderson's release. Even that Burger King manager thinks the state should set him free.
It's their fault. So, I mean, it's like they're going to try and penalize him for another 13 years? That don't seem right.
But the current prosecutor disagrees.
I believe that if we allowed somebody to avoid an incarceration sentence, it's just a slippery slope.
Missouri's Attorney General declined to comment on the case, but must respond to Anderson's petition today. The legal system will now determine if Anderson's sentence is over or just beginning. For today, Joe Fryer, NBC News.
Missouri man should learn.
Anything else you wish to say about that particular broadcast?
Well, as you can see, there's some resistance to my petition for writ of habeas corpus at that point. The local prosecutor was not happy about it, and the attorney general had not really commented publicly on it. But my change.org petition was directed to both the governor, who I believe was Jay Nixon at the time, and the attorney general, whose name I think was Chris Koster, Koster. So I know that not only were they getting peppered with emails from a change.org petition, but I published their office phone numbers and encouraged supporters to not only email, but to call and write letters.
Okay. Let's go to the next exhibit, which is 78. Another video.
All right, so this is
Well, now
this is
Well, before we do that, I want this is over 5 minutes.
5 minutes and 30 seconds.
Okay, let's not show the whole thing. But first off, do you recognize what this is?
Yes.
What is it?
This is a Fox News Happening Now show that aired on April 17th, 2014. So what's happened by this point is when one network gets interested in a story, other networks will follow. And I was invited to do a live broadcast on Fox News and share my side of the story on this particular broadcast. And I went to the television studio and gave a live broadcast and got my story out. And as it turned out, this was a favorable news piece.
Okay.
So this is me using the media to publish my version of events and explain to the public and really direct at the public officials that are handling the case. This is the narrative. This is the right thing to do. And this is why you should do what I ask you to do.
And this was on April 17, 2 days after the other piece we saw?
Yes.
Okay, let's show some of that. Wait, before we do that, is this advancing the ball because now you're actually being interviewed yourself?
Yes, and this is a live piece. And when I get notice that this is happening, I'm not keeping this to myself. I'm blasting this out on social media and through the change.org petition to now, 30,000 people. Hey, watch this newscast. I'm about to go live, in a couple of hours. And now this is being published, not just on Fox News, but if you're on Facebook and this pops up in your feed, you can just click on it and watch the feed, even if you're not watching Fox News.
All right, let's watch some of this.
If you want,
From Warner
you probably want to scroll forward until my point, because the initial part is just the background information,
That we
which I know you've
have.
already seen.
Let's get Mr. Megaro.
Oh, I'm sorry. Go back. All right, there. Go back. All right. And the significance of this, pause it right there. The significance of this piece is now you start to see the resistance by the Attorney General start to break down, because I'm assuming they've gotten a lot of flack, for lack of a better term, about the injustice that's being done to my client. So,
All right, let's start there.
Error made by the criminal justice system alongside Mr. Anderson's conduct since his commission of the crime. All three factors deserve recognition in resolving this difficult situation. So he's supposed to sit in bars, behind bars for 13 years and make up this case, but his attorney wants something different. He says it's cruel and unusual punishment. Joining us now is Michael's attorney. His name, Patrick Michael Megaro. And Patrick, it's nice to have you on the program. Our viewers really took to this case yesterday when they first heard it, very sympathetic towards your client. But there is one question that comes up. Your client did know he was found guilty of a crime, appeal after appeal. Why did he believe he didn't have to serve the sentence?
Good morning. He did have to serve the sentence. And the problem is that we're dealing with a 23-year-old young man with no legal training, no prior criminal history, no experience with the criminal justice system. He relied upon his attorney, who told him at the time, don't worry, someday the state of Missouri will direct you to surrender. You just have to wait for that day. Unfortunately, that day never came, and he just continued on with his life.
And so he didn't think, one of the reason why I'm bringing this up is that in the Attorney General's response to your case, this is what they say about your client. Essentially, they say that he took advantage of the situation in hope that it would never come up again. They say he has unclean hands in that sense, and that he knew he was under, bond, and he chose not to tell the court. By the way, we'll use this photo of him, his mugshot, but I feel like it's unfair because he has other photos as well of him in the community, and that's just one mugshot. He's never been in trouble since this time in 1999, I believe. But what do you say to the Attorney General that says, hey, he took advantage of the situation?
That's completely incorrect. He notified the court several times that he was out on bail. Even after he lost his appeals, he filed a document with the court, said in the first paragraph on the first page, I am not in custody, and gave his home address. So to say that he took advantage of the situation is simply not correct. It was the state that failed to execute the judgment. It was the state that failed to seek him out and find him.
The state also disagrees with your claim that this is cruel and unusual punishment to have him serve his sentence, which would mean that he would be behind bars now from this point on for 13 more years. But again, in their response, they map out a possibility of another case saying that perhaps they could turn this over to the parole board and your client could be on parole in some sort of agreement to say that he served his time and went through the process. Are you open to that? What do you think?
We are exploring that possibility, and I filed a reply with the court last night going through that exactly. There is another possibility, which I've also filed an application for executive clemency with Governor Nixon. That application was filed yesterday, and Governor Nixon could take the matter into his own hands and simply issue a pardon or commute the remainder of a sentence, which would achieve the functional equivalent.
I just want to point out to our viewers, because they might have seen, we were trying to fix your mic there, so it's not another person in the shot, but we were able to see that. We just want to make sure we hear you clearly. On that final point, we have looked at the state of Missouri and how many crimes they've commuted or sentences they've commuted, pardon me, and it doesn't seem likely. What do you think is the most likely outcome, and what sort of timeline do you see on this? Because again, your client remains behind bars at this current time.
If he were granted clemency yesterday, it wouldn't be soon enough. I've pushed the court to hold a hearing as soon as possible, and I've implored the governor's office to hear this clemency application as soon as humanly possible. This is a man that does not deserve to be removed from the community. He is a credit to his community. He's a valuable member of society, and I want to bring him home to his wife and children as fast as possible.
All right, Patrick, nice to have you on the program. Again, we read
Thank
some
you.
statements from the Attorney General's office there. We look forward to talking to them perhaps and continuing to follow this case. Thank you so much for the time today. We appreciate it.
A couple of questions about that. Did you have input into that particular broadcast?
A lot. All of those photographs,
Being interviewed.
aside from the interview, I submitted to them a synopsis, my synopsis prior, and all of those photos came from Laquana Anderson, my client's wife, and I passed them along to the media to make sure. And as you can see, they're not just using his mugshot, they're using favorable, what I would term favorable photos to humanize the man. As you can also see in the broadcast, there's also now a continued softening of stance from the Attorney General, and they're exploring other avenues for them, I think, possibly to save face, but also to give me what I wanted to do. And as it ultimately turned out, that's exactly what happened. Neither the clemency nor the habeas corpus petition were the things that saved the day. It was I was suggested to file a strange declaratory judgment action asking for a court to determine that every day that Mr. Anderson had spent at liberty would be credited toward that prison sentence. So the judge could immediately declare that the sentence was satisfied. That was what the Attorney General agreed to. And then everything else sort of fell by the wayside because it was no longer necessary. I achieved what I needed to achieve.
All right, and let me just ask you, in the interview there, who was your target audience?
The governor, the Attorney General, and the public at large. I'm making my case in the court of public opinion.
Is that something you did in Brown and McCollum's case as well?
That's exactly what I did in Brown and McCollum's case.
Okay, just a couple of more related to Mr. Anderson. If we could go to Exhibit 79. This is, how long is this? 2 minutes. Okay. What is this?
Okay. When it became apparent that the Attorney General was going to consent to my declaratory judgment action and Mr. Anderson was going to be released for sure from prison, I wanted to maximize the exposure for my client. And I also wanted to turn that into an opportunity for him to benefit from it in some way. So I made a deal with NBC for an exclusive interview to film the homecoming as he was reunited with his children. And for the first media interview after his release on the NBC Today or NBC Today show the following morning. And this is the exclusive video of the homecoming that only NBC was permitted inside the house the day that Mr. Anderson was released from prison. So what happened that day is Mr. Anderson woke up in a prison cell with 12 years and 2 months left to serve on his sentence. He was released from the courtroom. That night, he was with myself, my partner, his wife, and their 4 children in Times Square, New York City, looking up at the lights and getting ready to be on the Today Show the following morning.
And was that a benefit to your client to
Absolutely.
have that exclusive about him?
Absolutely. I believe he was compensated well, and he got his first trip to New York for free, all expenses paid.
How about in terms of rehabilitating his reputation with the public?
It was 100% productive towards that, because as we stayed in New York for, I believe it was 3 days, right? 3 days. And I took him because I know New York. I'm from New York. I was taking him all over Manhattan to show him different places. And as we walked through Central Park, people were coming up to him saying, "Oh, I saw you on the Today Show. Good luck. Hope this all works out for you. You're a good guy."
Just one more. We go to this exhibit 80.
So we're going to begin this.
All right. That's over. Is that over 6 minutes? Let's not show the whole thing, but let's show some of that. What is this?
This is the Today Show on May 6, 2014, the day after Mr. Anderson was released from prison. And this is myself, Mr. Anderson, and his wife, Mrs. Anderson, on the couch at the Today Show, telling the story, and he's being portrayed in a very positive light.
And again, this is with NBC. Is it fair to say that flowed from what the earlier video we saw where you gave him the exclusive?
Yes, this was the deal that he would do the Today Show first, and then he was free to do any other show after that. So this was the first one that morning. We then went to, after this, we went to CNN. He appeared on Chris Cuomo. We went to Fox News, That Happening Now. I can't remember the name of the host, but she interviewed both of us. We did a current affair. We did a couple of New York City local channels, I think New York 1. And there was a couple of radio shows that we did. That whole day was media blitz.
Let's watch a little bit of this.
Probably want to scroll forward a little too, because the entire first part of this video is the intro and the lead-in, which you've already seen.
Right. Show the client. Do we start about there?
This is the homecoming. If
Keep
if
going.
the panel wants, it's on the other video. If the panel wants to watch the homecoming, that's the day before.
Tell us when to start.
Start.
Right here.
All right.
Okay.
So this is the stills, as you can see. Mr. Anderson, Mrs. Anderson, their youngest daughter and I are leaving the courthouse. He's walking out a free man. You could start it up there.
Just so thankful. Thank God for everything.
Anderson's release Monday, even welcomed by the man he robbed back in 1999.
It's about time to let the guy go home. What the state did was their screw up, okay? Not his.
It's one of my happiest days of my life.
Celebrating with his family in St. Louis, Anderson says he looks forward to simple pleasures.
Shower, a bath, some real food, a real bed. Just enjoy these guys.
Ready to enjoy life without looking over his shoulder. For today, Kate Snow, NBC News.
And Mike Anderson is with us exclusively, along with his wife, Laquana, and his attorney, Patrick Megaro. Good morning to all of you.
Good morning.
Mike, I was going to ask you, what was it like to wake up a truly free man? But I hear you didn't sleep at
I
all.
didn't sleep at all.
Why not?
I watched my family, watched them sleeping. Just wanted to make sure I didn't wake up from a dream, though.
What was it like in that moment yesterday in court when they said, you're done, it's over, the slate is wiped clean, you're free?
Didn't have words, just overwhelmed. I couldn't say anything. I was just thankful, just thank God and thank my family and everyone that's been supporting us.
Laquana, you, of course, have been right there every step of the way, taking care of your 4 kids, right? All by yourself. What was it like to have him home and to know that this is over?
The feeling is just great. I miss my husband. I miss my best friend. My kids miss their father. And I'm just so glad that he's home.
One of the things that amazed me to hear your story, Mike, is you didn't want your family to visit you in prison.
No.
You didn't want them to see you that way. So they haven't seen you in all these months.
No.
Why was that so important to you?
I just, especially with children, you know, they're so young and impressionable, you know, you don't know how it's going to affect them. And I don't think any child should have to see their father or loved one like that, because I didn't want my children to feel that was normal. It's something that's acceptable. So I didn't want them to see me like that.
By all accounts, you have turned your life around. But there was a clerical error. You didn't turn yourself in. When you look at that now, and the circumstances now, what do you think you should have done? What would you tell your kids to do? What have you learned from this whole experience?
I just learned God is good. He's awesome. He's got us he's got us through this. His hand was in this the whole time. And, you know, it sounds weird, but if I had to do it all over again, I don't know if I'd do anything different because he just shown me so much of what's going on and just the lives that he's touching. It's not about us. It's not about me. He's doing something for other people out there. The stories of people telling me that it was encouraging to them. And, you know, I got letters from strangers all over the US that I don't even know, you know, and people saying that I've had people tell me that they gave up, you know, they weren't praying anymore, listening to God, and something told them that they need to pray and they need to help. And just, you know, God working in their life is awesome.
Carter, this was a shock to you the moment the authorities finally came 13 years later and took him away. You didn't know about this. Right. Were there moments in these long months where your faith was shaken or you had doubts about who this man was? No, because you have to know the type of person he is to know that he likes to take on a lot on himself, and he didn't want to put that burden on me. So one of the things I think is really extraordinary about this case is that the victim in the initial crime, which you have acknowledged, has come out and advocated for your release, saying this man has lived a good life, he has changed, and he deserves to be free. What does that mean to you?
That's awesome. I mean, that in itself is enough for me. It lets you know his character, his integrity as a man, and that people can get, you know, I don't know if he's gotten over it, but he can get to the point where he can say, hey, that man messed up. He was young, but look at him now. And to hear it from him, that should just let everybody know there that that's a testimony in itself.
Well, Patrick, very quickly, for those who think this is an unusual case, but does it set a precedent for somebody who maybe has not lived as an exemplary life as Mike? What would you say?
It doesn't set a legal precedent, but I think it sets a good moral precedent. It teaches us that if you do the right thing, good things will happen in your life and in the law as well.
Yeah, I think you said it well, Patrick. You said yesterday that justice can be swift and harsh, but it can also be merciful. Thank you all for being here.
Thank you.
Appreciate having you.
That's the last exhibit from the Anderson matter. Let me just ask you, is it fair to say that what you did in the Anderson matter was a prototype or template for what you did with Brown and McCollum?
It was. I applied the same lessons learned from the Anderson matter on how to run a campaign like that and bring pressure to bear to a public official that I did in McCollum and Brown, ultimately successfully.
I want to turn your attention now as to how you got involved with McCollum and Brown.
Sure.
Okay. And first off, heard some testimony about two advisors or something, Ms. Weeks and Ms. Pointer. Do you know who they are?
Yes.
Well, who were they, or are they?
Apparently, Deborah Pointer and Kim Weeks had entered into some sort of agreement with Geraldine Brown at some point in January of 2015, approximately a month and a half to 2 months before I ever became involved or even knew about that Brown and McCollum existed. They'd entered into some sort of contract which provided for some sort of services. And shortly after that, they sent Ken Rose a sort of letter notifying them that, or notifying Ken Rose that they were now involved and they had authorization on behalf of Brown and McCollum to speak to them. Later in February of 2015, I was contacted by my former boss.
So let me interrupt you right there. What you just testified to occurred before you had any involvement in the Brown McCollum matter?
At least a month, possibly 2 months before I had, and before I even knew that Brown and McCollum existed.
Before we go forward, let's look at defense exhibit number 4.
Number 9.
What?
Yeah.
Number 9?
Yeah.
Sorry about that.
Okay.
Well, is that the letter of authorization?
No, that's the contract,
Oh, the contract.
that Pointer
I'm
and
sorry.
Weeks Inc. Had with Geraldine Brown and it says as guardian for Leon Brown and Henry McCollum. She was not guardian at that point. She was actually power of attorney. And if you scroll down, that consideration 2A, paragraph 2A of this, in the last portion of that paragraph, you can see the words 10% of monetary advance, 5% of penal funds, and 1% of civil lawsuit settlement. So that was the terms of their compensation that that they had contracted with Geraldine Brown for their services, whatever those may be.
And ultimately, what can you say about what services they provide?
If I could characterize it in a word, subpar. They were supposed to be doing exactly what I had done in the Anderson case. They were supposed to be these social justice warrior types. They were had all of these contacts in television and media, and were going to publicize the case. That turned out to be incorrect. They were incompetent when it came to all of that. The other portion of the services they were supposed to provide was some sort of, for lack of a better term, social workers. They were supposed to help these guys get an education, get them set up with medical appointments, that sort of thing. And that likewise fell apart.
Did
But-
you?
I'm sorry, go ahead.
Oh, go ahead. I interrupt.
I was going to add something, is that, as you can see from that last, or the portion of 2A in parentheses, as of January 2015, before I even became involved in this, there was already contemplated a monetary advance. It's in writing right there.
Can we scroll down just to see who signed this?
This version that I have is unsigned. I never received a signed version. I was told it existed by both parties on either side, but I never got a copy. This is the only copy that I got.
All right. And we'll get back to some more with Ms. Weeks and Pointer, but again, prior to any involvement you had, I want to look at defense exhibit number 81.
Okay.
Now, what is this, and why is it significant?
This is an article published by Joseph Neff at the Raleigh News and Observer, dated January 31st, 2015. Again, at least a month before I got involved. And the title of the article is "For Henry McCollum and Leon Brown, Freedom Has a Cost." And if you scroll down, I'll show you the portions. Okay, so right there. This,
And just to be clear, the emphasis is what we've added. This doesn't
Yes.
appear in the original. Okay,
right,
go ahead.
the highlighting is yours. What this article detailed was the conditions that McCollum and Brown were living in as of January 31st, 2015, and really showed that they were in dire straits, which is ultimately how I found them when I met with them in person for the first time on March 1st, 2015. They were struggling. They had serious financial problems. As you can see, McCollum is unhappy about his financial situation. He's not able to pay bills. If you scroll down, I'll go further. Go down. Keep going. Okay, pause here. What this article also detailed on January 31st, 2015, is that Leon Brown, who had been previously medicated with some heavy-duty psych meds, had stopped taking his medication because of side effects, which I've experienced countless times in my career as a criminal defense lawyer. And at this point in time, he's stopping taking his medication. Go down.
you had highlighted there, waiting for a pardon.
Yes, okay, go up, I'm sorry, we forgot that. Okay, so this is a byline in the article. What Joe Neff is also publicizing here is that there's been several months with no activity on the pardon application that Ken Rose had filed for them in September of 2014. And as they wait and wait with no activity, their financial situation, their living conditions are deteriorating. Go down. Okay. And this highlighted portion here on page 4, Joe Neff is detailing the fact that there's apparently an allegation that the Center for Death Penalty Litigation and Ken Rose had a fundraiser. That wasn't enough. The water was turned off, the bill went unpaid, the rent was unpaid. Keep going. Okay, now this highlighted portion is Joe Neff reporting on the fact that there's been no public action on the case since the pardon application was submitted on September 11th, and that the governor's office was unresponsive to inquiries.
Anything else
In
this
I'm
article?
not sure. Oh, right there. Okay.
Okay.
This portion of the article on page 6 shows that McCollum, his plans for the future. He's joined a church. He's now on Facebook. They applied for Medicaid because they had no money to pay for medical insurance, and he has financial worries. If you scroll down more, I'm not sure if that's it, but I think that was it. Okay.
Now, the next exhibit I would like for you to look at is Defense Exhibit 3.
Okay. So 2 or 3 days, I mean, it's dated February 2nd, 2015, but you can see from the fax header, it says February 3rd. I think there was testimony from Ken Rose that he received this on February 3rd. This is a letter of authorization consent sent to Ken Rose by Kimberly Weeks, basically demanding information and having or representing that she has authority from McCollum and Brown to, I guess, waive attorney-client privilege or to get some information. And here you can see in the first paragraph after Dear Attorney Ken Rose, it says Miss Geraldine Brown, whom has legal authority, a legal power of attorney of Mr. Henry McCollum and Mr. Leon Brown. So this is representing that Geraldine Brown had power of authority. I'm sorry, power of attorney for Henry McCollum and Leon Brown. And this is dated and signed by all three on February 3rd, 2015.
And was that before you had any involvement?
Yes, and it was also consistent with when I met with Geraldine Brown, Henry McCollum, and Leon Brown in person for the first time on March 1st, 2015, that Geraldine Brown showed me 2 powers of attorney, one each for Henry McCollum and one for Leon Brown.
Did you ever get a copy of those powers of attorney?
I did not.
But you saw them?
She showed them to me. She had them in a folder in sort of a, in the 80s, we called it a trapper keeper. And she opened the folder and showed me on each side of the folder the powers of attorney. She only had one original for each. She did not have any copies, and I didn't want to take her only originals.
All right. So we're now at the point where you actually did get involved somehow. Could you describe how that occurred?
Sometime late in February of 2015, I was contacted by Scott Bretschneider, my colleague and friend and former boss in New York, that told me that he'd learned of this case. He'd been contacted by someone. The case was in North Carolina. It was 1983 action. And would I be interested in looking at the case? I said yes. I found a bunch of news articles about the case online, and there was a link in one of those articles to the actual transcripts of the motion for appropriate relief hearing, which was held on September 2nd, 2014, which I believe was about 130 or 140 pages long. I read through those transcripts. I found some additional information, and then I did some legal research into what claims and how to process those claims. And once I determined this is something I might be interested in, I contacted Mr. Brett Schneider, and I was put in touch with Deborah Pointer. I think it was the last week of February 2015, I was traveling to New York and New Jersey to argue a couple of cases that I had pending. Mr. Hallscott was with me. He just happened to come along, and while I was up in New York, I set up a meeting with Deborah Pointer at the Brooklyn Marriott Hotel. The Brooklyn Marriott is centrally located in downtown Brooklyn. It's sort of surrounded by 5 or 6 courthouses, and that's just a place where lawyers congregate because there's a restaurant there, there's a lobby, there's parking. That was the most convenient place to meet her. And that's where I met Deborah Pointer for the first time. I don't remember the exact date, but it was sometime after February 21st, 2015, but before March 1st, 2015.
And what happened at that meeting?
At that meeting, she gave me some information. She got Kim Weeks on the phone, who was located in Atlanta, Georgia. And they presented themselves as these civil rights advocates for Henry McCollum. And I was told that Kim Weeks had a family connection to Leon Brown as some sort of cousin or cousin of a cousin, something like that. But she said she had some sort of family connection, and that's how she had gotten involved. And they were the gateway to Henry McCollum and Leon Brown, and their sister Geraldine Brown.
What happened next?
After I spoke with them, expressed interest in the case. They asked me my thoughts. I outlined for them, based on the statute, this is what the possibilities are.
When you say the statute, are you talking about the pardon statute or something else?
The statutory award for the Industrial Commission. They wanted to know, if you were to take this case, how would you handle this? And very simple. It's very straightforward. The step number one is to get a pardon of actual innocence from the governor, because that's the only way that you can achieve the statutory award of up to $750,000 for a wrongful conviction. It's right in the statute. The other thing they wanted to know is, did I have any experience in 1983 litigation? I did. And I said, this is what I envisioned the claims to be, that there would probably be a deprivation of due process. There would be a false arrest, a malicious prosecution. None of this is secret. But these are the types of claims that you can raise in a 1983 action. And I also knew from my research that getting a pardon of innocence, in my opinion, is absolutely indispensable to the success of any future civil rights lawsuit, because without that declaration from either a court or from an executive body that these men were actually innocent, it would have been much more difficult to establish a claim of malicious prosecution, false arrest, and deprivation of due process.
And did you discuss that with Ms. Weeks at that meeting?
I outlined briefly the strategy, and I also outlined a strategy for using the lessons that I learned on Anderson to apply those to McCollum and Brown, and how I would go about getting a pardon.
And what you described, was that similar to what you just testified to about your strategy for social media campaigns and the like?
Yes.
Well, what happened next? Well, how did you leave it at that meeting? Was there, what was to be decided, or what was to be the next step?
They just said, okay, we'll pass this information along to Geraldine and the brothers, and you'll hear from them or us or both next.
And did you?
I did.
Tell us about that.
After I returned to Florida, I was contacted by, I believe it was Deborah Pointer, and she said they're interested. They've looked you up on the internet. They found out some information about you.
Sorry,
Sustained.
objection to
sorry.
hearsay.
I have to remember myself.
Well,
Okay, all right, I'll start over. After I returned to Orlando, I was contacted by Deb Pointer. She just indicated that they were ready. to take the
Objection.
next-
well, let me, if I could address that, I'm not offering it for the truth of it. We're offering it to explain what he did and why. I don't think that that's classically hearsay.
Mr. Megaro, just tell what you did after receiving the phone call.
Certainly. I sent a proposed retainer agreement to Deborah Pointer to forward it to Geraldine, and I awaited the next step, which was a call from Geraldine directly. And that happened.
And that happened.
And Geraldine invited
When did that happen?
on the 27th or the 28th of February. I can't remember the exact date, but it was at the tail end of February, and I was invited to go meet with Geraldine, Henry, and Leon at their home in Fayetteville.
And was that a call from Geraldine or?
Yes, Geraldine called me directly and said, well, I won't tell you, I won't say what she said.
Objection.
She just invited me to come up and meet with her.
Okay.
Well, just Mr. Megaro, please just say what you did after receiving the phone call rather than having a direct quotation that runs the risk of hearsay.
After I received the phone call from Geraldine, I booked a flight and went to Fayetteville on March the 1st, 2015. I believe it was a Sunday.
And when you went there, what did you do?
First thing I did, obviously introduce myself. I made observations of the house as soon as I walked in.
What were your observations of the house?
It was disturbed by the conditions that they were living in. I'm trying not to be disrespectful, but I did not consider it fit for human habitation.
Could you describe it in a little more detail? Just give us an idea.
It was filthy. It was devoid of furniture. They had dirty mattresses with no covers on the floors of the bedrooms that they were sleeping in. They had no dressers. There was clothes all over the place. It smelled. It smelled like mildewed rug and cigarettes. And the only furniture that they had was a couch, looked like it had been picked up off of the curb. And there was a outdoor patio set for furniture in the kitchen. And when I came in, I brought a pastry ring from Panera Bread. And Geraldine offered me coffee, and she opened the refrigerator, and I looked inside, and the only thing inside that refrigerator was a container of Sanka. And as she made, I then declined the coffee. And I turned around, and Henry and Leon had dug into that pastry, and they had no forks and knives, no napkins.
But what did you do at the meeting?
First thing I did was I introduced myself. I talked about my experience. I talked about, I asked them questions about the case. I asked them if they had any documents to show me. That's when Geraldine showed me the powers of attorney. She also had, as is very common when you speak with clients, they have bits and pieces of documents. She had a trapper keeper with some documents in there. I went through them with her. I asked her questions about them. I asked Leon and Henry questions about them. And then I asked them if they had any more. Henry, when it disappeared, he came back out with a prison laundry bag. And inside the prison laundry bag was a bundle of papers about 24 inches, looked like it had come from prison. They were in rough shape, and they were tied together with a string. And that was his documents, his case file that he had. And I went through all of those documents with him. I asked him questions about it. And that's when I learned that they'd had separate retrials. And I just kind of went back and forth asking them questions. How did the trials go? Who said what? Who testified to what? What was the evidence introduced? Those sorts of things.
Were they able to cooperate with you and give you answers to your questions that you were
Yes.
asked?
Henry remembered things with incredible detail. And to listen to him tell the story about his time on death row, and in particular to describe him watching friends of his dragged out of their cells to go to their executions, and some of them would go kicking and screaming, some of them would go singing, some of them would go willingly, some of them had to be carried out. He could tell you the names, the dates, and the details of every single one. I think it was 41 or 42 people that he watched march off to death. He was able to recall for me in excruciating detail.
I'm going to object now to hearsay. I think we've heard enough about that, and this whole narrative of what Henry told him is hearsay.
Sustained.
Well, if I could just say in response to this, it's relevant to, they're making a claim that it was evident to him that when he met them that they were mentally deficient. And I think his sense impressions of their abilities and what they were able to tell him is relevant to that. I'm not offering it for the truth of it. I do not believe that's hearsay.
I don't have any objection to him describing his belief into the ability of the clients to understand the conversations. My concern is that when we get too far down this road about what they were saying and specific things that they have told him, there's not ability for the state bar to question about that. Now, I understand the point about it not being truth, not being offered for the truth asserted herein. I'm going to allow some leeway about this, but I think the focus needs to be on the impressions that he formed and not the details necessarily of the conversation that he had with Mr. McCollum or Mr. Brown.
All right, very well. Well, let me just ask you that right now. Did you form an impression based upon that meeting and your questioning of them and their answers as to their mental capacity or deficiencies or what? What was your initial impression of it? And if you give it separately as to Mr. McCollum and Mr. Brown, if you would.
Okay. Mr. McCollum presented to me as no different than any other client I've represented in the past 20 years. That's number one. Mr. Brown presented to me as no different than any other client who had mental illness issues and was medicated in the last 20 years, and I've represented many of each.
All right. Now, as a result, well, how long did that meeting last?
Hours. It was several hours because it took me a long time to go through the history, 31-year history of the case with each one of them and go through a stack of documents, 2 stacks of documents that Geraldine had on Leon and Henry had for himself. After I went through, and I always lead off a conversation like this, so tell me about your case, and I let them go. And then I just follow up with questions. I did that in this interview as well. After we discussed the history of the case, they then asked me, so what can you do for us? That was the question that they wanted to know. And I outlined the strategy of how to get a pardon, the importance of getting a pardon, and how a civil rights action worked, what the claims would be. I went through in a sort of truncated form, the basic elements. You have to prove this, you have to prove that. And based on the information they'd given to me, I worked that in and I said, well, we can prove this way based on what you've told me, based on this document. You know, see, it says right here, he did this, we can use that for that. And I went through all of those things with them. After I went through all of that with them, they huddled in a separate room for a little while. I just sat there and waited, and then they came back.
Okay.
And I say they, all three of them, Geraldine, Henry, and Leon.
Okay. And as a result of that, did you enter into any retainer agreement that day?
I did. And I'd prepared a retainer agreement that I had previously sent to Deborah Pointer and or Kim Weeks that had been passed along. They already had it. They had a printout in front of them. I brought a fresh copy with me. And I went through with them the retainer agreement, paragraph by paragraph.
And what was the source of that retainer agreement? That is for you. How did you draft that or
Sure.
okay.
I found the form online on a Texas website. It was an approved form that the Texas bar had approved. I later learned after this all came about that the state of Texas has the same prohibition of charging liens that the state of North Carolina does. I didn't know what a charging lien was then, and frankly, I still don't know what it is now, but in any event, I used the form that I found online, this approved form, and I simply changed the names, obviously, and I changed some of the terms because the form that I found online, I believe, was just a straight third, 1/3%, or maybe it wasn't. I don't remember what it was, but I know I adjusted some of the percentages because this was a graduated contingency fee agreement.
Mr. DeVore, if you wish, it's been 2 hours. This thematically would be a good place to break if you wish.
All right, so that's fine. Why don't we take our morning break at this time? We'll resume at 10:30.
Thank you. In terms of the timeline, we were still at that.
I can't hear. I'm sorry. There's a lot of background noise, and that's actually coming through more than your voice.
We'll close the doors.
Thank you. I'm sorry.
That's all right. Can you hear me okay? I do have my microphone on.
Can you move a little bit closer?
I can move the microphone too.
Tilt it down.
Not that tall.
Better.
Is that
Thank you.
better?
Directional.
Right. Okay. Okay, I think we're ready. We last left it, you were still at the house in the meeting with Geraldine, Weeks. Were Weeks and Pointer, were either of them there?
No.
But Brown and McCollum were there,
Yes.
both, and you.
Yes. And Scott Bretschneider was there, but he wasn't really participating in the discussion. I was doing the talking. He was just kind of hanging out, listening.
All right. Now, I believe you testified before the break that they did sign a retainer agreement at that meeting.
Yes.
And let's look at that now. If you could bring up Exhibit 105.
This is States 105. Okay.
Well, it is within it. It's an Exhibit C, but if you scroll down. Okay. Do you recognize that as the retainer agreement that was executed that day?
Yes. I don't know if I don't remember from the other day whether this has the signatures on it. If you could scroll down. to the
Scroll
bottom.
down.
Okay. Yes.
Okay.
Scroll
So-
down a little more. Yes. Okay.
So, and this is apparently fair to say that this is a fully executed copy of the retainer agreement.
Yes.
And
I think there's some pages that come after the signature page. If you could scroll down a little more. Yes. Okay. Keep going. Okay. Yes.
okay. Go back to the signature page. Okay. And do you see Mr. McCollum's signature there? Did he sign that himself?
That is his signature, yes.
What about for Mr. Brown?
That is his signature, yes.
That is the way he signs his name.
Yes.
Nobody signed for
Sometimes he signs it with a script L. Sometimes he prints.
it? All right. And then also there's Geraldine Brown.
Yes,
And you see that she signed as attorney in fact.
that is her handwriting, yes.
And as you previously testified.
This
you
is our fourth or fifth leading question in a row. I understand this is direct exam. I would just object that we ask questions instead of guiding him through what we want to be said.
Mr. Williamson, don't lead.
All right. How did she sign? In what capacity?
She signed as their power of attorney on behalf of both.
And was that something that you had seen?
Both powers of attorney I saw, yes.
Okay. If we could go back up. All right. Been in evidence. I'm not asking to go through the whole thing. But is this a contingent fee agreement?
Yes, this is a contingency fee agreement. It's a graduated contingency fee agreement, which has different percentages based on the amounts awarded or collected in a settlement. And they did that to give them a competitive rate, so to speak, because I knew they had a retainer agreement with someone else, and I wanted to undercut the competition.
All right. And what we see on the screen there is that the graduated amount?
Yes. Yes.
What is it?
It's 1/3 or 33% of any recovery up to 1 million. And then anything between 1 million and 2 million is a 30% contingency fee. And anything above 2 million is 27% contingency.
And does this agreement cover any sources of recovery on their behalf?
Yes, this agreement is for the entire matter, which included the pardon petition, the industrial commission award, and a lawsuit that was contemplated because as of March 1st, 2015, nothing was guaranteed. There was nothing that was a lock or for sure. Everything was dependent on getting that pardon of innocence.
Was there a pardon of innocence petition pending at that time?
There was a pardon of innocence petition pending. And from the information that I had, it had laid dormant for several months. And the clients were extremely unhappy with that situation, as they expressed to me over and over.
All right. Was there ever any separate agreement for the industrial commission recovery?
No, it was all one and the same. It was never broken up into different parts or pieces. It was for me to represent them in the matter of getting any recovery due to their wrongful incarceration.
And did you explain to them what the potential sources of a recovery were?
I did. Among many other things, I went through, as I do with every single client, I go through paragraph by paragraph and I break it down to terms that laymen can understand in the simplest language possible. I don't know why over the years these retainer agreements are worded the way they are, why they're required to be the way they are, but I always break it down in the simplest possible terms. And if necessary, I'll draw it out on a piece of paper, I carry a yellow legal pad, and I'll draw out and use a calculator to show them this is what this means. If I get 1 million, this is what you get, this is what I get, so on and so forth.
And did you go through that process with them that day?
I did.
Now, without saying what anybody said to you about it, simply describe in more detail, if you can, specifically what you said to them or explained to them about this agreement and its effect.
So after I explained the agreement to them, they huddled.
No, I want you to tell me what you told them about it. Did you go, well, you said you went through it. What did you tell them? Give some detail as you recall.
Okay. When I explain a contingency fee agreement to people, I always tell them, if you don't get anything, I don't get anything. So that's number one. Another thing I always say, even though that's at the end, I say it right in the beginning, is if you don't like me for any reason, you can fire me at any time for nothing, no reason at all. And I always use, even if you don't like the color of my tie, you can fire me because you don't like the color of my tie. So those were some of the things that I said to them. When it came to the recovery, the graduated contingency, I drew it out on a piece of yellow paper and I showed them using a calculator. This is, okay, so let's say you get $1 million. This is what I get, this is what you get. And I show them on the calculator and I write it on the paper. Say you get $1.5 million. This is what you get, this is what I get. Say you get, $2.5 million. This is what you get, this is what I get. And I always tell them, and sometimes there's always other costs involved. So I went through the concept of expert witnesses. They were already familiar with that. I said, there's always filing fees. We have to pay for transcripts. They already knew that by virtue.
Objection to what they already knew and they were already familiar with. He cannot testify to that.
Sustained.
Just again, tell them what you told them. Keep going down that list, what you told them.
Talk to them about expenses. You realize I'm in Orlando, I have to come up. That means there's travel expenses. I have to get on a plane, I have to get in a car. Sometimes we have to travel for this or that. We have to go out, we might have to hire a private investigator. We might have to hire witnesses, expert witnesses. There's filing fees, there's fees to the court, there's costs for transcripts. As I said, there's probably others. I just can't think of everything right now, but these are the types of things that you see in a case like this.
Right. Without saying what they said, did it appear to you that they had an understanding of what you were telling?
Yes, because they would interject with questions as I was going through.
Without saying
Objection.
what the questions were, did you get questions from?
I got questions and I gave answers to those questions, yes.
And without saying what the questions were those questions that you would expect from an engaged and interested potential client?
The questions that I got from them were no different than any question that I've gotten from other clients in any other type of retainer agreement. And it's always a lot of what ifs. What if this, what if that? And then I would explain, okay, if this, then that.
If you recall, how long did it take you at that meeting specifically to go through the agreement with them as you just described?
I don't remember how long it went to go through the agreement with them. I was at the house for several hours. A lot of it was me asking them questions about the case and the stack of documents. I needed to have a full understanding of what they knew. How much time was devoted, I can't say for sure. It took a while because there was 3 different parties rather than just one party. There were 3 different people that I had to explain this to.
But you explained it to them all at the same time, not so. Yeah.
At that kitchen table, yes, sir.
Okay, or did you? I don't mean to lead you. Did you tell, by the time you left that meeting, did you tell them what you were going to do next?
Yes, when we left that meeting, I didn't just leave them at their house. We actually had to find a notary public that was open on a Sunday, which we found one in Fayetteville. And I took them with me to the notary because I needed them to notarize some authorizations for release of information. One of the things I explained to them is, I need to get your file and your records and your medical records from all these different places. I had to write to the North Carolina Department of Adult Corrections, So I knew they had medical records there. I knew they'd seen some doctors since they'd gotten released from prison. I knew I had to get those medical records. I knew that they had a number of prior attorneys, so I needed authorization to obtain those medical records. In addition to the retainer, I went through these authorizations with them and explained to them why I needed this material. And then we went to a notary public so they could sign the authorizations, get them notarized, and then I dropped them off at home.
And once you dropped them off back at home, then what was the next thing you did on this matter?
I went back home to Orlando, and I think it was the following Monday, I started sending out authorizations. I started notifying other attorneys that I was retained. I think within a week, I notified the governor's clemency people that I was retained, and I started gathering all of this information from all of these different sources.
Let's look at Defense Exhibit 1. Well, first of all, before we leave there, would you bring up Defense Exhibit 102? Do you recognize that?
Yes, that is a photograph of 417 Perth Street in Fayetteville, North Carolina. That was the house where Geraldine Brown, Leon Brown, and Henry McCollum were living when I met them on March 1st.
All right. Let's next go to Defense Exhibit 150.
This is a letter I wrote to Thomas Howlett, Howlett, and Mike Lewis, Esquire, Bloomfield Hills, Michigan. This is my letter to them notifying them that I've taken over the case and to please send me a copy of, and I sent them also a notarized release and asked them to send me a copy of their file.
Did anybody send you a copy of their file?
I believe they did send me something, but I think it was relatively small in comparison to what I received from other sources.
Without saying the source of your knowledge, is it fair to say that at this time you had some information that you knew these gentlemen were representing Brown and McCollum in the civil matter?
Yes, it's documented. It's in the emails that was turned over to the bar.
Okay. Now, let's also go to Defense Exhibit number 82.
Okay. This is a letter that I wrote to the office of the governor and the clemency office. Sent it by mail, fax, and email on March the 9th. And this is me reaching out to them, telling them I've taken over the pardon process. And I wanted to check the progress of the applications.
Did you get a response to this letter?
To this letter, no, I was not responded to, or I did not receive a response for them for a while, which motivated me, and put it that way.
So what did you, were there other letters that you sent out after the meeting for authorizations as you testified to?
Yes, I sent, I know I sent one to Ken Rose in the Center of Death Penalty Litigation. I sent one to, I think the name of the firm was Wilmer Hale Cutling or Cuttering, something like that, which was the firm that Mr. Rose had been working with on Henry McCollum's behalf. I sent.
What was that in connection with the pardon petition or the civil lawsuit?
Well, both, but my immediate concern was the pardon application because that was the pressing matter, number one. And I knew that I needed I needed as much information as humanly possible in order to prosecute that pardon application intelligently and expeditiously.
And was it to the pardon process that you turned your primary attention to at that time?
Yes, because I knew that without that pardon, in my opinion, the civil suit would probably have not been viable. I put all of my stock and energy into that, getting that pardon of innocence from the governor.
Okay. If we could look at Defense Exhibit 83. Now, what do you recognize this?
Yes.
What is it?
This is an article published in the New York Times on March 16th, 2015 by the journalist Alan Blinder, Blinder. And this was something that I helped set up after I was retained. And this was one of the starts to my public relations campaign. I wanted a large media outlet to start publishing information about this and starting to put some pressure on the governor's office to issue the pardon of innocence.
So did you have a personal input to that?
I did.
Is there
the photograph in there, for example, was supplied by my office. And that was the house that Henry McCollum and Leon Brown moved to shortly after I became involved in the case in Eastover, North Carolina, which is right outside of Fayetteville.
To your knowledge, how were they able to move to a new house?
They took out advanced loans from multi-funding.
Now, did you have, what involvement, if any, did you have with those advanced loans with multi-funding?
My involvement was simply to supply information to multi-funding. My involvement was also to acknowledge receipt of some documents and acknowledge the existence of the lien.
Did you recommend, well, first of all, did you have any prior experience yourself with multi-funding?
No, I did not know multi-funding existed until this all came about.
Okay. Were you involved at all with contacting multi-funding to arrange that loan?
No, to my knowledge, it was Deborah Pointer and Kim Weeks that contacted multi-funding, and then they contacted me as the attorney to ask for a synopsis of the case, which I provided.
Now you mean multi-funding?
Multi-funding. I emailed them a short synopsis of the case. I did not express any opinion as to the viability of the lawsuit, viability of the claims, or anything like that. I then acknowledged receipt of some documents, and they funded the loan to Henry McCollum, Leon Brown, and Geraldine Brown.
And that was loans to them, is that right?
It was not loans to me, that's for sure. And I never took custody of any of that money. It was sent directly to Mr. McCollum and Mr. Brown.
And to your knowledge, did they use at least a portion of those proceeds to move to a better home?
Yes, they prepaid an entire year of rent in advance. I did not find them that home. My understanding was they found it through a real estate company. Who hooked them up with the real estate agency, I couldn't tell you. But that was where part of their loan proceeds went to, is paying a year's rent in advance for a very nice house in Eastover.
All right, well, let's take a look at that. Could you bring up 103? That the house that they
Yes,
rented?
103 is a photograph of 1847 Rock Rose Drive in Eastover. That was the house that they settled into, and the New York Times went and documented, as you can see from the article, they're documenting their move into a new house and their improvement in life. The house pictured in this photograph was, in my opinion, 10 steps above where they were living. It was a nice, quiet neighborhood, an upscale neighborhood. I don't know how old the house was, but it appeared to be brand new and unlived in. And it was
You
much
ever
more
go
spacious.
inside it?
Yes, several times.
Was there anything else that you wanted to note about the New York Times article? Do we need to go back to
Yeah,
that?
can you go back to it? Sorry.
That's 83.
I think you scroll down. Okay, yeah. As you can see, there's what I would term a non-responsive response from the governor's office when the New York Times contacted them. They're just saying our review is ongoing. And at that point, there had not been a review, as I learned later.
Okay.
Well, I don't want to say there had not been a review. There had been no activity. I learned later that the activity all came about after I entered the case.
All right.
Objection here. Can I get some clarification on where we're getting this information?
From documents provided to me by the Innocence Inquiry Commission that I turned over to you.
Well, okay. Is there anything else about this article that you wish to bring to the attention of the panel?
The article really speaks for itself. It's really just talking about, the whole thrust of the article is, why is this taking so long? Why is nothing happening on this pardon application? It's been 6 months.
And is this part of your media strategy campaign similar to what you outlined before?
Yes.
And did you continue that campaign after that date? That article being March 16th. Not.
I did. I continued it in various respects. One of them was starting my own change.org petition and promoting that.
Okay.
Another.
Well, let's look at that.
Okay.
That's Exhibit 89.
All right. So if you can see, this is my petition on change.org. And it's marked victory, which means it was successful. And I gathered 34,030 supporters in this. This was one of the, if not, actually, I think this was the shortest run of a change.org petition that I've ever had. This only lasted 2.5, maybe 3 months. This is the quickest victory I've ever gotten.
When you say shortest run, it only ran as long as it was necessary. Is that what you mean?
Exactly, as compared to, say, Corvain Cooper's, which lasted all of Obama's second term and all of Trump's first term. No, I'm sorry, most of Obama's second term and all of Trump's first term.
Can these change.org petitions last indefinitely? I mean, you have control over how long they last?
I don't know, but I there are several on there that have lasted just years and years and years, and I guess go into the ether. I have no idea when they purge them or if they purge them, but
Now, as far as the content of this petition, who prepared that?
I did.
Now, you had mentioned about Pointer and Weeks. Did they have any input or help you at all with this?
Not with mine. They started their own, and they were very proud of the fact that they had 215 supporters. And I told them that is not going to work. They did not want to spend any money promoting their petition.
Objection to what they did or did not want to do.
Yeah, sustained.
Okay. Are you aware if they did spend money?
I have no information that they spent money, and I would have to say no.
Again, is this part of your ongoing strategy for the pardon?
Yes, this change.org petition is an advocacy piece. This is my narrative that I want to get out in the media. This is my call to action. This is me asking the public to join me in this cause to the governor's office.
Let's also go, did you plan some sort of a rally? On
I
their
did.
behalf?
I did.
Tell us about that.
As I think all of the people in the audience here that are here for me will tell you that I do not react well to being ignored. And when I felt that I was being ignored by the governor's clemency folks, I decided I was a little bit more than a standard media blitz was going to be necessary. So I decided to plan a rally in Raleigh or rally for justice. I forget what I termed it. It's in one of the exhibits there. Okay, rally for justice. And Mr. Hallscott and I had an assistant working in the office that had some, his background was in graphic design. We put together this rally. I planned it, and I planned it for May the 19th. I gave plenty of time for a lead to for people to plan to attend this rally. I then contacted every church, every sort of social justice community type organization in a 100-mile radius of Raleigh. We hired a temp to sit there and make calls all day long to gather support, to get people the information about this rally. We put out press release regarding this rally, and we published the rally and press release through social media as well, and through the change.org petition.
In that regard, let's look at Defendant's Exhibit 91.
Okay.
Do you recognize that? What is it?
Yes, that is the flyer for the rally that I put out. This was attached to a press release. It was attached to social media postings, and I hired people in Raleigh to paper the cars downtown by putting them on the windshield wipers, cars parked on the streets.
And you referred to a press release. Let's look at Exhibit 90.
Okay, this is the press release that I distributed on April 21st, 2015, which gave people approximately 1 month for this rally. And this is me announcing this. And I can't remember the outlet that we published this press release through. We used several different ones back then. But this was a press release that was published through a service that then puts it into not only social media, but also dumps it into local mainstream news media and national news media as well.
To your knowledge, was it picked up by other media?
Yes, it was.
What do you recall about that, if anything?
I just remember some media inquiries about the rally coming into the office, asking if it was still on.
Let's go to Exhibit 93, Defendant's 93.
Okay. This is a list that we had prepared of some of the organizations that we contacted to get supporters to the rally. It was my intention to have a number of people in front of the governor's mansion with signs and placards supporting the cause of Henry McCollum and Leon Brown to get that pardon of innocence.
And did you contact or have contacted through your office all of the churches that are on this list?
I don't think I contacted the churches. I know I contacted other organizations like the NAACP, the Southern Poverty Law Center. I don't remember exactly who I contacted, but I know I contacted several, but I believe this list was for the temp that we hired to go down the list and call, and she would get contact information so she could send them the press release and the flyer.
All right. what kind of response did you get, without saying what anybody said to you, just say what kind of response did this generate?
We had a positive response. There was a number of people that were aware of the case and that had promised to show up at the rally.
Right. The next is Exhibit 92.
Okay.
What is this and what's the significance of it?
You can see in the top left corner of the page the date, March 26, 2015, which is the day I printed this. One of the things I wanted to do was make sure that if we were going to hold a rally, that that we would be licensed, permitted, and we wouldn't have an unlawful demonstration. So I had to look up the ordinances, the local ordinances for the city of Raleigh, and make sure that whatever I wanted to plan was going to be lawful, a lawful assembly. I didn't want to get a bunch of people out there just to get arrested for unlawful assembly or something like that. So I looked up the local ordinances, and I contacted the library that was across the street from the governor's mansion to ask if we could use the sidewalk and the grassy area as a staging area for the rally.
So was it your intent to comply with whatever was required by the city?
Yes, the last thing I wanted was an unruly rally that would devolve into arrests or something that would go sideways and then not achieve the desired effect.
Okay. Now, getting back to Pointer and Weeks, what, if any, role did they have in this rally or the planning for the rally?
I had asked them for assistance, and they were unable to provide any meaningful assistance.
Did this rally actually occur?
Did not.
Why not?
Because shortly before the rally was set to occur, I received a contact from the governor's the governor's council, office of the governor's council, inviting me to participate in an interview with my clients as part of the normal procedure for the pardon process. And if you want me to go on, I'll explain what happened at that meeting.
Let's hold that thought. Let's look at Exhibit 95.
All right, if you go down the bottom, no, all the way down. Sorry, up a little. Okay, up a little more. Right there. Stop.
What are we looking at here, and what's the significance?
Okay, this is the last page of Defense 95. This is the email from myself to Lindsay Wakely, who was an attorney with the governor's council, office of the governor's council. And I'd sent her a confirmation email that I would meet with her, Mr. Bob Stevens, and a third attorney whose name I can't remember at the moment, at the Brownstone Hotel in Hillsborough Street in Raleigh. Whatever the following Wednesday would have been from May 8th, I want to say that was May the 13th by my count, I might be wrong, at 9 a.m. with Henry McCollum and Leon Brown. And if you go up, if you scroll up, she confirms 9 a.m. works for them. And Bob Stevens and Jonathan Harris, the three of them were planning to attend. And she asked me specifically that I do not notify the media or have any members of the media attend.
Did you comply with that request?
Absolutely. I did not tell the media, and I did not want any media there.
And that was to be for what day?
I believe it's Wednesday, May the 13th, if I'm calculating the dates correctly.
Okay.
It says the following Wednesday, so. Okay, all right.
All right.
Then the next email is that Friday after that May 13th meeting.
Okay, before we go after the meeting, I want you to describe well, before I do that, as a result of this communication with the governor's council, was the rally canceled?
As a result of the meeting on May the 13th, the rally was, I canceled the rally. Yes.
All right. The cancellation happened after the meeting with the governor?
No, the cancellation happened after the May 13th meeting with Governor's Council at the Brownstone Hotel.
Oh, okay.
The interviews with McCollum and Brown separately.
All right. So just so I may be a little confused, in terms of the timeline, there was the meeting with the governor's council first, is that right?
Right.
And then the cancellation of the meeting, of the rally, excuse me.
And then the meeting with the governor himself.
Okay. Well, how did you cancel the rally?
It's not easy to undo, but number one, you have to publish now a press release canceling the rally to notify everybody that it's off. The other thing you have to do is go through that same list and make all of those phone calls again and say, by the way, this rally is canceled. It's going to be rescheduled at some future undetermined date. That's what we did.
So you got that press release out there?
Yes, and I believe
the
that's in
word
the
out.
exhibits. Yep.
97.
Okay,
We
there
look
it
at
is.
97.
Okay. Yes, as you can see on May 15th, 2015, I put out a press release saying we've met with representatives from the governor's office. And we've decided to postpone this May 19th rally in order to respect the pardon request process. And we asked everyone else to do the same. And that was following my discussions with governor's council at that May 13th meeting at the hotel.
And the meeting with the governor himself and the governor's council, when did that occur?
I can't remember the exact date. I think there's an email that says it. I want to say it was May 31st or June 1st, something like that. Actually, if you look at Defense 96, I think. It'll tell
Okay,
you.
90. Let's get 96.
Okay, all right, so 96, hold on, can you scroll back up? This is an email from Bob Stevens, who is governor's counsel, to myself, May 30th, 2015. Okay, and this confirms a scheduled meeting with Governor McCrory and Henry McCollum for 8:30 a.m. on Wednesday, June 3rd. And I don't know why it doesn't say this in this email, but Leon Brown came also. He was interviewed separately. It was the same day. And as you can see from the bottom, right before his closing thing, he asked to keep the meeting confidential. And we had previously agreed not to having any media or anyone else because that would not facilitate a productive meeting.
Were you encouraged by this development?
Very encouraged. I knew at that point when the language that was used by governor's council led me to believe that I had at least a fighting chance.
And I take the meeting did occur. Did the meeting occur?
Two meetings occurred. The first one was May the 13th. Before that meeting, I don't know if I talked about this earlier, but I prepared myself for this for months by reading all the case materials, but I guess we can get to that part. But what I had done when I got confirmation of the meeting is I had to prepare the clients to be, it's almost like preparing the client to testify. I knew that 3 attorneys would be questioning each client individually about the facts of the case and about the pardon process and why they felt that they were entitled to this, and about some very hotly contested issues concerning whether they were actually innocent or not. And I had to prepare these clients to answer those questions, or what I anticipated to be the questions, and then to sit with them as they were questioned by these attorneys for, I don't remember exactly how long it was, but I know it was in excess of 1 hour each.
Just to be clear, when you say this was in excess of 1 hour, what meeting you're talking about now?
The meeting with Governor's Council at the Brownstone Hotel.
That was the May 13 meeting.
Right. Then I had to do the same thing and prepare the clients in order to be questioned by the governor himself on that June 3rd, 2015 meeting. Again, same thing. They were brought in separately. They were each questioned independently by Governor McCrory himself. And I had to prepare them for that examination, for lack of a better term.
And did you also have to prepare yourself for the meeting in terms of your personal or your knowledge of the background of the matter in case you had to respond to questions?
I knew that from day one, that if this pardon process was going to proceed, that at some point in time, I would have to advocate on behalf of my clients. And I knew that I would have to know as much and more than my clients. When I received the files from the prior attorneys, I basically barricaded myself in the conference room with, I remember 49 boxes of paper coming in. The boxes of paper looked like they had not been touched in years. And it also resembled a deck of cards that had been shuffled because everything was out of order. So over weeks and weeks and weeks, I went through every single document, reassembled everything, reorganized everything, and read everything at least once, probably twice, just to know that file as cold as I possibly could, because I knew that not only would my clients have to answer questions, I would have to be prepared to answer questions as well.
Now, you've already testified as to the May 13 meeting.
Yes.
And let's go to the meeting on, was it June 3 with the governor?
Yes.
Without saying what anybody else said at the meeting, could you describe what occurred at that meeting?
There's actually two separate meetings because the governor wanted to interview each client separately. So when I was called into the governor's office, it was myself, Mr. Stevens, the governor, and the first person that went in was Henry McCollum. We spent well over an hour answering a number of pointed and very specific questions from the governor.
When you say from the governor, was that from the governor himself or through his counsel?
Mr. Stevens barely spoke in that meeting. It was 100% the governor's questions directed to myself and directed to the client.
And without saying what the questions were, what impression did you have as to the extent of the governor's background knowledge of the matter?
Appeared to be very well briefed, and he knew almost as much about that case as I did. There were certain things that I had to educate the governor about, such as the concept of false confessions, because he was not a lawyer. There were certain principles about legal liability, especially 11th Amendment immunity, that I spoke up about, and that's what the discussion that I had with Mr. Stevens about in front of the governor. But apart from that, the governor knew a lot, much more than I expected about that case.
Did you say it was Mr. McCollum who went first?
That's my recollection, yes.
And did Mr. McCollum at that meeting respond himself to questions?
Many questions. Mr. McCollum spoke about as much as I did.
And without saying what the content was, did he appear to you to answer them appropriately?
Yes, he absolutely answered them appropriately. He gave meaningful answers to legitimate questions.
Now that occurred, let me make sure, you had two separate meetings, one with Mr. McCollum present, one with Mr. Brown.
Yes, after Mr. McCollum, after the governor was finished with whatever questions he had from Mr. McCollum, he invited Mr. Brown to come in, and the two basically switched places.
Okay. Was there ever a point that McCollum and Brown were together with the governor?
Only in the waiting area outside of the governor's office when he just exchanged pleasantries and welcomed. It was Mr. McCollum, Mr. Brown, their sister Geraldine, and myself in that hallway. And the governor just exchanged pleasantries and, said, welcome.
Objection.
Well,
I don't know where this is going. I mean, if he's going to talk about this conversation, that's hearsay.
overruled.
He just welcomed us to the building. That's all.
Okay. But the question was, they were never together with the governor in the formal meeting where he was making these inquiries?
No,
Okay.
nothing of any substance was discussed in that hallway. The substance took place behind closed doors in the governor's private office.
So you described the meeting that Mr. McCollum had.
Yes.
And then when Mr. Brown was brought in, what in general happened? Was it similar to what had gone on with Mr. McCollum?
It was the same thing, except actually Mr. Brown was a lot more talkative than Mr. McCollum. He appeared much more at ease, whereas I was ill at ease because it's an intimidating atmosphere in the governor's office. Mr. Brown just had a fireside chat with the governor.
Same question as to Mr. McCollum. Did his responses seem to you to be appropriate to the questions the governor had directed to him?
The governor asked generally the same questions to Mr. Brown as he asked Mr. McCollum, and got, with some differences because the cases were slightly different, got generally the same answers. Again, with slight variations because the two split off. The two split off in the early 1990s. So they had different experiences when the cases diverged. But other than that, it was the same conversation, and it was the same reasonable responses to legitimate questions.
And once the governor was through with you and Mr. Brown, how did you leave the meeting?
Ill at ease. I did not.
And I'm only talking about your feeling here. Explain what you just said.
I likened it to going into a court hearing and walking out not knowing and not having a very comfortable feeling that you're going to win. And based on the tenor of the questions and the pointed questions of the governor, which is almost like a cross-examination, I did not walk out of there with a warm, fuzzy feeling that, I've got this, or I'm going to win this. I didn't know what was going to be the outcome, and I was not comfortable with that.
How did you find out what the outcome was?
And the governor went on television and made the announcement. I don't know if Mr. Stevens had called me immediately before that or immediately after to tell me. I don't remember what the sequence of events was. It might have been all at the same time, but I think it was 2 days after.
Okay. In any event, you found out either from Mr. Stevens or from the actual announcement that was televised, or both? What is that, your recollection?
Yes.
Okay. Well,
I was in
where were you?
I was in New Orleans visiting my brother-in-law with my wife and children when I got the call. I think I got off the plane. If I remember right, I think I got off the plane and there was a voicemail.
For Mr. Stevens?
I believe so.
All
I
right.
don't remember whether that was immediately before or after, but I had to go. The speech had already been given. I had to go find it online.
Okay. Well, let's look at that. That's defendants exhibit 98.
I announce that on ground pardons of innocence to Henry.
Okay.
I announce that on ground pardons of innocence to Henry.
Identify this. What is it?
I'm sorry. There's something tapping. I can't hear. Go ahead. I'm sorry.
Would you please identify what it is we're looking at here, exhibit 98?
Okay, this is Governor McCrory's press statement given to the television cameras on, I believe it's June the 4th. So I think that was, I think that was the next day.
Okay.
June 4th, 2015, announcing the pardons of innocence.
All right, let's play that.
As with all pardons of innocence, both pardon applications for Mr. McCollum and Leon Brown were thoroughly reviewed by the Office of Executive Clemency, my legal team, and the Clemency Committee. Many individuals were contacted and interviewed, and I met personally with Mr. McCollum and Mr. Brown prior to making this decision. It is difficult for anyone to know for certain what happened the night of Sabrina Bowie's murder. My deepest sympathies go out to the family of Sabrina Bowie for what they have endured. I also know that there are different opinions about this case and who is responsible. This has been a very comprehensive and thoughtful process during the past 9 months. And based upon the available evidence that I have personally reviewed, I am granting pardons of innocence to Henry McCollum and Leon Brown. It is the right thing to do.
Following this announcement, was there formal documents about the pardons?
I couldn't hear what you said.
Following this announcement, were there formal documents about these pardons?
Yes. I think it came through Federal Express, but I've received a delivery at my office of the actual signed, sealed pardons of innocence. And I gave them to Mr. McCollum and Brown in frames so that they could hang them on the wall. I made color copies for myself, saved them. And that's where the pardons of innocence.
Well, let's take a look at those. Exhibit 99. Do you recognize those as the pardons of innocence?
Yes, the first one is for pardons of innocence for Henry Lee McCollum. And I believe the second one was for Leon Brown. As you can see, there's a bunch of other documents attached to it. That's because and these pardons also had to be filed with the court. And the judgments of conviction had to be attached to them as well, so that I guess there was no question as to what they're being pardoned for.
Okay. Did you convey to McCollum and Brown that the pardons had been granted?
I did.
How did you do that?
I called them on the phone.
When did you do that? Where were you?
I believe it was in a hotel in New Orleans.
Were they back home?
Yes, they were in Fayetteville or Eastover.
The house that we looked at?
Yes.
Is that right? Without saying anything that they said to you? what was their reaction?
Relief, happiness, the usual, what you would expect.
Well, what did you do next after the pardons were granted for McCollum and Brown?
I prepared the petitions for the Industrial Commission Award.
And what did you do to prepare those petitions? For that
Again,
petition?
Reviewed the file, assembled a number of exhibits that would support the petition, synthesized the facts, and there were some forms that were required. I found and downloaded those forms, completed them in addition to the actual factual portion of the petition, and filed those with the Industrial Commission, and then followed up requesting docket numbers assigned, so on and so forth.
We could look at Exhibit 100.
Okay. This is the petition for compensation to the Industrial Commission. And as you can see, I attached the written factual portion instead of using just those boxes because it wouldn't have been big enough.
And when was that file?
It's dated June 19th. I don't think it was filed until after that because I think I had to send it to the clients to be signed and notarized. If you go to the next page, I think it'll say, I know, I'm sorry. I take that back. I'm sorry. I was confused. I believe it was filed on June 19th. I think I prepared this, sent it to the clients. They had it notarized, sent back to me. And then I filed it because I needed a like a sworn verification form or something. Yeah, okay. I dated it June 19th, 2015. That's why I left the date thing open so I could handwrite on the date.
And between filing the petition, how long was it before there was an actual hearing before the Industrial Commission on the petition?
I think the Industrial Hearing Commission was on September 2nd, 2015, if I remember correctly. If you show me if there's transcripts, it'll have the specific date on there.
We'll get to that. What I want to ask you now is between the filing of that petition and the hearing, did some sort of issue arise regarding Leon Brown?
Yes, unfortunately.
What happened?
Brown stopped taking his medication, and I think the term is decompensation. When a person stops taking psych meds, the blood levels of the medication decreases and their mental condition degrades. He started, to make matters worse, he was diabetic and he was not hydrating properly and he was not getting proper nutrition. And he was hospitalized several times due to these conditions. And he devolved to the point where his sister Geraldine could not handle it anymore and asked me to consider a guardianship petition.
And did you prepare such a petition?
I did. After I looked into the matter myself and I determined that Leon was no longer coherent, and I was genuinely concerned that he might get super sick or even worse, I petitioned the Cumberland County Superior Court for guardianship.
And let's go to Exhibit 28. And it's Exhibit 28. Is this the petition?
This is.
Okay. And when was this filed?
I remember the exact date. If we get to the bottom, I think it was August 14th, 2015.
Okay.
Sounds about right.
Okay. Okay. And do you recall some previous testimony about this petition involving Mr. McCollum?
Yes,
Okay.
it was an error.
Okay, well, explain that.
I don't know why it was included. I think one of the law students was helping me draft this. I don't remember exactly how it ended up that Henry McCollum's name was included in this document, but it was mistakenly escaped my attention. It was never my intent to include any details about Henry McCollum in a petition for Leon Brown. It was a simple mistake that I made.
If you had made those statements intentionally, would you also have petitioned for Mr. McCollum?
If I had made those statements intentionally, I would have petitioned for Mr. McCollum, but I did not petition for Mr. McCollum because I did not believe that he would need a guardian then. I do not believe he needs a guardian now.
Well, what happened with that guardianship petition?
It was set for a hearing, I believe on September 1st, 2015. Before that, as is the normal procedure, a guardian ad litem was assigned to represent Leon Brown's interests in the guardianship proceeding.
Who was that? Who was the guardian ad litem?
I cannot remember her name. I can remember her face, but I believe there's an exhibit that has her answer in there.
Well, let's hold on. Let's go ahead and look at that. Exhibit 30.
Okay. I think her name was Sharon Keyes, Keyes.
Oh, it should be at the end of the document.
Yes, Sharon A. Keyes, guardian ad litem.
Was Ms. Keyes an attorney?
Yes.
Okay. Did she indicate agreement with the petition?
She did, and she appeared at the guardianship hearing, which I believe was September 1st, 2015, and went on record as saying she agreed with it and agreed with the choice of Geraldine Brown Ransom as the guardian for Mr. Brown.
Did you attend that hearing?
I did. I was the petitioner.
Was there any consideration to appoint someone else as the guardian other than Geraldine Brown?
I had considered one other person, which was Henry McCollum's half-sister from his father's side. Mr. McCollum shared a mother with Mr. Brown and Mrs. Ransom. So his other half-sister, his name was Latasha Hicks, Latosha, I think. That was a name that was pitched to me as a potential guardian. There were a couple of problems with that choice. She lived in Raleigh, whereas Leon lived in Fayetteville. She had no familiar relationship with Leon Brown. She really didn't know Leon Brown at all. And Geraldine Brown Ransom was the closest living relative to Leon Brown and had known him his whole life. That was a logical choice to me.
And did the clerk accept Geraldine Brown Ransom as the most appropriate person to be appointed guardian?
Yes, and I believe I put in the petition Mrs. Ransom's husband, David Ransom, as an alternate guardian, just in case Geraldine could not serve. But both the guardian ad litem and the court agreed that Geraldine Brown Ransom was the most logical choice as his closest living full relative.
And was that appointment to be a general guardian?
Yes, it was guardian of both the person and his property.
Or the estate.
The estate.
They call it here. Now, in connection with that petition, had you intended to set up some kind of trust for him?
That was my intent. I wanted to set up a trust that would earn income because I told one of the things that I explained to the clients is there is no guarantee you will win a civil suit. The money that you get from the Industrial Commission may be the only money you ever receive as compensation for what happened to you. And I wanted a trust to be set up so that there would be, for two reasons. Number one, it would generate some income. And number two, it was my intent that with a trust, there's a lot more oversight. The trustee watches the money, the guardian watches the trust, and the court has ultimate authority over everybody to make sure that the money's being invested wisely, spent wisely, et cetera.
And let's look at Defendant's Exhibit 29.
This is the trust that I had set, that I had drafted for Leon Brown's benefit that was going to be, was supposed to be funded by Geraldine Brown Ransom. And I'd contacted a company that in Florida that specialized in these kinds of trusts. And the reason why I wanted to domicile the trust in Florida is because Florida does not have a state income tax. So the trust would be free from a state income tax.
Was this document presented to the court as part of the guardianship proceeding?
It was presented in the exhibits, I believe, to the petition. And if memory serves me, I did talk about, there was discussion about it on the record during the guardianship hearing.
And as a result of that hearing, was it contemplated that that trust would be set up and funded?
That was my understanding. It was never, I don't think it was explicitly stated, but it was implicitly stated. And as events would later unfold, there was someone had a question about that. Well, I'll put it to you that way. Not me, but someone else.
Okay. And we'll get to this in more detail later, but was that trust ever funded?
It was not.
And again, we're going chronological order. We'll come back to that. Now, about this, well, let's Exhibit 32. I don't want to go through all this. I just want it identified for the record. Does this appear to be the transcript of the incompetency hearing you've been testifying about?
Yes.
All right. Other than what you testified to, is there anything you want to particularly point out in the transcript itself, or is it sufficient simply to identify at this point?
I'm sure the panel members could read it if they wanted to. And
okay. Let's go to Exhibit 33. And you recognize this?
Yes, this is the order appointing Geraldine Brown as guardian for Leon Brown.
And that was that a result of the hearing?
Yes.
Was that order entered that day?
Yes. I had to go downstairs to the clerk's office, and I had to wait around for the order to be processed because I wanted a certified copy.
Did you explain to Geraldine Brown Ransom what her responsibilities and duties would be as a guardian for Leon Brown?
Several times. I explained very clearly to Geraldine that a guardian, you will have to account for every single penny spent. You cannot spend money on yourself. You have to spend it on Leon's well-being, number one. Number two, you're going to have to keep records and receipts, and you have to be always ready to explain to the court why you spent this money and how you spent it. Number three, you have to make sure that he gets his medication and he is well taken care of. And that was one of the things that was discussed during the competency hearing, is forcing him to take medication. There was some discussion about that. They said, you will make decisions for him as if he were your child and he were an underage child. And I was assured multiple times it was going to be no problem.
Mr. Williamson, was this a guardian of the estate, a general guardian?
General guardian, I believe he testified too. Is that specified in the order? I assume
Yes,
so.
I
the
can't
box
see the
is
whole
checked.
order, so.
Okay.
General guardian. If you go up, there's a box that's checked. Yep, see?
Yes.
All right, thank
There
you.
you see, general guardian.
And I also explained, if you mess up, you could get yourself in serious legal trouble. You could go to jail, you could get sued, all of those bad things can happen to you.
Right. Now, did a hearing before the Industrial Commission happen shortly thereafter?
Yes, I believe is the next day.
You had already. What did you do to prepare for that hearing?
I reviewed the petition that I'd filed. I reviewed all the documents. I also assembled a number of exhibits that I wanted to introduce because nobody had called me ahead of time to tell me that this was not going to be contested from the Attorney General's office. I did not know what I was walking into. I did not know whether someone was going to come and argue about the calculation, about anything. I had no idea. So I prepared myself as if this was going to be a contested hearing because I simply did not know. Reviewed all the documents, prepared the exhibits, and then showed up to the hearing on the day of.
Now, you were here, when Mr. Sneed, I believe it was, testified, who handled that case from the Attorney General's office. Did you have any prior notification or that Mr. Sneed was going to appear from the Attorney General's office at that hearing?
No, I thought it was actually going to be someone else because when I received the notice of hearing from Mr. Donovan, who I believe was I think his name was Brad Donovan from the Industrial Commission. It was there was another attorney, a different Attorney General CC'd on that email with the notice of hearing, and I remember reaching out to that person a couple of times and never got a call back. So when Mr. Sneed came in, it was, just sort of a surprise. I didn't know I had no advance notice that he would be showing up. I thought it was going to be someone else.
And when Mr. Sneed showed up, there was was it Mr. Donovan who was the commissioner?
Yes.
Well, what happened?
Mr. Sneed showed up, I don't want to say late, but I try to be early to those kinds of hearings, especially when it's carrying a large box of paper. So I had a very brief conversation with Mr. Donovan, followed a telephone conversation I'd had with him when he reached out to me at one point a couple of weeks earlier. Had a brief conversation with him before, and then Mr. Sneed walked in. Mr. Donovan said, "Okay, good, come on over here. Let's talk." We spoke again, the three of us briefly, and then went on the record.
And what happened when you went on the record?
The state did not oppose, and the commission granted the full statutory award.
And the actual transcript of that hearing is Exhibit 34. If you just pull that up for identification. Excuse me, 101. Okay. You recognized this is Exhibit 101?
Yes, that is the transcript of the Industrial Commission hearing.
All right. And as a result of the Industrial Commission hearing, were each of Brown and McCollum awarded $750,000 each?
Yes.
did you subsequently have distribute the money, have a settlement statement with them as to how the money was allocated?
I did. The meeting took place in my office in Orlando. They had planned a Disney trip to celebrate the win, number one, and also to come down to collect their award. And I invited them to the office. They came in and everything, the whole breakdown was committed to writing.
Did you provide a settlement statement with the breakdown?
I did.
Go to Defense Exhibit 23.
Okay, this is the first 4 pages of that settlement statement. And as you can see, I broke it down to each one, Henry McCollum and Leon Brown in writing.
What I want to ask you about is, we're looking there, there's recovery less $10,000. What does that represent?
When I was going through the breakdown with them, I asked them if they wanted to, before I finalized these numbers, I asked them, do you want to amend our agreement and put $10,000 in each to pay for some expenses that will arise in the future? Do you want to get some, for lack of a better term, some skin in the game? And they both said yes, no
Objection.
problem.
Objection sustained.
All right. Well, did you proceed with that understanding, not what they said to you?
That was the I don't want to say the offer, but that was the idea that I asked them about, and ultimately they agreed to it.
Objection.
Objection sustained.
Okay. Don't say what they agreed to, but did you proceed on that basis?
Yes, I proceeded on that basis.
Now, once you got the settlement from, or the money from the Industrial Commission award, did you also proceed on the civil lawsuit front?
Before I got the money on the Industrial Commission award, I filed the lawsuit in federal court, and that was filed on August 31st, 2015 in the Eastern District of North Carolina.
And what did you do to prepare that complaint?
Again, for I don't know what number time, I went through the file that I had, and I wanted to make sure that I had the facts as correct as humanly possible in the complaint. Part of the complaint was also advocacy, so I wanted to word certain facts a certain way to strengthen my case or strengthen my claims. I went through the complaint, I drafted the complaint, and it was filed, and then it had to be served on the defendants.
Had you waited for some reason to file the civil complaint until the Industrial Commission matter was resolved?
I did, because I knew that the media was going to be at the Industrial Commission hearing, and I wanted to simultaneously make the announcement that not only have we come this far, we've also filed the civil complaint, because I was looking for some positive media attention on the lawsuit as well.
And did that happen?
Did. The media came and did a piece on it. I came with a filed copy of the complaint. I handed it to the media, and that made its way into the news, and it created the splash that I wanted, so to speak.
Now, after what you just talked about, that is the Industrial Commission money coming in, the lawsuit being filed, did there arise any difficulty with Ms. Brown's performance under the general guardianship.
Yes. That started right after the money was distributed. The bulk of the Industrial Commission award remained in my trust account, pending funding of this this trust for Leon. And shortly after the money made it into my account, Ms. Ransom wanted me to cut a check to her for the entire amount directly, and I refused.
Was there some, did you have some interaction with an attorney named Steve O'Connor about this?
Yes. After I refused to give Geraldine the money directly, I was next contacted by an attorney named Stephen O'Connor.
And I believe we have some exhibits about that.
Yes.
We'll next go to Exhibit 33, an email from Mr. O'Connor.
So this is an email that I received from Mr. O'Connor on Tuesday, November 17th at 12:25 p.m. And Mr. O'Connor is notifying me in this attached letter that he's been retained to represent Geraldine Brown Ransom in the guardianship in Cumberland County proceedings only.
And he,
yes, defense number 34 is the letter that was attached.
we're now looking at 34. That was the letter referenced in the email.
Yes, that is the
Okay.
letter that was attached to that email, that he's been retained to represent her with guardianship duties regarding sums received or to be received.
And what is significant about this letter?
If you go down a little bit towards the bottom, you could stop. Geraldine Brown does not want to now fund the trust that I believe the court had ordered her to do.
Was she to be the trustee under that trust? Who was to be the trustee?
I can't remember the name. It's a CPA firm that does that handles trusts of that nature. They were the trustee. Leon Brown would have, or the estate of Leon Brown would have been the beneficiary.
Okay. Go ahead. I was asking you about the significance of this letter.
Okay, and she wants the money sent directly to a guardianship bank account she set up in Fayetteville. In other words, she wants the money in her own name.
Did that cause concern for you?
Yes. I
What was
felt that was violating the court's order. And as you can see in the next subsequent group of communications that I had with Mr. O'Connor,
That
that's
would be
exactly-
Exhibit 35. Let's go to that.
sorry, it's not 35. This is a letter from Mr. O'Connor to me on December 10th.
Is this 36?
Yes, defense exhibit
No,
number
we're now at
36.
36. Okay. Oh, okay. All right. What's the significance of this letter?
He's asking for ledger accounts. He wanted the what I believe to be the settlement statement that we'd seen earlier. And then he wants to provide wire instructions for me to wire the amount left in trust directly to the amount directly to Geraldine's account. And
You say Geraldine's account, her guardianship account or personal
Yes.
account? What do you mean?
if you go, he said a guardianship account, but not a trust. It was not a trust. It was a bank account. And if you go down to the next page, right there, he claims to have spoken with an official from the Cumberland County's the Cumberland County Court's office, and Ms. Fullerton said that at no time is ever. He's making the claim that there was no requirement that a trust be required here, and that was because that was in response to some conversations we'd had where where I told him, my understanding is that this money has to go into a trust. It cannot go into her direct account. There was an argument over that. He claimed that he spoke to the court, and the court said, no, it doesn't have to go into an account. But as you can see in later communications, he turned out to be wrong.
All right, we just looked at 36. Let's go to 152, I believe.
This is my response to Mr. O'Connor on December 11th, providing him the information about what is left in the account. And if you scroll down, you'll see me telling him it's my recollection that the court did in fact require the money to be paid into the trust, and that I ordered the CD of the audio recording from the September 1st, 2015 proceedings. And I told him, once I review those proceedings, once I get back to you, and I offered to transfer the $325,000 left in my trust account directly to his escrow account pending final resolution from the court and resolution of this outstanding dispute.
Was Mr. O'Connor at the guardianship hearing?
No,
Did it appear that he was retained after that?
that's exactly what his letter said.
Believe anything else about 152?
I just offered to write him a check because I wanted to avoid a wire fee.
All right. Let's next go. I believe it's Defendant's Exhibit 37. Is that his response to that letter?
Yes, and he's asking to take custody of the $325,000 from my trust account into his escrow. I'm sorry, from my escrow account into his escrow account. I guess we use the word trust and escrow interchangeably, but
you say escrow account is, you mean trust? We would understand that as a trust account.
it's called different things in different states. Sometimes I get the terms confused depending on where I am.
But you're not making a distinction in this regard, but between what you label it as.
Right.
It's the same thing.
It's the same thing.
All right.
IOLTA, Iola, wherever you want, whatever you want to call it.
Anything else about this particular letter from Mr. O'Connor you want to draw the panel's
Yes.
attention to?
He acknowledges that I'm not authorizing him to transfer the money to Leon Brown's guardianship bank account because my position was the court requires this money to be paid into a trust, not into a regular bank account where Geraldine could withdraw at her will. That was the big point of contention between the two of us. He kept asking me for authorization, and as you can see in some emails, do I have your authorization? Do I have your authorization? And I kept saying, no, you do not.
Okay. Well, let's go to the next exhibit. I believe that's 30A.
So this is a letter that I wrote to Mr. O'Connor on December 21st with a check to be held in escrow for the benefit of Leon Brown. And I said, I trust you will distribute the funds in accordance with the requirements of the Cumberland County Court in the guardianship proceeding.
Right. Did you actually make that transfer to his escrow account?
I did.
Okay. Well, let's go to Exhibit 39.
Okay, and this is my email to Mr. O'Connor on December 22nd, 2015 at 11:38 a.m. And this is me telling him, I don't want to violate any court orders. This is my recollection of what happened in court. And, if the court tells you it's fine to distribute it, then that's fine. If not, then, then don't. And I told him I'm getting a CD of the hearing. I want to have it transcribed because I wanted to be sure that what I was saying was correct.
Did you in fact do that?
I did.
And were you satisfied that what you said was correct?
Yes, and if you, I think it's probably the next email that I sent to him. Or the next string of emails, which is defense exhibit number 40.
Let's
I
look
believe
at
that's
that.
exactly what I said.
Well, let's look at that.
I think you gotta go all the
This
way
is a
down.
string of emails.
Yes, if you go all the way down, I think it starts with January 4th.
Is it
2016.
reverse chronological order here? Okay.
Okay, so the email from at the bottom of page 3, you see the email on Monday, January 4th, 2016 at 2:14 p.m. Mr. O'Connor emails me and is looking, it appeared to be looking for my approval, my consent for him to deposit the $325,000 that he's received into Geraldine Brown Ransom's guardianship bank account rather than a trust. If you scroll up, I'm sure my response to him is up next. Okay, and yes, my response to him was Tuesday, January 19th, 2016 at 5:27 p.m. This is my response telling him that I finally received the CD from the Cumberland County court. I listened to the audio recording and I told him it is your ethical obligation to disperse the money in accordance with the court's order, and that's all I can tell you.
Okay. Is there additional emails on this string?
Yes, if you go back
a little
up.
more.
And he responds to me on Wednesday, January 20th of 2016 at 8:42 a.m. And again, asking for my approval to distribute the money directly to the guardian, Geraldine Brown. And my response to him at 3:38 p.m. the same day was, you need to ask, this is a question you need to ask the court, not me.
Was that your last communication with Mr. O'Connor?
My memory, yes.
You have personal knowledge of what was done with those funds that were now in his trust account?
I don't know what ultimately became of them now.
All right. Did it come to your attention later that there was some action taken by the court regarding Geraldine Brown Ransom's guardianship?
Yes.
How did that come to your attention?
Geraldine had called me at one point, and I won't say what she said, but she informed me that someone else, and the way she made it sound, I was led to believe that someone in the court was looking at Leon Brown's money. That's what that was the information that came to me, and that it was a court official that was looking into something having to do with his money. And at that point, I realized something was up, but she never told me that she'd been removed as guardian of the estate. I didn't know that for sure until later.
But that aroused your suspicion?
It aroused my suspicion somewhat, but when she was talking, she wasn't making much sense. I can offer an opinion as to why, but I don't know.
Well, did you do any investigation of the situation at that point?
At that point, no, because she told me she was still guardian.
Okay. At some point, did you get a notification that she was not?
At one point, I found out that she was removed as guardian of the estate, which was when I got a letter, or I don't know if it was preceded by a phone call.
Well, let's bring that up. That's exhibit 41 from Mr. Gilliam.
Yes.
Let's look at that.
On May the 4th, 2016, Dwayne Gilliam, Gilliam, of the Gilliam Law Firm in Fayetteville, faxed me a letter informing me that he was now successor guardian of the estate for Leon Brown on February 26th, 2016.
But the letter is dated when?
May 11th.
Okay. Had you had any, well, going back, your last communication with Mr. O'Connor was in January?
To my recollection, yes. I don't think I ever heard from him after that last email that I sent him.
Okay. And so it's 4 months later, you get this letter from Mr. Gillian. Is that your first notification that there had been a change in status from Ms. Geraldine Brown Ransom?
This was the first time I knew for sure that she'd been removed as guardian of anything. At that point, she was still guardian of the person.
Right. And I believe most of us know the difference, but what is your understanding between guardian of the person and guardian of the estate?
My understanding is that a guardian of the person can make decisions about a person's well-being, health decisions, anything other than financial decisions, when to go to bed, what to eat, that sort of thing.
Okay. So what did you do when you got this letter from Mr. Gillian? Did you contact him?
Called him on the phone. Either that day or the next day.
And did you write a letter to him shortly thereafter, after receiving this letter, Exhibit 41, dated May 11th?
I did. At his request, I wrote a letter a day or two after that.
Okay, well, and let's look at that. That's Exhibit 42.
And at his request, I provided him with a lot of information about the case, what was going on, and informed him that now that I knew that he was guardian of the estate, that I would need to substitute him in as a plaintiff in the pending federal lawsuit.
In the pending federal lawsuit, was it Geraldine it was in her name?
Yes, when I commenced the lawsuit, Geraldine had not been appointed guardian at that point. Not long after I commenced the lawsuit, I don't remember exactly when it was, I moved to substitute Geraldine in place of Leon in the federal lawsuit, because now she was guardian, so she naturally had to be the party, not Leon. And then after I found out that Mr. Gillum had been appointed as guardian of the estate, now I had to move to substitute him in place of Geraldine Brown Ransom.
And did you do that?
I did.
Was there any issue about that?
No, not at all.
Okay, in this letter, did you give Mr. Gillian some background about what was generally going on with the lawsuit and so forth?
Yes. I had to provide him with information about the pending suit because he requested that.
And I see, without going into a lot of detail, is it fair to call this something like a status report to him, bring him up to speed?
Yes.
Now, after that, did you find that there was some additional difficulty with Geraldine?
Yes.
Let's go to Defense Exhibit 168.
This is an order removing Geraldine Brown Ransom as guardian of the person and appointing the, I believe it was the Cumberland County Department of Social Services as guardian of the person. It's also an order finding Geraldine Brown in contempt of court, or at least it references a finding of Geraldine Brown in contempt of court because she apparently had lied to the court about taking out one additional loan of $25,000 against Leon Brown's federal suit and attempting to take out a second loan of $25,000 against Leon Brown's federal suit while having no authority to do so.
How did you receive this order?
The bar turned it over in discovery.
Had you seen this order before then?
I had not seen the order to my knowledge. I was informed about the basics of the order, but I don't think I'd seen the order prior to that.
When you said you were informed about the basics, was that from Mr. Gillian?
Part of it came from Mr. Gillum, and then eventually Geraldine informed me that she had been thrown in jail as a result of the contempt. That came in well after.
Mr. Williamson, let's take our lunch break at this time. It's about 12:15. We'll try to reconvene at we'll be taking an hour and 15 minutes, 1:30.
Yes. Thank you.
You may step down, Mr. Megaro.
Mr. Megaro, can you still hear me fine?
Yes, thank you.
All right, I want to get back to the lawsuit. At the time we're talking about, we're in early 2016, ending in May. Is the lawsuit going on at that point?
Yes, at that point in time, the stage of the lawsuit is discovery is in full swing. We are, I don't remember exactly when, but we're scheduling depositions, if not starting to take depositions. Discovery requests are going back and forth, and some discovery is starting to come in.
And did you, what was the sequence of discovery just in general in that civil lawsuit?
And I think every federal civil lawsuit, Rule 26 of the Federal Rules of Civil Procedure require voluntary initial disclosures by each party to the other party, where certain things have to be turned over without any request. I don't remember the exact sequence of events when initial Rule 26 disclosures were provided, but I know that if they were not provided immediately by me, they were provided shortly after the lawsuit commenced. There was also a scheduling order where the parties have to confer with the lawyers, have to confer with each other and agree to a schedule. That had been accomplished, I believe. And I also believe that there had been a motion to dismiss filed by the defendants that I had to oppose and ultimately successfully oppose mostly.
And when you reached, you had a mediation at some point.
Yes, the court had ordered the parties to participate in a mediation. I prepared for that mediation, and then that mediation did last for a total of 8 or 9 hours. Did not produce a settlement.
At the time of the mediation, what was the status of discovery? Had you done depositions at that point?
I know that most of the depositions probably had been done by the point of, if I recall correctly, the mediation was in December of 2016. I know there had been several depositions done at that point. I don't remember which ones, because I know there were a couple that were done in early 2017.
Was the mediation done before summary judgment motions were filed?
It was.
And did you say that there was no no settlement or partial settlement as a result of the mediation?
No, the mediation was unsuccessful in producing a settlement, but it did produce some initial, it did produce some fruitful discussions that ultimately did lead to a settlement with the town of Red Springs.
And just so we're clear, who were the party defendants to the civil suit?
When I initially commenced the lawsuit, it was against several defendants, and I broke them into 3 groups. One I called the state defendants, one I called the county defendants, and one I called the town defendants, because Two of the defendants were State Bureau of Investigation officers, or former retired State Bureau of Investigation officers. Two of them were former deputy sheriffs, and one of the parties, Kenneth Seeley, was actually deputy sheriff in 1983 during the arrest and questioning of McCollum and Brown, had actually been the elected sheriff of Robeson County at the time that I commenced the lawsuit. So he was named personally, individually, and in his official capacity as the successor of the sheriff. And the last two defendants was the entity of the town of Red Springs itself. And by that point in time, the chief of the Red Springs Police had passed away. So he named his estate as the, ultimately it was his estate that was named as a defendant in that lawsuit too. So there's three: state, county, town.
How many lawyers were there total, if you recall, representing the various defendants?
There were two deputy attorney generals representing the two state defendants. There were, I believe, two lawyers from a law firm representing the county defendants, but the town of Red Springs had at least three different firms and multiple lawyers from each firm representing, I guess, differing interests. Two of the law firms had been hired by the insurance carriers, and one, which was Neil Yarborough, Y-A-R-B-O-R-O-U-G-H, is that right?
I believe so.
Okay. Neil Yarborough's office and Tim Smith, who was his associate, were the actual town attorneys, so they were involved as well. But the town of Red Springs by far had the largest number of lawyers on that firm, on that side.
Now, eventually, there were discussions that ultimately led to a partial settlement with Red Springs. That is a partial settlement of the lawsuit, but a full settlement with Red Springs. Is that correct?
That's correct. At the mediation, not only were all the lawyers there, but the representatives from the insurance carriers themselves came. And I think separate counsel representing the insurance carriers came to that mediation. And
when you say separate counsel for the carriers, were these attorneys who had appeared in the case or simply appeared at the mediation on behalf of, say, insurance carriers?
Simply, I believe they're in-house counsel that appeared on behalf of the insurance carriers to represent the carrier's interest at the mediation. Sorry, I lost myself. What was the original question? I forgot.
I think you just answered it. I'll ask another question.
Okay.
So what started, well, what happened first to open serious settlement discussions with the town of Red Springs?
By that point in time, I had conducted a fair amount of investigation into the insurance policies. We had the town of Red Springs turn over a number of policies because I'd requested a range. I think the first year I requested was probably either 1980 or 1981, and they requested all of the policies up until the present time because I wanted to see the range of coverage that occurred over the years. There was several hundred pages of insurance policies that I believe the town of Red Springs ended up supplementing with additional pages later.
Let me interrupt you there. Come back to that. When you said that they turned it over, was that in response to discovery requests, or did they do that voluntarily?
I believe it was both. I believe most of the insurance policies came through initial Rule 26 disclosures, and I believe I'm reasonably certain I requested additional information in my regular discovery demands as well. But I do remember there were two dumps, for lack of a better term, of insurance information on us, and there was a lot to go through. In addition, I had researched the town's budget online, which is posted on the town's website. We were able to view their finances, and I had personally visited the town several times myself in the course of investigating various different leads and witnesses and so on and so forth.
You were here, of course, to hear Mr. Housecott's testimony regarding his review of those policies. Is his recollection similar to yours that he did that?
Yes, that was one of the things I specifically asked him to do, was look through those policies and give me a summary. And later I did it myself as well, just not because I don't trust him, but I wanted to see for myself what exactly the limits were. And that's when we discovered there appeared to be a gap for 1983, which was consequently the year that Mr. McCollum and Mr. Brown were arrested and initially charged. If there was a policy in effect, which we did not have, then judging by the policy limits for the years prior and the years immediately after, it was a cap of $250,000 per incident and total occurrence. And then the other issue that we looked at was whether it would cover intentional torts, such as a 1983 malicious prosecution, that type of thing. And we concluded that it did not. The other thing that we looked at was
So
whether
you concluded it did not. Was there an exclusion for that?
there were policy exclusions, yes. And the other thing that we looked at was whether there could be insurance coverage in the future, but all of the policies had an effective date of, it went year to year, and anything occurring prior to that effective date was contained within that exclusion, so it would not cover anything from the years prior.
And the coverage for the years prior to 83 and post 83, around that time, what was the dollar limit of coverage that you saw?
250,000.
Was it the same company or companies during those years as insurance carriers?
I believe through the 80s, it was if memory serves me, I believe it was the same carrier, and then at one point they switched. And then as you get further along, the policy limits get higher as, I guess, as the cost of living and inflation gets higher, whatever. But I believe it was the same carrier for the first several years, and I don't remember off the top of my head.
Would you continue with your narrative of how it came about that there came to be a meeting of the minds for a potential settlement on the town of Red Springs claim?
Certainly. When I started the lawsuit, my initial review of the documents, my initial impressions were that the town of Red Springs, through the chief, whose name was Luther Hagens, was much more culpable than it ultimately turned out. As I did the depositions and deposed several of the named defendants, some of which were deposed for 7 to 8 hours each, and as I got more and more information from the defendants, uncovered more and more information, ultimately from the Innocence Inquiry Commission, I realized that the town of Red Springs, in my opinion, had little to no liability. The sequence of events for Mr. McCollum and Mr. Brown's arrest were that when Mr. McCollum was brought in first, after the investigation had been already 2 days old into the death of Sabrina Bowie, B-U-I-E. By that point in time, it was no longer the town of Red Springs investigation. The investigation had been taken over by the sheriff and the State Bureau of Investigation. The primary actors in the interrogation of Mr. McCollum and Mr. Brown were a State Bureau of Investigation detective and Detective Kenneth Seeley from the sheriff's office. Chief Luther Hagens simply allowed the SBI and the sheriff, or the deputy sheriffs, to use the town of Red Springs Police Department as a venue, and was present in the room for part of the interrogations, but did not himself participate in the interrogations at all. Once I realized that, after doing extensive discovery, I believed that the town of Red Springs had little, if any, liability whatsoever. When I combine that with what I had found with the insurance or the lack thereof, and the town's inability to pay what I believed was a significant judgment, and statements that had been made by Mr. Yarborough where he floated the idea of a municipal bankruptcy.
Objection.
Yeah, sustained.
Did you have any consideration for some reason from somewhere that there might be a municipal bankruptcy involved?
I was concerned that a municipal bankruptcy would be filed if I would prevail against the town of Red Springs. And that would have frustrated an ability to collect on a judgment, number one. Number two, it would have tied up the case in extensive litigation in a bankruptcy setting for I don't even know how long after that. Another concern that I had was Dan Hartzog, Hartzog, who was the lead attorney for the town of Red Springs. When, as a trial attorney, when you watch another lawyer fall into a cadence or rhythm of cross-examination, you watch how they handle a witness, you know very quickly who's very capable and who's not as capable. As I spent probably close to 100 hours in depositions with the other defense lawyers, I saw Mr. Hartzog in action and saw how he was handling witnesses and how he was picking away at our case, highlighting problems in our case, impacting witness credibility. And I was highly concerned that if I were to go to trial with a defense lawyer like that on the other side, that would give me significant problems. And I also watched the other defense counsel, for lack of a better term, ride Mr. Hartzog's coattails at the depositions. So one of the things that I considered was, if this case were to go to trial, who would be sitting on the other side?
Did you at some point get a proposal for settlement that you had to consider?
Yes. You have to keep in mind the town of Red Springs was defending with a reservation of rights. So that was a consideration as well. When I received a settlement offer from the town of Red Springs, I discussed it with Mr. Gillum, Mr. McCollum, and Mr. McCollum's fiance. He wanted her to be a part of the discussions.
All right.
And I went through those same considerations with them right here in Raleigh. We were out to dinner at the Pit, at the restaurant on Davie Street. And I went through all those considerations with all three of those parties at that dinner. And in my opinion, I believed a settlement with the town of Red Springs was the best thing to do to get them out of the case, to get some money for my clients, and to eliminate the possibility that having them in the case would do damage to my case against the remaining defendants. And I memorialized that in an email.
Well, let's look at that. That's defense exhibit number 12.
Okay. Yes.
What are we looking at here?
Okay. This is an email that I sent to Mr. Gillum on February 22nd, 2017 at 10:27 p.m. This followed the dinner meeting. I'm reasonably certain it was sent the same night because I remember going back to the hotel and writing
Before
this.
you talk about that, just again, identify at this point, what was the capacity Mr. Gillum was in?
Okay. Mr. Gillum at that point, I don't remember the exact date that he was substituted as a plaintiff, but he had already been assigned as guardian of Leon Brown's estate, and he had already been substituted as a plaintiff in the federal lawsuit for quite a while at that point. I'd been working with Mr. Gillum, but he asked me for a written synopsis of what we had discussed, and I provided this to him, which set forth my reasons for the settlement with Red Springs. There were a couple of other considerations that were present in that consideration to settle, but the main ones are the ones I just described to you. The rest of them are set forth here.
What you testified to earlier is it all pretty much also contained in this email?
Yes, the email contains, I think, a couple of other, if you scroll down. Bear with me a moment, I'm sorry. Scroll down, please. Keep going. Okay, yes, there was another consideration, which was at that point, the only defendants that had provided any sort of expert witness disclosure were the town of Red Springs. And I felt that it was a reasonable strategy. If we got them out of the case, there would be no expert to testify on the defense side, which would, in my opinion, make it much easier for me to prove my case without an expert on the other side to prove that to attempt to prove that everything the defendants did was above board.
At this point, according to any scheduling order, had the time to designate experts passed?
Yes.
Now, after informing Mr. Gillum and other clients of this situation, then what happened?
Mr. Gillum and Mr. McCollum both signed the requisite releases to effectuate the settlement with the town of Red Springs.
When you say releases, what were those?
Those are your general releases that that are required in a civil case to effectuate a settlement release defendants from future liability.
And was this settlement understanding subject to the approval of the court?
Yes, and the reason being is that Leon Brown had already been assigned a guardian, so the local rule required that anytime there was an incompetent in the case, it had to be approved by the court prior to finalization.
Now, at some point, there was a hearing for the purpose of approving or not that settlement. Is that correct?
Yes, at one point I filed a motion for approval of the settlement. I don't remember exactly when that was. But that motion was filed and a hearing was set for May the 5th, 2017.
Let me ask you, when you filed that motion for the settlement with Red Springs, had summary judgment motions been filed?
I don't remember the exact sequence of events. I do remember that the deadline for summary judgment motions was sometime in March of 2017. And one of the things I wanted to accomplish was make sure that the town of Red Springs did not file a motion for summary judgment because I was worried that they might get it granted. I filed a motion for summary judgment in March of, I filed two motions. I filed a motion for sanctions against the state defendants for what I believed was deliberate hiding of evidence that was very favorable to the McCollum and Brown case. And on the heels of that, before the defendants filed their motion for summary judgment, I filed my motion for summary judgment, which with the exhibits and all the attachments totaled 12,800 pages.
Well, let's take a look at those motions. First, the motion for discovery sanctions, number 147.
Okay. If you scroll down to the bottom of the page, there might be a stamp. No, I'm sorry. This is not the filed version, but this is the version that was filed. This is just not the stamped copy. This was the motion I filed against the defendants for hiding evidence. I correct myself. I did file it against all defendants.
Including Red Springs?
No, not including Red Springs. They did not hide evidence from me.
How much work went into preparing that motion?
I can't even estimate the number of hours. This is 235 pages with exhibits. It's extensive. I had to comb through thousands of pages to find parts that would help my motion, parts that would support my arguments. I can't even tell you how many hours it took.
Well, let's look at the motion for summary judgment. That's number 148.
Okay, this is the 12,800 page motion that synthesized 30 something years of litigation, thousands of pages of depositions. I think if I remember right, my statement of material facts was somewhere in the neighborhood of 40 or 50 pages. How long did this take me? I don't know. Weeks.
And were other folks in the office also helping with that effort?
I made everybody in the office stop what they were doing, drop everything, and proofread, double check and cross check against all of my exhibits.
Did the defendants also file cross motions for summary judgment?
Yes, I filed my motions first. They filed extensive motions for summary judgment. And I also had to oppose those motions, which again required me to respond to each individual fact that they had alleged and go through each of their motions and respond very specifically to each one.
Was there a hearing on those motions or was it heard on the written materials?
Eventually, there was a hearing on the motion, but that did not happen until I think it was January 28th, 2018, because before that, the case took 2 left turns with the guardianship issue for Henry McCollum.
But by the time there was a hearing, were you still counsel of record in the case?
I was.
What was the ultimate result of the summary judgment hearing?
I believe it was March the 1st. Judge Boyle.
March the 1st of what
2018,
year?
sorry. I believe it was March 1st, 2018. Judge Boyle denied both motions for summary judgment on the grounds that I had repeatedly urged him to deny them on at the oral argument. And that is that the motions were denied on the basis that there was disputed issues of material fact. That was extremely important to me because I knew from my research and my experience that if a judge denies a motion for summary judgment based upon the doctrine of qualified immunity on purely legal grounds, then the defendants have a right to an immediate appeal. And if the appellate court were to agree with the defendants that the motion should have been granted and the case should have been dismissed, they can grant that motion on appeal and dismiss the case and prevent it from ever going to trial. However, the law says if the grounds for denial of the motion are that there is disputed issues of material fact, then the defendants cannot appeal immediately.
Do you recall whether there was an immediate interlocutory appeal or not?
The defendants did file an immediate interlocutory appeal. While I was still counsel of record, I immediately filed a motion to dismiss the appeal, citing to that body of law that says you can't appeal a denial of summary judgment if the judge says there's disputed issues of material fact. And then shortly after that, I was removed as counsel.
And at that point, you had no further involvement in the case.
That's correct.
Well, let's go back and look at the events that gave rise to that. First of all, do you recall when was it the hearing for approval of the Red Springs settlement that set that process in motion?
I believe it was actually a newspaper article that came out a week before that hearing.
Okay. What do you recall about that?
After I'd filed my motions for summary judgment and the motion for sanctions and the motion to approve the settlement, I received a phone call from a newspaper reporter from the Raleigh News and Observer.
Who was that?
I believe it was Mandy Locke, Locke.
All right. I guess you can't say what she said to you, but what did you say to her?
I gave her some details about the case. Most of these, I'd filed several of these motions under seal because they contained some sensitive information, and I requested that they be filed under seal. She was very interested in finding out what these
Objection.
Yeah, sustained.
I did not provide her with information regarding sealed motions, discuss the case in general, and I did not discuss with her the terms of my retainer agreement with Mr. McCollum.
Did some newspaper article then appear?
Yes, a newspaper article came out approximately 1 week before my May 5th, 2017 hearing with Judge Boyle on the motion to approve the settlement.
And what was in that newspaper article?
Extremely derogatory towards me and
Objection. Do we have this article?
Got an exhibit.
I don't think we've identified as an exhibit.
Objection then.
Sustained.
Okay. To your knowledge, was that the first newspaper article that made some accusations against you regarding your handling of this case?
that was the first media article that I had seen since the Industrial Hearing Commission and the announcement of the lawsuit. That was approximately a year and a half, maybe more prior, if I'm doing the math correctly. Let me count, I'm sorry, 12. Approximately 18 months prior was the last newspaper media account of that case that I knew about.
All right. Okay, well, let's get up to the hearing. What happened? And when was that?
May 5th, 2017.
Okay. What happened at that hearing?
Judge Boyle, for the first time, started questioning Henry Lee McCollum's competency, cited a dissenting opinion from a denial of a writ of certiorari to the United States Supreme Court, and refused to accept the settlement at that time, and continued the case for further proceedings.
And were there further proceedings?
Shortly after that, Judge Boyle ordered that Raymond Tarleton be assigned as guardian ad litem for Henry McCollum. And that was approximately a week or two after that May 5th, 2017 hearing.
And did you communicate with Mr. Tarleton after he was appointed?
Yes, after I received the ECF bounce notification, I contacted his office.
You may need to say what that is.
Okay, ECF bounce is, ECF stands for electronic case filing. It's the system that the federal courts use to track cases and process them through their electronic filing system. And they call it it's called a bounce. Whenever there's any activity on the case, it automatically sends out, an email to all of the lawyers on the case and the court, of course, to let every participant know this is what just happened on the case. They call it an ECF bounce. And usually it'll contain a hyperlink to the actual document that was filed. So when I received that email notifying that Judge Boyle had appointed Mr. Tarleton, I looked him up and I contacted him probably within either the same day or the next day.
How did you contact him?
I called him on the phone and spoke with him.
And again, don't say what he said, but what did you say to him?
I offered to work with him, and I wanted to bring him up to speed, let him know where the case stood at that point, and offered to come to Raleigh to meet with him personally. The file was too large to transfer through any electronic means. You can't, it's too big for Dropbox or any of those sort of cloud type services.
Well, was your outreach to Mr. Tarleton similar to what you did when you found out about Dwayne Gilliam's appointment?
Yes.
We look at the Defense Exhibit 1. What is this?
This is the email that I sent to Raymond Tarleton on June 22nd, 2017 at 2:47 p.m. And in this email, I recapped our meeting the day before, and I offered to address his concerns and clean up the retainer agreement, to clarify what the real intent and the understanding was, and offered to consult with an ethics expert on any other issues that he had concerns with.
Without saying what he had said to you, what was you talking about regarding cleaning up the retainer agreement issues? What does that mean?
He had a concern about the language of the retainer agreement, as I believe he testified, and I offered to fix the retainer agreement to clear up any language issues that he had any problems with, and told him it was never my intent to assert a charging lien as was reported, and said we can work through these issues together. And he responded, I believe, the following day.
Before we do that, that last sentence, the other issues, what are you getting at there? Again, without saying what he said.
I believe there was an issue about McCollum's competency. During that meeting, I told him what my belief and my position was. And the ethics question concerned, as far as I can remember, the ethics question concerned the validity of the language in the retainer agreement.
Okay.
I can't finish that answer without talking about the contents of a news article.
All right, as far as you can say. Let's go to the next exhibit, number 2.
This is Mr. Tarleton's reply to me on June 22nd, 2017 at 6:25 p.m., which is just a simple, it was a productive meeting and it was good to meet both of you. I will follow up.
Did he in fact follow up with you?
We spoke on the phone and I think exchanged a couple of emails a couple more times. Then at one point he cut off communication with me. And the next thing that I heard from him was he filing a motion to invalidate my retainer agreement and my representation of Mr. McCollum at night. And that was through email. He refused to engage me any further on the phone. And that was that motion that I believe.
I'm going to object to, he refused to engage me anymore on the phone.
Did he respond to you?
No.
When you tried to call him?
I called his office several times. I did not receive a response prior to him filing that motion.
Then at some point, Was it around this time that you found out, scratch that. Well, what then happened next with any court activity in the lawsuit?
Prior, I have to go back to kind of set the stage. Prior to the next step in the lawsuit, during my discussions with the town of Red Springs, and with counsel, they were well aware of a couple of these dissenting opinions that were out there concerning Mr. McCollum's intellect. Dan Hartzog had raised the issue with me concerning Mr. McCollum's ability to settle. And simply to get an opinion, that's why I referred him to Dr. Harbin for that March 2017 evaluation, in which Dr. Harbin found that Mr. McCollum was competent to enter into a settlement agreement. After that was in hand, the parties felt more comfortable moving forward with asking the court to approve the settlement. After Mr. Tarleton's, I believe it was July 26th, 2017 motion to terminate my retainer and my representation of Mr. McCollum and potentially undo the town of Red Springs settlement, we started litigating the issue of competency at my client's request. And at that point, there was a hearing on August 10th, 2017, where Mr. McCollum testified, Dr. Harbin testified, and Dr. Harbin testified consistently with that March 2017 report. Mr. McCollum testified that he wanted me and my firm to represent him. And it's all in the transcript. It's all there in black and white. And at the conclusion of that hearing, and I believe Mr. Rose also testified, not called by me, called by Mr. Tarleton, who at this point in time was seated at a different table as if he were an adversary. And at the conclusion of that hearing, Judge Boyle demanded that further testing be done because I'd raised an objection to appointing a guardian before there was any evaluation of competency.
And then what happened after that?
The parties were asked to submit names of potential doctors to conduct the evaluation. We submitted names, and the court did not choose any of the names that the parties had suggested, chose Dr. Corvin. And Dr. Corvin was assigned to conduct the evaluation. And Dr. Corvin did conduct his evaluation. If I remember the date right, it was August 22nd, 2017.
And was there a further hearing on the matter?
There was.
When was that, if you recall?
That was December 14th, 2017, if I remember the date correctly, before Judge Boyle. And that was here in Raleigh.
What occurred at that hearing?
At that hearing, Dr. Corvin was called to testify. He was cross-examined. And I was prepared to call Drs. Ballard and Drs. Harbin at the as is evident from the transcript, Judge Boyle stopped Dr. Corvin's testimony.
I'm going to object. I believe the transcript would be the best evidence of this. I'm fine if you want to testify about it as we look at it, but I do think it should be at least displayed here.
Well, this is the defense choice. I'm going to overrule that objection.
Thank you. Go ahead.
And I'm just summarizing. Judge Boyle stopped Dr. Corvin's testimony at one point. And then before Drs. Harbin and Ballard were going to take the stand, directed myself and Mr. Tarleton to go into a conference room and attempt to work out our differences for the benefit of Mr. McCollum. And we took a lengthy recess of almost an hour, probably about an hour.
Again, without saying what Mr. Tarleton, did you meet with Mr. Tarleton?
Yes.
And without saying what he may have said to you, what was the upshot of that meeting, and did you come back to the court after that meeting?
The meeting was tense. The meeting did not produce, there was a lot of arguing going on. The meeting did not produce any sort of meeting of the minds. But as the record shows, Judge Boyle settled it himself when we came back into the courtroom.
What was the ruling or direction from the bench at that point?
When we came back, Judge Boyle basically said, okay, this is where we are. I'm not going to change my ruling at this point. Mr. Tarleton stays. Mr. Megaro, you stay. I'm going to approve the settlement, if that's okay with everybody. And I'll reserve the issue of fees. I'll reserve the issue of costs. You can submit a motion to me later about that. But for right now, we're going to settle this case. And is that all right with everyone? And Mr. Tarleton and Mr. Gillum both agreed. The town of Red Springs agreed, and Judge Boyle asked me to put my justifications for the reasonableness of the settlement on the record. I basically almost verbatim read him that email that I had sent to Mr. Gillum that was displayed on the screen before. I gave him the justification why I believe the settlement was fair and reasonable, and Judge Boyle approved the settlement, and that was the end of Red Springs' involvement in the case.
And then what happened with the case as far as your involvement?
Then the case was scheduled to move forward to the next step, which was finalizing the motions for summary judgment. And we had a hearing on those motions. I believe it was January 28th, 2018, where I appeared, and we had extensive legal argument from both sides. I should say all three sides.
Was the matter of your fees or guardianship or anything like that at issue at that hearing?
No, that had been settled by Judge Boyle, but what had happened in the interim was myself and my partner had extensive conversations with Mr. Tarleton about coming to a new retainer agreement. Mr. Tarleton had brought in another counsel at that point just for consulting purposes. He never filed a notice of appearance on the case or anything like that. And there was a discussion about working as co-counsel with this new attorney and formulating a global new retainer agreement to cover Mr. Brown as well. Mr. Gillum was also involved in those discussions. Those discussions continued and they ended abruptly, sort of like the year before.
Now, at some point, did you object to the appointment of Mr. Tarleton as guardian ad litem?
I did at Mr. McCollum's request.
Objection.
Sustained.
All right. Well, what did you do?
I filed objections in the court. I submitted documents from Drs. Ballard and Dr. Harbin. Those documents were submitted ex parte and under seal. I did not want the defendants in the case getting that information. And at various steps of the way, I would ask Mr. Tarleton if we could possibly work this out without having to make everything public. And I never received a response.
And then what happened?
After the decision denying summary judgment was issued, I was actually very happy because that meant that the case was going to go to trial. And I felt reasonably comfortable about trying the case against the attorneys that were on the other side. And I started to discuss going to trial and making plans for trial with Mr. Tarleton and Mr. Gillum. And we were still having discussions about writing a new retainer agreement at that point to cover both. And at one point, I don't remember the exact date, I found out that Mr. Tarleton had gone to a Virginia court and petitioned for their version of a guardian there for Mr. McCollum. I did not know about this until after it happened. And once the new guardian was appointed, she contacted me and then I dealt with her directly for a very short period of time. And I was discharged sometime in April, I believe, of 2018. I don't remember the exact date.
Do you recall who the guardian was in Virginia?
Kimberly Pinchbeck, Pinchbeck.
And how did you find out that she had been appointed as a guardian?
I don't remember the exact sequence of events, but I spoke with I believe it was an associate of hers, an associate from her office, before speaking with her directly. And then the next thing was that I received an email from Ms. Pinchbeck, or maybe it was her associate, I can't remember which, informing me that my services were no longer needed. And an email from Mr. Gillum followed soon right after that.
The email from Ms. Pinchbeck was was within regard to Leon Brown, is that right?
No, Pinchbeck was for McCollum, Gillum was for Brown.
Oh, sorry.
Okay.
Backwards. So,
I'm sorry, Mr. Williamson, did you say, I misunderstood something you said, I think. Did you say that you received an email after Ms. Pinchbeck, that you heard that from, you got an email from Mr. Gillum or from Mr. Tarleton, did you say?
No, my recollection is first I got an email from Ms. Pinchbeck saying your services are no longer needed from Mr. McCollum. And then shortly after that, the same substance as an email from Mr. Gillum saying your services are no longer needed for Mr. Brown.
That's the part I didn't hear. Thank you.
Okay.
and did that end your involvement in the lawsuit?
Yes. That was April or early May of 2018.
Did you have any involvement or were you informed by anybody of any proceeding in Virginia prior to the appointment of Ms. Pinchbeck as a guardian?
Not to my recollection.
To your understanding, was that to be a guardian, a general guardian?
I didn't know what it was at first. I found out later that it was a limited guardian for Mr. McCollum.
Limited to what areas?
I think to create a special needs trust and to manage some financial affairs. I'm not sure if it was all.
Did you have any knowledge of who, if anyone, was guardian of the person by then of Mr. McCollum?
There was no guardian of the person.
Did there come a time that you had some direct dealings with Mr. Duffy and the multi-funding company regarding some loans?
Yes, early on in my representation, the clients wanted to take out a loan and they sought the services of multi-funding to give them a litigation advance loan. And I provided some information to Mr. Duffy. I believe it was an email just giving the synopsis of the case. Later, I signed just an acknowledgement of the lien and a statement of no superior liens when they sent over the loan documents to me. And then over the course of the litigation, Geraldine Brown took out an additional loan of $25,000. The point she took out that loan, I did not know she'd been removed. She'd been stripped of any authority to manage Mr. Brown's affairs.
Slow down. Let me back up. Now, we're backing up a little bit in time, right?
Yes, we're backing up to 2015 was the initial loans. And then the subsequent loans were 2016, I believe.
Now, you mentioned some loan to Geraldine Brown herself.
Yes, it came to my attention later that she did not have the legal authority to borrow in Leon's name. That came after the fact. At that point in time, I did not know that she'd been stripped of legal authority. Then when she tried to take out a second loan for $25,000, and by that time I believe I knew that Mr. Gillum had been in the case. Then I notified multifunding that she no longer had authority. And before they would fund that loan, that's something they might like to know, because I did not want someone with no authority indebting my client.
Did it concern you when you found out that Geraldine Brown had tried to get this loan for herself?
The second loan or the first one?
Second one.
Yes, because that point I knew she didn't have legal authority, and I did not want her indebting Leon Brown's estate for something that she had no authority to do.
Did you express your concern or act on that concern in some way?
I did. I notified Mr. Duffy at multifunding that she no longer has the legal authority to do this. So you can proceed at your own peril.
And was that loan funded or not? To your knowledge, if you know.
I don't think it was, no.
Did there come a time at some point that was there some court hearing or regarding multi-funding?
That was one of the issues that came up in 2017 after Mr. Tarleton raised that issue with the court. And I had requested that someone come and testify from multifunding that what Mr. Tarleton's accusations were incorrect. First, I spoke with counsel for multifunding. I spoke with the owners of multifunding, informed them of the fact that I could use a witness in court to testify. And they sent Mr. Duffy as a representative. I coordinated with Mr. Duffy, him getting to Raleigh before the hearing. He knew, well, I informed Mr. Duffy ahead of time of what the purpose of his trip to Raleigh was. He acknowledged that in an email. And when he got to Raleigh, we actually had dinner at the Pit restaurant. Mr. Hallscott was there. Mr. McCollum was there. And I went through, this is what's going to happen tomorrow. And I went through some of the questions that I would ask him, and I asked him for his answers just like I would prep any witness. The following morning, things changed.
All right. There's some documentation about that I want to go through, and I'll show you some exhibits. Let's first of all look at the defense exhibit 119, I believe.
Okay. I think you have to scroll down to get to the original email. Sorry. Okay. If you can go up a little, I can't see that. All right. This is an email from Mr. Bradley Winston on November 20th, 2017 at 11:09 a.m. notifying me that he represented multifunding and left a message at my office and asked me to call him.
Do we need to look at more in this exhibit?
I think so. Yes. I did speak with Mr. Winston. I told him what I was looking for in terms of witness, whether anybody would be able to testify. He informed me that there would.
Objection.
Just say what you know, please.
And then the next thing is my email to, you can scroll up, you can see. Mr. Winston on December 11th, 2017 at 9:19 p.m. asking him if Harley from multifunding would be coming on Thursday, which I assume was the date of the hearing, the 14th. And offered to go over testimony with Harley from multifunding. Ultimately, they did not send Harley, they sent Joseph Duffy.
All right. Could we go to 167B? These are, this is, well, go ahead, bring it up.
Okay.
What is this and what's the significance of it?
These are my printouts of my cell phone records for, you go to the top of the page, you'll see the date range. December 10th to January 9th, 2018. And if you scroll down, I believe we highlighted the telephone. Okay, there we go. So on December 12th at 11:30 a.m., Joseph Duffy called me from that 732 number. And we discussed the upcoming hearing on the 14th. That's when I learned that it would be Mr. Duffy, not Mr. Harley coming. So that's a 6-minute phone call. If you scroll down. The day prior to the hearing, I got another phone call, or I think I made a phone call. I don't know if that's incoming or outgoing. I'm assuming it's outgoing to Mr. Duffy. I think that's Mr. Duffy, same place. Go down. And then the evening of December 13th is the phone call that I received from Mr. Duffy. And that's when I learned that he had landed here in Raleigh and was coming to meet me. And I told him where to meet me at the restaurant so we could have dinner and talk.
Okay. Anything else about this exhibit we need to look at?
I think if you go down, there might be a couple more. Okay, yes. The following morning, December 14th at 8:47 a.m., I received a phone. That's when I received a phone call from, I can't remember who, whether it was Harley or Jerry at Multifunding to discuss the hearing that was supposed to take place later that day. I think it was in the afternoon. And then I received another call at 10:29 a.m. About the same issue. And then the last entry is the day after the hearing, where I received a phone call from Mr. Duffy and spoke to him briefly, finding out what happened, or he telling him what, in a brief synopsis, what had occurred at the hearing the day before.
Is that all about that exhibit we need to look at?
I think that's the last page, yes.
Okay, could we next go to exhibit 121?
Okay. Bless you. This is an email I received from Joseph Duffy on December 12th, 2017 at 8:14 a.m., where Mr. Duffy confirms to me that he is flying to Raleigh for the hearing on Thursday morning and asked me about chatting about it and wanted to know the time and location of the hearing.
Well, and just to be clear, what was this hearing to be on the, what, 18th?
It was a continued hearing on Mr. Tarleton's request to declare everything invalid.
Can we go to 120?
Okay.
What do you want us to look at here?
All right, stop, go down, sorry. All right, the first in this string is an email that I sent directly to Joseph Duffy on December 14th, 2017 at 10:05 a.m., sending him a draft affidavit of the affidavit that he ultimately signed on December 14th, 2017, instead of testifying. And that is me sending him the affidavit. And if you go up, this is his reply to me at December 14th, 2017 at 10:06 a.m., where he acknowledges receipt of the affidavit and he forwarded it to Jerry, who is his boss, and their attorney for a quick look over.
Let's go to exhibit 122. What is this?
This is an email string. Okay, if you go up a little more. This is an email that I received with Mr. Duffy copied on it, December 14th, 2017 at 11:08 a.m. Just giving a recap of those initial loans. And if you go up, this is an email addressing all of that specific detail, and just me saying I made some minor changes to paragraph number 9 of the affidavit because I felt it did not have to be that detailed. And then this is an email back from Jerry CCing Joseph Duffy at Multifunding on December 14th, 2017 at 11:30 a.m., in which he said it looks good.
Okay.
And I took that to mean that they approved of it.
All right, let's go to 123.
Yes,
May we take a 5-minute break?
yes. Why don't we, let's go ahead and take our afternoon break, and it's about 2:36. Can we come back about 5 minutes of 3, something like that?
Thank you.
All right, thank you. I know we'll designate some portions of depositions the same way, not, the video or anything, but just that's very short. I don't have that right now, but would anticipate doing that in the morning. Or whenever.
Okay. Do you believe, and again, I'm not trying to rush you in any way, do you believe that your further case in chief will last more than an hour, less than an hour?
Oh, with Mr. Megaro, right?
Correct, right.
Not more than an hour.
All right. And Mr. Murphy and Mr. Walthall, again, not putting you in a box about this, but do you have a general forecast as to your the length of time you'll need for cross-examination?
How it goes and how long each minute refer back to documents, but I'm pretty confident I can finish today.
Okay, so my concern is that we've again got to have closing statements, and we've got to have a period of time to deliberate. And I want to make sure, if possible, we can complete at least phase 1 by tomorrow, and see where we are. So it sounds like that's still doable. The question is, do we need to start at 8:30 in the morning, or do we just resume at 9 o'clock on our regular schedule? Does anyone have a strong feeling about that?
Either is fine with the state bar. I will say, if we finish today with all testimony and exhibits and whatnot, we just have closing arguments. I don't know how long the defendant plans on closing, but it seems like tomorrow we would have plenty of time to finish everything, at least in phase 1.
Ms. Miani, let's just open at 9 o'clock tomorrow. All right. And that way we don't have to put a burden on the security folks to come early or anything like that. Let's just plan on 9 o'clock in the morning. Thank you. All right, Mr. Williamson, you further questions for this witness?
Yes, sir. Thank you, Mr. Board. On my microphone. Can you hear me okay, Mr. Megaro?
Yes, thank you.
I think we left it at 123. We through with that exhibit, I believe.
No, I don't think I talked about that yet.
Oh, okay. What's significant about this?
Okay, so after I made the change to one paragraph in the affidavit, I sent a draft back to Mr. Duffy, and he responded to me on December 14th, 2017 at 11:48 a.m., ready to sign in the lobby when ready, because he was staying in the same hotel, which is the Holiday Inn right here downtown.
Down the street.
Yeah. Yes, sorry.
Let's next go to exhibit 124.
Okay. This is the affidavit that Mr. Duffy signed on December 14th, 2014, after a couple of, I think 1 or 2 drafts. If you go down to the second page, he made, stop. On paragraph number 3, he made one change, which was to cross, I'd written 18% rather than 19%. He made that one change and he initialed it. And if you go down, he signed it before a notary public here in downtown Raleigh on December 14th, 2017. This affidavit was never used.
I'm sorry, you said it was never used. Is that what you said?
Never used. I just kept it and that was the end of that.
I didn't hear what you said.
Okay. The next exhibit is Defense Exhibit 16.
Okay. This is the order that approved the settlement by Judge Boyle after that December 14th, 2017 hearing, and this is where it basically memorializes what Judge Boyle said on the record, which is Mr. Tarleton stays as guardian ad litem, and myself, Mr. Hallscott, and Mr. Brett Schneider remain counsel of record for Mr. Brown and Mr. McCollum.
And was that the last order in the case prior to your being relieved by the respective guardians?
Now, the last order in the case was the order denying the motions for summary judgment, both mine and the defendants, and basically setting the stage for a trial.
And once you were relieved as counsel in the civil case, did that essentially end your involvement with Mr. McCollum and Mr. Brown?
Legally, yes.
Let's now turn our attention to the Grace Humphrey matter. But just don't put up an exhibit. We're just changing gears. Okay. Mr. Megaro, how did you first become involved in the representation of Ms. Grace Humphrey?
Grace Humphrey contacted my office sometime in September of 2015 and was seeking assistance with appealing an equitable distribution judgment that had been entered that was not in her favor in the Alamance County Court. I don't remember the exact date that she contacted my office, but at one point, bless you, I met with her in person, bless you, right by the airport here in Raleigh. I was either going or coming, I don't remember which I was, but at that initial meeting, Ms. Humphrey brought a Rubbermaid tub of paperwork with her. We met in a coffee shop and she brought the tub in. And I just went through the documents with her and started discussing the case.
Okay. Then what happened?
At some point after that, she made the decision to hire the firm, and she was given the retainer agreement. Went through the retainer agreement with her, just like I do with everybody else. And one of the portions of the retainer that I always highlight and emphasize with any client dealing with a post-conviction, post-judgment, or appeal matter is that you are responsible for buying the transcripts from the court reporter, because without them, you simply cannot do what you want to do. And that's why in the retainer agreement for appeals and post-conviction relief is a standalone bold paragraph that I always make sure I go over that with the client. At that initial meeting with Ms. Humphrey, one of the questions I always get asked, and Ms. Humphrey asked, was how much is this going to cost? And I can give an estimate based on almost 20 years of experience on how much a transcript will cost by the length. because so many pages times certain dollar amount per page will, the relatively simple formula. At that initial meeting, Ms. Humphrey told me that the trial was only.
Objection.
Well, Ms. Humphries testified. Is this outside of something she said yesterday?
No, this is exactly,
I'll
this is
withdraw the
exactly what
objection.
she was confronted with.
Overruled.
Go ahead. She told you about, were you answering about days?
Yes, I asked her how many days was your trial, and she said it was only a few. I don't remember the exact number she gave me, but certainly less than 10. Later, I come to find out that it's not just a few days, it's 17 days of trial.
How did you find that out?
We contacted the court and asked the court for the list of days that the case was on the trial calendar. And we were provided with 17 dates and had to order 17 different audio CDs for those dates. After, okay, so she retained me, I believe, on September 21st, 2015. And one of the main concerns that her immediate concern was that payment, the first equitable distribution payment to her husband, which was due October the 1st, 2015. As the court documents bear out, she had already been held in contempt by the judge. From my review of the file, her ex-husband's attorney had pursued the case very aggressively against her. And she was concerned that if she did not make that initial payment on October the 1st, what would happen to her? Bankruptcy was already in the air at that point, and she wanted to use bankruptcy as a means to avoid paying on the judgment to her ex-husband. So on October 1st, 2015, her first equitable distribution payment was due. She did not make it. The following day, October 2nd, 2015, her ex-husband's attorney filed a motion for contempt against her, not just asking for civil contempt, but asking that she actually be jailed in the Alamance County Jail. And when she received that motion, she reacted poorly.
Let's stop here and look at a couple of exhibits. Can you pull up 129? I think.
This 129 is the retainer agreement that I drafted for Grace Humphrey. It's dated September 18th, 2015, but I don't think she signed it until a couple of days later. If you could scroll down, I think she faxed it back. Okay. All right, this is a fully executed version. We're on page 11. There may be a date header at the top of the page. I don't know. Okay, it says September 20th, 2015. That's the day I believe she sent it back signed.
How did she send it back? Fax?
Either faxed or emailed. I'm not 100% sure. It looks like it might be in the body of an email.
Okay.
I don't know what that is. It looks like an email.
All right. Could you highlight the provision in there about the transcript? Find that.
Right there. Okay.
Could you just read that?
Please be advised that in connection with filing this appeal, you are responsible for covering the costs of the purchase of transcripts and minutes of all of the proceedings in the trial court, as well as the costs of appellate printing and copies and all filing fees imposed by the court. You hereby expressly agree to pay these costs and acknowledge that without the transcripts and minutes of the proceedings in the trial court, we cannot properly file this appeal and represent client in this case.
Now, did she actually pay some money to the firm in connection with this appeal?
She did, and we allowed her to pay a small down payment and a monthly payment schedule because of her financial situation.
And was any of that designated particularly for the transcription of the proceedings?
No, when it comes to transcripts for an appeal, I always tell the client to make financial arrangements. When I make the financial arrangements, they have to pay the court reporter directly. I do not like taking custody of any money for transcripts unless it's absolutely necessary. There's some sort of extenuating circumstances. But typically what we do is we get the estimate from the court reporter, and we tell the client, this is who you have to make payment to. Please pay this person and pay them this bill. This is their bill. You have to pay them directly.
And if you go to 133.
$133 is the motion for contempt that was filed against Grace Humphrey on October 2nd, 2015. The attorney for ex-husband was Dan Bullard, Bullard. And as you can see, Mr. Bullard filed the motion on October 2nd and simultaneously requested a hearing time for that motion the same day and asked that motion be scheduled for a hearing.
Was that after you had been retained for the appeal?
Yes, it was less than 2 weeks after I got retained for the appeal.
Did you represent her at all on that motion?
No, that motion was never heard because Ms. Humphrey eventually came to an agreement to pay Mr. Humphrey's attorney some sort of payment for him to withdraw that motion, and he withdrew it.
Mr. Williamson, may I see the certificate of service on this, please? All right, thank you.
On the certificate of service, there's Ms. Humphrey's 2 prior attorneys, both of whom had been relieved. If you scroll down, it'll have the date. Okay, so it was filed and served the same day, October 2nd, 2015.
Was it within the scope of your retainer agreement with her to represent her on such a motion in the, what we call the district court?
No, I believe the retainer has language that specifically excludes any representation in the trial court without any other retainer agreement.
Was there, did there come at some point, was there any further order in the trial court regarding her?
Yes. What had happened was after this, Ms. Humphrey decided to go the bankruptcy route, and she filed a petition for bankruptcy in the Middle District of North Carolina. I have the petition. I don't remember the exact date, but I know it was shortly after that.
Is that 135?
Yes. Okay. So 3 weeks and change later, Ms. Humphrey filed a petition for bankruptcy in the United States Bankruptcy Court, October 28th, 2015, in case number 15-11173. And this was an attempt to avoid paying the ex-husband's attorney the money that she had agreed to pay him in order to have him withdraw that motion for contempt, and the rest of the equitable distribution amount as well.
Do you know what happened with that bankruptcy petition?
As far as I know, it's still pending.
But you don't have any personal knowledge of it right now?
No, I haven't looked this up in a while, and I really don't know much about bankruptcy.
Were there any other proceedings in the district court relating to any allegations of contempt?
Not that I'm aware of while I represented Ms. Humphrey. I don't know if there's been subsequent. There were other proceedings on the appeal.
Right, and we'll get to that. What happened in regard to anything being done to order the transcripts for the appeal?
Once we received the 17 CDs from the Alamance County Court, my paralegal immediately sent them over to a court reporter transcription service that we use in Orlando. We'd been working with quite a bit over the years. I trusted their work. I knew they always delivered transcripts ahead of schedule, and I believe that they were reasonably priced. When Ms. Armenteros, my paralegal at the time, forwarded that estimate to the client, as we always do, she responded with that she did not have the money to pay that much, and she then began a long-standing argument about her going off and hiring her own court reporter in an attempt to save money.
Look at Exhibit 136.
And if you scroll down, this is an email from, scroll up a little, from Patricia Armenteros to Grace Humphrey on November 11th, 2015 at 4:31 p.m. This is her forwarding the estimate from the court reporter to Ms. Humphrey.
And is there a response there?
And the next morning, Grace Humphrey forwarded that email that she received from my paralegal to me. And if you want me to read it, I'll read it, or I can summarize.
Are we looking at it right now?
Yes.
Go ahead and read it.
Hey, Patrick, received an email yesterday about the cost of transcripts. I hope that is only the estimated cost for the entire trial. The transcripts need to only be transcribed for ED. I'm not sure how to do that, but there is no way I can pay $10,000 for those. I had in my budget of a couple of $1,000, but that figure from the email is out of my reach. Please contact me today or have one of your assistants to discuss and explain this to me if I'm not on target here. Thanks so much, Grace.
All right. Let's go to 137.
Okay, so in between that email and this email, there were a number of phone calls, and I tried to impress upon Ms. Humphrey multiple times the importance of getting the transcripts done in a timely manner to meet deadlines, and the fact that I did not know it was going to be $10,000 because she had told me that the trial was 1/4 the length that it actually was, or something to that effect. And she responded that she was going to find her own court reporter to do the transcripts, and she was going to save money by doing that, and insisted on that course of action, despite my better efforts to dissuade her. So this email here, which is 137, was the email that she sent me on November 18th, 2015 at 2:12 p.m., where she describes the court reporter that she found, and that court reporter had only asked her for $1,000 up front and the remaining balance upon completion.
Well, what happened in terms of obtaining a transcript from that court reporter?
Well, as you can see from the email here, the court reporter initially agreed to have it completed by the end of December that year. It was not completed until, I believe, March of the following year.
Did there come a time that did you make any efforts in the trial court to get an extension to get the transcript?
Not at that time, because Ms. Humphrey was kind of going through this waffling back and forth with, well, I don't need to do this appeal because I'm going to do this in bankruptcy. Her whole goal was not to have to pay her husband the money that the court had ordered her to pay. And a lot of discussions with her, she would go back and forth, but I'll do this on the bankruptcy side, or we'll save the appeal for later. I always told her that's a bad idea. I don't think it's going to work out the way you want it to, and I strongly advise you against this course of action.
Could we go to, what was that one? 138? That.
Okay, this is an email from Ruth Paulson, Paulson, dated March 4th, 2016 at 3:13 p.m. And in this email, she's completed the transcripts and she's transferring them to me. You can see the different volumes. I think they're in Roman numerals. And there's 17 volumes total.
At some point, due to the delay of getting the transcript, was the appeal of right dismissed?
Was I'd filed the notice of appeal, and Ms. Humphrey's ex-husband had filed a notice of cross appeal. And due to all of these delays, Mr. Humphrey's attorney at one point filed a motion to dismiss the appeal in the district court. Initially, a hearing was held on a date that I ended up in the hospital. I was hospitalized either that morning or the day before. I don't remember which. The hearing was held in my absence, and after I was released, I contacted the court, and the court agreed to vacate that prior hearing and hold the hearing again due to my illness. Then there was a hearing. I don't remember the exact date, but the judge did ultimately dismiss the appeal because of the issues with the delays.
And had you warned her that the appeal would be dismissed without the transcript?
Many times. From the day I first met her, I went through the various deadlines of the North Carolina Rules of Appellate Procedure. There is a cheat sheet at the end of the North Carolina Rules of Appellate Procedure that has a sort of schedule of deadlines. I went through that with her. I believe at that time we might have even had it posted on our website, so I didn't even need to carry it around with me. But I'd gone over that exact scenario with her multiple times. And I did advise her at the same time, if your appeal is dismissed, you do have the option of filing a petition for a writ of certiorari, but that burden is much harder. It's a much steeper hill to climb.
And do you recall some testimony that regarding the hearing concerning dismissal of the appeal that you admitted violating appellate rules and so forth? You recall that?
I do. I was trying to bring some levity to the situation, making a joke because I knew that I couldn't go into a hearing and tell the judge, well, Your Honor, the fact is that my client just doesn't have the money to prosecute this appeal. I tried to use other justifications or other excuses rather than come out and say that outright, including the bankruptcy. And I tried to say that the bankruptcy would toll this, and ultimately none of those arguments worked. But I knew for certain simply going there and saying my client doesn't have the money to do this is not a legal excuse.
Did you in fact file a petition for certiorari after the right to appeal was dismissed?
I did. After all that dust settled, I started preparation of the petition. And I filed a petition on the issues that she wanted me to file on. And I made the best argument that we possibly could. But the problem was that the standard of the law, the law and the facts were not in her favor. And the third glaring problem was that she had consented to the judgment. So that made it difficult to turn around and say, well, the same judgment that I consented to was patently unfair, because then why would you agree to it? But I did absolutely everything I could. And as you can see in a subsequent email, Ms. Humphrey expressed a lot of satisfaction with that effort.
Okay, and we went over that with her.
Right.
After that, did she file a case in Brunswick County Superior Court, an action against you for alleged legal malpractice?
Yes, there is a lawsuit against myself and my firm for legal malpractice arising from this whole series of incidents that is currently pending.
And due to the pandemic, has there been any result in that case?
No, we had a mediation, and that was a while ago.
Yeah. Anything else you wish to say about the Grace Humphrey matter?
I think it's all there in black and white.
Okay. No further questions at this time.
Will there be cross-examination by the State Bar?
Yes, Mr. Chair. Mr. Megaro, do you recall the date that the DA, Luther Britt, asked the governor to issue pardons for Henry and Leon?
I don't recall that date, no.
I'd like to show you that letter just to refresh your memory and enter it into evidence. May I distribute copies of that letter, Mr. Chair?
Is this one of the documents that we have that's previously been as part of your list?
No, sir. This is a rebuttal document.
Has this document been shown to the defense?
Yes, sir.
attorney? All right, any objection, Mr. Williamson?
I have no doubt I've seen it, but I'd like to see it again.
Let's exchange that first before you show it to us, please.
Okay.
Yes, I've seen this. I have no objection to it. So
What is the exhibit number, please?
803.
Thank you. Yes.
well, I guess what I would say, I have no objection to its use since it's our case to admit it on the rebuttal case.
You understand what?
Yes, sir.
You really technically can't introduce evidence on your in his case in chief.
I understand.
Once he rests, then you can
Yes, sir.
move whatever exhibits in you want at that time. Then we can rule on them.
I just want to be able to look at it.
Right.
Very good.
And that's fine. I have no objection to that.
Are we set up over here? Okay.
Are they under control now?
Mr. Megaro, do you see that on your screen there?
Yes.
What's the date on this letter wherein the district attorney Luther Britt encourages the governor to issue pardons to Henry and Leon?
September 23rd, 2014.
And that was 6 months prior to your involvement with the case, is that right?
I think about 5.5 less.
Okay, all right. And let's look at your exhibit, Defense Exhibit 81. This is your highlights from earlier. If you would, please read the highlighted portion there. This is page 4 of Defense Exhibit 81.
On September 4, Governor Pat McCrory said he looked forward to reviewing their joint pardon application. It was submitted September 11. The governor has taken no public action on the case since. The governor's office on Friday and Saturday did not return calls, emails, or texts inquiring about the status of McCollum and Brown's pardon request.
And what do you know the date on this? You can pull up to the front here.
January 31st, 2015.
And that was also prior to your involvement with the case, is that correct?
Over a month, yes.
Okay, so there was already some media attention on this matter and the pending pardons before you were involved?
Some.
Okay. At one point, you sent Charles Gallman to Henry and Leon's house, is that correct?
I asked Mr. Goldman to go to Mr. McCollum and Brown's house to provide them with training for electronic devices to help them communicate with me.
Is that the only reason you sent him to their house?
At that time also, Ken Rose was attempting, as he testified, to have Mr. McCollum and Brown leave me and return to him. And I wanted to find out more about the situation.
And where did you, oh, I'm sorry, I didn't realize you were finished.
Well, I think everyone's talking over each other. Let's make sure the questions are completed and the answers completed before we, so it's clear for the court reporter, if not for the panel.
Yes, sir, I apologize. I was truly accidental. I did not hear him.
You may complete your answer, Mr. Megaro, if you've not done so.
I think I said I wanted a second pair of ears to hear what Mr. Rose was saying to Mr. McCollum and Mr. Brown.
Where did you send Charles Gallman from?
New York.
Did he fly or drive?
I believe he flew.
And did you pay for him to fly down there?
I did.
Did that come out of Henry and Leon's costs?
I believe it was taxed as a cost.
Okay. You shared your retainer agreement with Deborah Pointer and Kim Weeks, is that correct?
Proposed retainer agreement.
You sent it to Deborah Pointer and Kim Weeks?
I emailed it to them, yes.
Okay. Isn't your retainer agreement confidential client information?
At that point, it's not confidential. It's a proposed, the final product, I would agree with you, is confidential.
And let's look at Exhibit 116. Are you familiar with this exhibit, Mr. Megaro?
This is the petition that I filed on behalf of Leon Brown for a guardian.
Okay, and you testified on direct that the paragraphs referencing Henry were an error?
Yes, it looks like a cut and paste kind of situation.
That a law firm, a law student wrote that part? Is that what you said?
I said possibly, or possibly a law student cut and pasted that into a draft.
Did you take any steps to correct these incorrect statements with that tribunal after you made them?
I didn't realize that it was that much of an issue.
So you haven't taken any steps to correct them with that tribunal?
No.
Okay, let's look at your deposition on page 84, Exhibit 100. Just to make it easier, I'd be happy to read my lines starting at line 8 if you would read your responses, and we'll go through line 19 there. I asked you at your deposition, what is Exhibit 116? And what was your response?
This is the petition for incompetence in an application for guardian on behalf of Leon Brown that I filed.
And I asked you, you drafted this?
I did.
You signed it?
I did.
You filed it?
Yes.
Is everything herein true and accurate?
Yes, and I gave that response before you showed it to me, and I realized that error.
Okay. let's look at page 88. And I'll again read my line here on line 7. If you would please read your response. Question, okay, go ahead and turn to page 10, please. Page 10 of Exhibit 116 and read into evidence paragraph 35, please.
Quote, in the course of representation on the civil claims, undersigned counsel assisted both Henry, end quote, I'm sorry, open quote, assisted both Leon Brown and Henry Lee McCollum with obtaining a cash advance loan of $100,000 from a legal loan company. The terms of the loan were as follows. The loan company paid the rent for an entire year on the home, which both Leon Brown and Henry Lee McCollum distribute to them a lump sum for furnishings, clothing, and basic necessities, and distributes to them monthly prepaid credit cards with a limit of $2,500. The $2,500 per month is for basic living expenses and spending money. Both brothers need assistance with budgeting their monthly allowance because they are unable to understand the concept of paying utility bills and making purchases. One thing is clear, neither Leon Brown nor Henry Lee McCollum have a concept of budgeting or spending limits, nor do they have any experience in managing money, let alone large sums of money, end quote.
And then I said, is that a true paragraph that you wrote and then pled? And what was your answer?
Well, I guess, when I say when I assisted them, the assistance that I did was signing the documents and forwarding the information. But yes, neither one of them had an idea of budgeting. They both went to jail when they were teenagers.
Thank you. Let's look at Exhibit 709. Have you seen this exhibit before?
This is a motion to terminate the guardian ad litem and to direct no further competency evaluation and incorporated memorandum of law.
And you drafted this document?
Yes,
You signed it?
I believe it was digitally signed, but yes,
You filed it in a federal court?
it was filed.
Is everything herein true and accurate?
I believe so.
Okay. Let's look at page 5. You would please read the first sentence of paragraph 23 that is highlighted.
First, there is no credible evidence that Henry Lee McCollum is mentally retarded.
Thank you. Let's look at Exhibit 145, page 59. Exhibit 145 is a PowerPoint presentation that you drafted and presented, Mr. Megaro.
This is the PowerPoint presentation that I drafted and presented at the mediation, and the slides regarding mental retardation I took directly from Ken Rose's slideshow on the same topic.
And you show 30 pages of evidence that Henry is mentally retarded. Is that correct?
I used the same historical evidence in the case file that you and Mr. Rose have relied upon, and use that as an advocacy piece at the mediation. That's correct.
And you claimed that Henry and Leon were mentally retarded.
I did make that claim in the context of the civil litigation, correct?
So you have made the claim both that Henry is mentally retarded, that there is, as in your words here, evidence of mental retardation, and you've made the claim that there is no evidence of mental retardation. Which, if either of those two claims is true?
I believe the truth lies in the expert opinions of Dr. Ballard and Dr. Harbin. As an advocate, I presented evidence that they were mentally retarded. And when a client asked me to fight against the guardian, I presented evidence that he was not, quote unquote, mentally retarded.
So which of those two statements is true? But both of them? Was that? I don't understand your response.
I'll be happy to explain to you.
Please.
As an advocate, you are permitted to present an argument that in good faith, even if you don't believe in it. And whether I believed that Henry McCollum was retarded or not, there was evidence that I could point to in the civil case so that I could present him as mentally retarded and Leon Brown as mentally retarded if that claim were to strengthen their claims in the civil case. I don't necessarily have to believe it myself, but I can present it as long as I have a good faith basis for doing so.
So just to go back to 709, you didn't claim Henry isn't mentally retarded. You claimed there is no evidence that he's mentally retarded. Is that correct?
In the context of this particular motion, I said there is no credible evidence of mental retardation currently before that court.
Okay, that, again, the sentence says, first, there is no credible evidence that Henry Lee McCollum is mentally retarded. I don't see before that court in that sentence.
The
Am I-
slideshow that you were referring to prior was not presented to that court at that stage.
Was that for the industrial commission matter?
The slideshow? No, the slideshow was for the mediation in an effort to try and convince the defense lawyers to settle the civil claim.
The slideshow was in the civil litigation matter?
It was at the mediation. Wasn't part of the record. It was at a confidential mediation in an effort to try and settle or convince the defendants to settle.
Is there evidence that Henry Lee McCollum is mentally retarded?
There is evidence, and I believe it is incorrect.
Okay, but there is evidence that he's mentally retarded.
There's no doubt about that there was evidence presented to various courts over the years and that the courts have consistently rejected that.
Is everything that you presented in this PowerPoint presentation true?
Do I believe it's true?
Is it true? Is the question.
Is there evidence of mental retardation? That is true.
Okay. Did you put anything in this presentation that was misrepresentative of the truth or inaccurate?
I'm not sure I'm understanding your question, but I put information in the slideshow of which there was a good faith basis to argue, and in an effort as an advocate on behalf of Mr. McCollum and Mr. Brown to convince defendants on the other side to settle.
So those arguments were in Henry and Leon's best interests?
It was in their best interest to convince the defendants to settle and give them large sums of money for their pain and suffering, yes.
So the arguments that they were mentally retarded were helpful to Henry and Leon?
At that particular venue and at that particular stage, yes.
Okay. Let's look at Exhibit 166. What is Exhibit 166?
This is an order.
Okay, if you would read the first paragraph beginning, "This cause comes," please.
This cause comes before the court on a motion by the guardian ad litem for plaintiff McCollum to determine whether the representation agreement is valid and whether a conflict exists, as well as a motion by counsel for plaintiffs to terminate the guardian ad litem appointed to represent the interests of plaintiff Henry Lee McCollum in this matter.
So your order was, or excuse me, your retainer agreement was specifically at issue before this court?
That was one of the issues.
Okay, let's turn to page 10 of Exhibit 166. If you would please read the highlighted portion into the record, please.
In its review of the evidence presented, the court recognizes that some of the medical and psychological opinions in this record were provided more than 20 years ago, but it has been presented with no evidence or persuasive argument that the intervening 19 years McCollum spent on death row before his release would have so dramatically altered his personal circumstances as to render such opinions moot.
Do you believe that Henry's time in prison and on death row made his mental capabilities better or worse?
I don't believe it affected his ability to manage his own affairs.
I understand that, but do you believe it made his mental capabilities better or worse?
Well, I'm sure it made his post-traumatic stress disorder decidedly worse and his depression decidedly worse when he was watching his friends be put to death, but I don't believe it affected his ability to manage his affairs.
Mr. Megaro, let me refer you back to your deposition transcript. This again is Exhibit 100. I'll read you the question I asked you if you'll read the first sentence of your answer. And then you believe that their conditions worsened in prison, is that correct? And please read your answer, the first sentence.
Just the first sentence?
Please.
Their mental conditions did worsen in prison because of the nature of incarceration, yes.
Great. Let's look back at Exhibit 166. I've got too many pulled up here. Right. And then if you would please read into the record this paragraph that is highlighted on page 11 of Exhibit 166.
Despite his desire to proceed for himself and manage his own affairs, McCollum continues to evince signs of being easily manipulated and a lack of understanding of his attorneys. For example, when questioned by Dr. Corvin about the fee arrangement with his attorneys in this matter, McCollum explained that under New York law, his attorneys are supposed to get 1/3 of any recovery because as New York and Florida attorneys, they are totally different from lawyers in North Carolina and the South. You want me to include the citations or no?
No, that's fine.
McCollum further explained that he received half or less than half of his award from the North Carolina Industrial Commission for his pardon of innocence because, as his attorneys explained, they had to take money out for his future civil case and expenses.
Still your testimony that Henry understood your fee agreement and the document explaining the settlement of the Industrial Commission funds.
Mr. Wall, that's the truth.
That's still your testimony.
That is my testimony. It is the truth.
Okay. If you will, please turn to page 12 and read the highlighted sentence.
Although McCollum is aware that $20,000 from the first loan was paid to two non-attorneys, Kimberly Weeks and Deborah Pointer, McCollum testified that he did not know anything about these women or why they were paid.
All right, and let's turn to page 15. And if you would please read the highlighted sentences on that page.
In other words, counsel was plainly on notice that his potential clients had intellectual disabilities and that their abilities to proceed without a guardian were at issue. Nonetheless, counsel entered into a representation agreement and has, to the court's knowledge, never sought to have the agreement ratified by any duly appointed guardian for either plaintiff.
Do you believe Henry and Leon have intellectual disabilities?
I believe that they have a low IQ, which I guess I conflate with intellectual disabilities. After hearing the specific definition by the doctors, I don't know. I'd have to defer to their expertise.
Okay, let's look at Exhibit 100, page 213. Please read, or I can read it to you. You say, is it true that they are intellectually disabled? Yes. Did I read that correctly? Line 9 to 10?
Yes, and as I just said to you, I believe that I conflate intellectually disabled with low IQ, but as the doctors testified and taught us, that's not what the medical diagnosis says.
Okay, let's look at Exhibit 150. What is Exhibit 150?
This appears to be the consent motion for to approve the settlement with the town of Red Springs, I believe. You're going through too fast, I can't see.
You need to see the top again.
Yes, that's what it is.
Okay. You would please read paragraph 2 on page 5 of Exhibit 150 into the record.
That plaintiff Henry Lee McCollum, while previously tested as having a low intelligence quotient, has not been adjudicated incompetent by any court. Counsel for plaintiff had Henry Lee McCollum evaluated for competency under North Carolina law by Dr. Thomas J. Harbin, PhD, a licensed psychologist in Fayetteville, North Carolina. Dr. Harbin has determined that Henry Lee McCollum is legally competent to enter into the settlement agreement and to manage his financial affairs.
And did you hold out to the court that Henry was competent to manage his financial affairs?
I believed it was, and as Dr. Harbin testified yesterday, he reached that same conclusion on, I believe it was March 17th, 2017, after an evaluation by Henry McCollum.
And did you draft this document, Exhibit 150?
Yes.
And what's the date here on page 1 when you filed it?
April 11th, 2017, which is a few weeks after Dr. Harbin's evaluation.
Okay, let's review just a bit of Henry's financial affairs for the roughly year and a half prior to you claiming to the court that he could manage his finances. Correct me if I'm wrong on these dates. In October of 2015, he received $360,000 from the Industrial Commission.
October 15th, I thought it was
No,
the 20th.
October of 2015, I apologize.
Oh, okay. I believe is October 20th or 21st.
He received $360,000 from the Industrial Commission.
Yeah.
Then roughly 6 months later, he received a loan from multi-funding for $50,000. Is that correct?
I don't remember the exact date of the second
Okay.
loan from multi-funding, but
All right, we can look it up. What's the date on, this is exhibit 132. What's the date on this loan document?
it appears to be May 11th, 2016.
So roughly 6 months after Henry received $360,000 from the Industrial Commission.
Roughly how many months? I can't hear you.
6 months,
Uh,
7 months. I'm
7
terrible at
months.
math.
Yeah, I don't do math, but okay.
Okay.
7 months roughly.
And how much is this loan for, referenced in exhibit 132?
$50,000.
Okay. And then in October, so 5 months later, he received a $15,000 loan from multi-funding.
I believe that's right.
Okay. And then in January of 2017, he received a $20,000 loan from Derek Hamilton. Is that correct?
I believe it was January 2015.
2017?
I mean, 2017, sorry.
Okay. And then in February of 2017, you sent him $500 via Western Union.
I don't recall sending him $500.
All
It
right.
might have been out of his account.
We can look it up. What is exhibit 645?
This is a text message that Mr. McCollum sent to me.
Okay. And he references needing $500 via Western Union. Is that correct?
I believe at that point in time, the $20,000 was in my escrow account. He wanted me to wire him $500 immediately and send him a check or wire the remainder to his account. But I believe the reason why he wanted $500 immediately so that there would be cash available immediately.
Okay. So you did send him that Western Union?
That was his money, yes.
Okay. And then in March of 2017, you sent him $1,000. Is that right?
I don't recall the exact date.
Okay. This is exhibit 646. Have you seen exhibit 646 before?
I believe so.
And what does it indicate?
$1,050.
Sent via Western Union?
Yes, but that's not me.
That's not you, Michael Patrick?
No, I don't live in Altamont Springs. I've never lived in Altamont Springs.
Okay. How did you get your hands on this receipt that was produced to us in Discovery?
I don't remember.
Okay. If my math is right, that is almost $450,000 over the course of a year and a half.
If your math is right.
Okay. And that was in the year and a half prior to you making the claim to the court that Henry could manage his financial affairs.
And that was in the year and a half. Say that again. I'm sorry.
In the year and a half prior to you making the claim to the court that Henry could manage his financial affairs, he had spent or gotten from you or with your help $450,000, give or take.
Henry McCollum never spent any money with my help.
Right. Did he obtain those loans with your help?
To the extent that I signed documents and sent them back, I guess you could say that is help, but I didn't help him spend money. That's what you said. I helped him spend money. I didn't.
Okay, but I'm asking if you helped him get these loans.
To the extent that I assisted him in acknowledging the receipt of these documents and sending the information back at his request to multi-funding, I guess you could say that's assistance.
So you were aware he had received a $360,000 from the Industrial Commission in October of 2015?
Of course, I'm the one who wrote him the check.
And then you were aware that he got the $50,000 loan from multi-funding in May of 2016?
Well, I assumed that they funded it. I don't know because I didn't track it after, but I assume they funded it.
But you signed portions of the loan document, correct?
Well before it was funded, yes.
Okay. And then you also were aware that he received another $15,000 loan in October of 2016 because similarly, you signed pages of the loan documents.
I signed the couple of pages from the loan documents, but I was never aware that it was actually funded and I didn't track those funds.
And then you also drafted the loan document for the $20,000 loan from Derek Hamilton in January of 2017.
Yes, I took the exact same prototype from the multi-funding and applied it to Derek Hamilton. The only change I believe was the interest amount, which was much lower.
So you were aware of Henry McCollum receiving all of that money in the year and a half prior to you claiming to the court that he could manage his financial affairs?
The $20,000 from Derek Hamilton, I was 100% aware of that. The initial payment from the Industrial Commission, I was 100% aware of that. The other two, like I told you, I didn't track them, so I can't speak to that.
Multi-funding never told you that they had been funded?
I don't remember them ever telling me that it had been funded, no.
They didn't send you letters indicating how much your clients owed?
Well, that sending me a letter saying that they owe money is different than tracking the funds in a bank account.
But you have no idea if Henry received those loans or not?
Didn't ask him and I didn't want to know. It wasn't my business.
Did you receive payoff amounts in letters from multi-funding for these clients?
Later, yes.
Okay. You learned how to do post-conviction work from Scott Brett Schneider, you said?
No.
You didn't say that in direct?
I learned how to do post-conviction work while I was a legal aid attorney, but that was not my focus while I was there. When I was at the Legal Aid Society, my primary focus was criminal trial defense. I started doing post-conviction relief work after I went to work in private practice and continued that after I opened my own practice.
You played no role in the exoneration of Henry and Leon, is that correct?
When you say the exoneration, if you're referring to the motion for appropriate relief, I was not, but I don't believe the motion for appropriate relief was an exoneration.
Okay. And you did not submit their applications for pardons from Governor McCrory, correct?
I did not submit the original application, but I supplemented it and I advocated and argued for it in person and on the telephone and over email.
You did not submit the applications for pardons?
I did not submit the original application, but I did supplement it and essentially prosecute it.
Okay. Did you do any discovery for the pardons or in the Industrial Commission matter?
There is no discovery in a pardon process. To the extent that there was discovery, I got approximately 49 boxes of paper. I don't know how many thousands of pages it was. And I basically locked myself in the conference room for weeks on end, going through reorganizing everything for a file that looked like it hadn't been touched in decades, and educating myself on all of the nuances of the case. So to the extent that that's discovery, I did do that. For the Industrial Commission, I did the same thing and had to draft a statement of facts and synthesize as much information as I had. But there is no, since the Industrial Commission is not litigation in the sense of civil litigation, there's no discovery procedures available there.
And you've mentioned the depositions you did in the civil suit. Did you do any depositions for the pardons or in the Industrial Commission matter?
To my knowledge, depositions are not permitted in pardons and they are not permitted in Industrial Commission matters.
You didn't do any?
Couldn't.
Okay. You mentioned having to get up to speed on everything. Is that because you had no prior experience with Henry and Leon?
It's because I didn't know the case, a 31 or 32 year history of the case. I had to get up to speed with 32 years of past litigation.
Did you meet with Ken Rose to talk about his extensive knowledge of the case?
I spoke with him on the phone, but I received an extremely terse reception, and he did not really want to talk with me at that point. I think he was upset.
When you planned a rally at the governor's mansion or just outside, the governor's office actually told you that your publicizing this would potentially be harmful to the pardon case. Is that correct?
Not in the way you've characterized it. It was much more nuanced than that.
Okay, well, let's read what you indicate in your notes. This is Exhibit 177, page 54. I apologize, bear with me. Let me can't find this. Yes, page 54 of Exhibit 177. And Mr. Megaro, if you would read your note on May 14th, 2015 that I've highlighted, please.
Patrick's note, received a call from Bob Stevens. His cell is, should I read the cell number into the record or?
Okay,
Yes or no?
you don't have to.
Okay, his cell number is whatever. He said the governor is concerned about politicizing the event and promised that the governor would make a decision at the end of the month. Asked me to please consider moving the rally. Told him I would get back to him, discussed it with Jamie and Scott privately, and we are all, it says or, but it should say on the same page. Don't do it.
Okay. Did you tell the governor when you met with him that you were going to put Henry and Leon's Industrial Commission Award in a trust?
No, that was not the discussion that we had, actually. It was different than that. And if you'd like, I'd be happy to explain.
You allowed to explain his name?
Well, he simply is asking at this point a yes or no question, and as I understand it.
That's correct. And I don't want to cut you off.
That's all right, go ahead.
Okay. Ms. Megaro, if you would please look at page 53 of Exhibit 177 and read your note from June 3rd, 2015 that is highlighted.
Patrick's note, met with clients at the Capitol building with Governor McCrory. He asked a lot of questions about the case. With Henry, he wanted to know why he had confessed and why he had told the TV cameraman that he had held the girl's arms down. I explained the power of suggestion on limited IQ and false confessions. They should say the governor also wanted to know how I got retained, how I was getting paid, what my percentage was, and wanted to know if he issued a pardon of innocence, how the money would be administered. I explained that the sister would be the trustee in a trust that we would set up for them. Henry was good and Leon was actually better. His meeting was quicker, but he was completely lucid. He was a completely different person than last time.
You held out to the governor that Henry had a limited IQ that led to his false confession.
I did tell the governor that people with lower IQs are much more susceptible to false confessions, and did explain to him, and I told him the story of Martin Tankleff as an illustration, that even people with high IQs can make false confessions, such as Martin Tankleff, who gave a false confession when he was 17 years old to murdering his parents as an honor student. Ultimately, Mr. Tankleff was exonerated and is now an attorney working in the state of New York after 20 years in prison, obtaining a settlement, going to college and getting a law degree.
And you also say in this note that you explained to the governor that the sister would be the trustee in a trust we would set up for them, plural them. Is that correct?
Yes, that's an error. I was referring to Leon only at that time. I thought that there was a possibility that Leon might be incompetent down the road, but as you can see in the note, he was completely lucid. He was medicated. He was very talkative. He was in very good shape mentally. And it was my intention at that time to say this is a possibility. And as you can see from the note also, the governor did specifically ask me what my retainer agreement was, how I was getting paid, and then asked each Mr. McCollum and Mr. Brown, do you understand that he's going to get 1/3?
Objection to the hearsay of what happened at that conversation. Let's stick to the notes that are here.
Overruled. You can answer.
The governor specifically asked me, how are you getting paid? And I told him I have a standard 1/3 retainer agreement with him that's graduated. And he specifically asked Mr. McCollum and Mr. Brown separately, do you understand if I give you this pardon, that Mr. Megaro is going to get 1/3 of that money, $250,000?
Objection. This is far beyond what is
I
written
agree.
here.
That's sustained.
So the them that you've written here is an error? Is that what you said?
That's what it looks like.
Okay. Did you write this note or did a law student?
I don't know who wrote this note. It says Patrick's note, so it may have been written by someone else.
Okay. The Industrial Commission, someone from the Industrial Commission called you before the hearing and told you that it would be formulaic. Is that correct?
Brad Donovan called me from the Industrial Commission, and among other things we discussed, he said it's relatively formulaic.
Okay, you said on direct that you gave Henry and Leon frames for their pardons. Is that right?
I think so.
Okay, did you charge them for that?
I don't remember. I might have.
Okay, let's look at Exhibit 121. This is page 5, where you list the costs that you deducted from the Industrial Commission matter. Can you see the highlighted portion, Mr. Megaro?
Pardon framing.
Okay, so gave is probably not the best word.
Well, I don't know. You really got to tell me what you want me to do. If I give them something, you're going to accuse me of giving them money. If I charge them for it, you're going to accuse me of charging them for it. So
I'll object for the record to that response. At lunchtime on March 17th, 2021, yesterday, after one of your witnesses revealed that you and or your counsel had emailed him, you produced 17 emails between you and your experts to us. Is that correct?
I assume Mr. Williamson did. I'm not privy to that.
Okay, and you had not previously produced these despite the State Bar requesting them multiple times.
I did not communicate with my experts. My lawyer did.
You didn't email your experts in January of this year?
I might have emailed them just a date asking them to contact Lane.
And you did not produce that email to us in Discovery until it was revealed yesterday?
I guess it slipped my mind.
Okay, the State Bar produced updated Discovery to you several times, including emails and text messages with our witnesses. Is that correct?
I assume so.
Okay, and wouldn't you agree some of the emails that you failed to produce to us were not innocuous? They were not just about times that you were going to meet. Is that right?
I don't believe I had any non-innocuous emails with the witnesses.
Okay, I
believe
mean,
that was
one of the
Mr.
emails that you, oh, I'm sorry, I can't hear you. You might need to get a little closer.
Sorry, I thought those emails about any substance were with my attorney.
Okay, well, one of the emails that was produced to us yesterday, your expert said that he had no knowledge of Mr. McCollum's competence to engage you or agree to the terms of the loans. Do you recall that?
I recall seeing that.
Okay, did you not want us to have that email?
Was that email sent to me? I don't remember. If you show it to me, I can tell you whether that was sent to me or not.
Okay, let's get it out. Oh, I got it. I can get it right here. All right, Ms. Megaro, this has already been admitted as Exhibit 801. It's on the screen here. An email that Dr. Harbin sent to your counsel on March 10th of 2021. And the sentence that I just paraphrased for you is highlighted there. Do you see that?
I do, and I also see that I was not included as a recipient on that email.
You never received this email from your counsel?
You're asking me for confidential conversations between my counsel?
No, I asked you if you ever received this email from your counsel.
If I got a paper copy of that email, is that what you're referring to?
Did you ever receive a copy of that email in any form?
Yes, my lawyer did forward it to me at one point.
Okay, and it was not produced to us in Discovery. Is that correct?
Well, it was not produced, but now you're really attacking Mr. Williamson.
I'm not, actually. I'm asking you if it was produced in Discovery or not.
I don't know.
Okay. The work before the Industrial Commission was completely separate from the civil case. Is that right?
No.
Okay, let's look at Exhibit 160. What is Exhibit 160, Mr. Megaro?
It looks like a transcript of the hearing on August 10th, 2017.
Let's look at page 5. you would please read lines 15 through 19, please.
The court, what was your gross fee compensation in the industrial commission cases? Mr. Megaro, Judge, I don't see how that's something that's confidential to both clients. And that's something that is outside of this litigation. If the court is ordering
That's
me
fine,
to
Mr.
provide
Megaro.
that information,
That's fine. Thank you. So were they completely separate or were they all one matter?
your question was the work for the industrial commission separate from the work on the civil case? That was a question you asked me. I said, no.
That's
I don't know what you're asking me now.
okay. Are these two matters all one legal matter or are they separate?
The effort and the work, and they are inextricably intertwined. They are connected, but they are two separate litigation matters because they exist in two separate venues.
So they are separate litigation matters? Is that what I heard you say?
Two different cases in two different venues that arise from the same set of facts and the same set of circumstances. So they're inextricably intertwined.
But they are two different cases. I believe you started your answer with they are two different cases. Is that right?
Two different cases in two different venues, but not two different cases in the sense that they're different facts or different occurrences.
Okay, you said on direct that you offered to Mr. Tarleton to edit the retainer agreement. Is that right?
Yes, and that's what my email to him says also.
Did you offer to return any portion of the industrial commission matter funds that you collected pursuant to that agreement?
I did not.
Okay. Were you involved in the loan process with your clients in multifunding?
To the extent that I provided information to multifunding and did what my clients had asked me to do, yes.
Okay. Let's look at your deposition, Exhibit 100, page 147, line 23 through 25. I said, why were you involved in the loan process at all? And your response was, well, I wasn't involved in the loan process. Did I read that correctly?
Is that the entirety of the answer? If you go down to the next page? Okay. And if you read the rest of the answer, it's exactly the same what I just told you.
I'll ask that again. I said, why were you involved in the loan process at all? And you said, well, I wasn't involved in the loan process.
And I added, all they're asking me for is information that's publicly available, and I'm providing it because it's what the client wants.
So were you involved in the loan process?
To the extent that I provided information at the direction of my client and that I acknowledged the receipt of documents and signed documents as directed by my clients, to that extent, yes.
Did you ever sign anything agreeing to pay multifunding?
I never agreed to co-sign those loans or guarantee multifunding that they get their money returned.
I understand that, but did you ever sign anything agreeing to pay multifunding?
I signed two documents out of the multi-page loan documents that acknowledge the existence of the lien, and at the client's direction, as the document says, to repay that lien, or to satisfy that lien, rather.
Okay, at one point you drafted a loan contract for Henry to borrow money from Derek Hamilton. Is that correct?
I did.
How much was that loan for?
$20,000.
Okay, let's look at Exhibit 147. What is Exhibit 147, Mr. Megaro?
That appears to be the $20,000 loan document.
Okay, and how much is it for? 20,000?
Right.
Okay, and what's the interest rate?
8% compounded every 6 months.
And what are the terms of disbursement? Would you read paragraph 4 there for us, please?
$20,000 to be dispersed to Patrick Michael Megaro, Esquire, as attorney to be held in trust for plaintiff.
Okay, and this was the loan contract that was effective between you and, Derek Hamilton and Henry McCollum?
I believe so.
Okay, let's look at Exhibit 644. You also produced this document to us in discovery. It's already been admitted into evidence. What is Exhibit 644?
That's a separate loan document for $30,000.
Is it a different contract?
It is a different contract, and that one was invalidated. That was never effectuated.
Why was there a contract for $30,000 that was invalidated?
Because initially, Mr. McCollum did not know whether he wanted 30,000 or 20,000. I don't remember exactly what the purpose of these these funds were. He had them earmarked for some specific purpose. And I sent him both sets of documents and asked him to sign them, send them back to me, and then let me know which one he wanted. I would invalidate that, and I would only forward the actual loan document that he wanted to Mr. Hamilton.
So there were two different contracts that he signed?
As far as I know, yes. I don't know if he signed both of them. He might have attached the signature pages only.
Okay, let's look at, we're still on 644. Let's look at that signature page. It's page 8 of exhibit 644. Do you see that there, Mr. Megaro?
Yes.
Okay, now let's look at the signature page of exhibit 147. Do you see that, Mr. Megaro?
I do.
Okay, I'm going to jump really quickly back to 644. Tell me if you see any differences between these two signature pages on these two different contracts.
One's darker than the other, but they appear to be the same page, and I believe that's because Mr. McCollum attached one signature page to both contracts.
And Mr. McCollum understood that he was only getting 20,000, not the 30,000?
When you say what he understood, I can only tell you what he told me. And when ultimately he told me, I only want the 20,000, tell him forget about the 30,000.
And in fact, your firm actually did receive $30,000 from Derek Hamilton. Is that right?
We did. Well, my firm did. We received that in the trust account, the North Carolina trust account.
Okay, let's look at the $20,000 contract, since I believe we can. You state that that one is the effective one. Is that correct?
That was the effective one. That's what Mr. McCollum borrowed.
Okay, who decided this 8% compounded every 6 months interest rate?
I asked Mr. Hamilton if he would consider a lower interest rate, and we settled on the legal interest rate of 8%.
When you say it's legal interest rate, what does that mean?
That's the New York State Court's legal interest rate.
Okay, and looking at page 3 of exhibit 147, if you would please read into the record paragraph A that is highlighted there.
In consideration of Derek Hamilton agreeing to purchase proceeds prior to settlement or judgment of plaintiff's action, plaintiff instructs his or her counsel to pay Derek Hamilton in accordance with the disclosure statement on page 1 of this agreement. Plaintiff's attorney shall contact Derek Hamilton prior to dispersing the funds for a current total fee and return the investment of Derek Hamilton. Such amount shall be paid upon settlement or judgment or verdict of the action and the receipts of proceeds therefrom. This payment shall be and is by this agreement an assignment of proceeds of plaintiff settlement, judgment, or verdict proceeds.
And were the terms that you just read complied with?
We never had a judgment, settlement, or verdict, not while I was on the case.
Did Derek Hamilton ever get paid back?
I don't know. You would have to ask him.
Okay. If you would also please read the paragraph at the bottom of page 3, that is 4A. It spills over onto page 4.
Plaintiff acknowledges that that only the existing liens in existence against proceeds of plaintiff's action are those set forth on Schedule B. In the event of a settlement/judgment, plaintiff and Derek Hamilton agree that attorney's fees, case preparation, costs, and liens as set forth in Schedule B shall be paid prior to any other liens. Plaintiff agrees that plaintiff will grant no further liens except those that are mandated by law and or which Derek Hamilton has given prior written consent. Plaintiff agrees that Derek Hamilton's irrevocable lien shall be paid in full before plaintiff receives money from the litigation. Any liens granted after Derek Hamilton shall be paid after Derek Hamilton is paid, except those liens that are mandated by law.
So you drafted a document that created a lien against your client's money in favor of Derek Hamilton?
I took that exact language from multi-funding and copied it over and changed multi-funding to Derek Hamilton.
And the result was that you drafted a contract that created a lien against your client's money in favor of Derek Hamilton.
At Mr. McCollum's direction, yes.
Okay. And the $30,000 that was sent to you, 10,000 of that was a loan to you and your firm because you were going through some financial difficulties?
There was a cash flow issue and that was a loan and I did repay Mr. Hamilton.
So you actually created a lien against your client's money in favor of your personal lender?
No,
How am I incorrect in that statement?
because that was not contemplated at the time that the loan was taken out.
What was not contemplated at the time the loan was taken out?
That I would be taking out that $10,000 loan. That was an afterthought.
Did you have a separate contract for the $10,000 you borrowed from Derek Hamilton?
I did.
What was your interest rate?
10%.
Have you produced that contract
Yes,
to the state bar?
yes,
You did.
yes.
And have you paid that loan back?
Long time ago.
How much interest did you pay?
10%.
Okay. And how long did that money stay in your trust account before you removed it?
I don't remember. I specifically earmarked those funds for McCollum's case expenses. And I will be the first to admit I did not move them out of my trust account. I left them in there. There was a lapse in judgment on my part.
Okay. Did you ever pay for representation of yourself out of Henry and Leon's funds?
No,
Okay. Look at Exhibit 185. This is Exhibit 185. It's been previously admitted into evidence. And this is page 5 of that exhibit. If you would, Mr. Megaro, tell us why this check was written to your counsel's firm in this case out of Henry's money, please.
on February 2nd, 2017, Lane Williamson was not representing me. He did not start representing me in this matter until well after that. And one of the things that I needed to do was consult with an ethics attorney about the McCollum matter, about how to proceed properly. I consulted with Mr. Williamson and I paid him $100 for that advice.
Okay, and you periodically gave Henry and Leon money to make copies of documents and mail them to you, is that right?
Among other things, yes.
And that money was over $1,000 to mail you things, is that correct?
Yes,
But not the powers of attorney you allegedly saw from Geraldine, is that correct?
she lost them.
She lost them.
Well, that's what I was told.
Okay. You testified at your deposition that Mr. Halscott knew more about the advances to Henry and Leon than you did?
I may have said that, but I think probably Rachel Halscott would know more about, she's the bookkeeper.
Okay, you said Jamie at your deposition. Do you recall that?
I may have said Jamie, but Jamie doesn't handle that kind of, Jamie's not the bookkeeper, Rachel is.
Okay, and he testified on cross that he didn't know anything about the finances of the North Carolina matter. Is that correct?
That's what he said, yes.
And is that true?
That he didn't know anything about the finances?
Right.
Generally speaking, I mean, mostly I handled that kind of stuff.
Okay. I have nothing further at this time.
Will be further direct.
No, sir.
All right. Will there be further evidence from the defense?
Mr. DeVore, I would like to designate portions of the deposition. I have part of that event. I don't have any more live with like the opportunity to file that and submit it to.
Well, we've had a long day. I don't have an objection to that. Let's, you can step down, Mr. Megaro. If you just wipe down where you are, I guess would be the safest thing to do. And thank you while we talk, while I have a conversation with the lawyers. Gentlemen, tomorrow, are we in agreement that the plan is it will begin at 9 o'clock? We'll go through those cuts from the depositions that Mr. Williamson will work on tonight. And then will there be rebuttal evidence? You can decide tomorrow if you want to just know at this point whether you have additional witnesses to call.
I don't believe we will, but we would like the opportunity just to chat before we make
Okay.
that final determination, but it does not look like we will.
We'll do that. So is the plan then for tomorrow that, as I see it, that we will relatively short order complete the presentation of evidence in the morning? We'll then move right into closing arguments if parties desire to make those. And then the panel will have an opportunity to deliberate at that point.
In regard to closing arguments, I would simply ask whether you intend to limit the time, for one, and also we've both submitted what we contend to be the issues. I don't think there's a lot of difference between them, but I'd like to know, beforehand, before we argue, what you're considering.
Well, of course, the burden is on the state bar for to present the evidence and the issues that they want to have decided. Mr. Williamson, are there other issues that you think need to be contended outside the realm of what the state bar submitted?
I don't think so. I have not really examined and compared theirs. And mine was taken directly from the initial complaint. I really don't think they're much different. I'll frankly tell you, they gave me a copy of it. And find it.
Well, as a practical matter, I told Mr. Walthall earlier I could not find mine and then immediately found it. So I think I have an extra copy if you need it.
I appreciate that very much. Thank you. It doesn't matter to me. I just want to know which one, if you want to use theirs, that's fine.
Why don't we let you review that tonight, Mr. Williamson? And if it looks like there are issues that are an issue regarding the issues that we need to address tomorrow, we'll do that before we do the statements, closing statements. Otherwise, I'm going to presume that we'll go with the state bar's issues.
Fair enough.
And then in terms, you asked me about limits in terms of closing arguments. It was not my intent to limit closing arguments, but with the understanding this is a non-jury matter and that we have heard the evidence and we have the documents in front of us.
We would like to complete this phase.
That was the point I was making exactly.
Yeah, you got a lot to work through no matter what.
Mr. Williamson, I think Mr. Halscott said to me that he would be able to find us a flash drive with the exhibits at some point.
Yeah.
And it doesn't have to be this afternoon, but I would like to have that in the morning if at all possible. I guess we'll probably need one for all three of us, or I can copy the hard drive and share it for that matter, but.
And the court reporter.
And
I'm so sorry. I'm so sorry for you. Well, maybe 5.
Yeah, I can do the same.
I'll make 3 business days.
All right. Is there anything else we can handle tonight?
One thing that I would ask, which I'm not necessarily entitled to, but I would kind of like to know for planning purposes, whether the state bar wants to open and close or simply close.
Has a decision been made about that, Mr. Walthall? You have the right to open and close, or you can certainly waive opening and just.
Yes, sir. I understand. It's our intention just to close.
So there will be waiving opening and have the last argument. All right. Have a good night.
Thank you.
Avoid the tornadoes.